Good morning, everyone. Good morning and welcome to the Joint Standing Committee on the Judiciary. It's nice to see everyone today. I just want to give a little announcement about how today's will proceed. We are going to start with the public hearing on LD 1911. This is an act to automatically seal criminal history record information for certain crimes, being sponsored and presented by our colleague, Senator Talbot Ross. If you are here for the second bill, 1941 exclusively, we do have an overflow room next door. And if you could head to the overflow room until we start 1941, that would be helpful. If you're here for both bills, you're welcome to stay, and we'll just make sure that we call people in and out. And likewise, when there are a couple of seats that free up in judiciary, if you're here for 1911, feel free to come into the committee room. And in just a moment, we're going to give a round of committee member introductions, but we'll give everyone a chance to find their seats. Thank you, everyone. Let's start with our committee introductions, and we'll begin with Representative Sinclair.
Good morning, everyone, and welcome. It's always energizing when we have a full room, so I'm glad you're all here. My name is David Sinclair. I'm here for the people of House District 50, which is the city of Bath.
Good morning, everyone. I'm Dylan Pugh. I represent House District 114, which is part of Portland.
Good morning, all. I am Rachel Henderson. I represent the people of House District 78, which are the beautiful towns of Bethel, Byron, Milton, Hanover, Roxbury, and my hometown of Rumford.
Good morning. My name is Danny O'Halloran, and I am from District 20, which is the majority of the industrious city of Brewer.
And I say hello, I'm Dave Hagan, Senate District 10, 12 towns surrounding Bangor and not Bangor.
Good morning and welcome, everyone. I'm Rachel Talbot Ross. I represent Senate District 28, which is on the peninsula of Portland and includes the University of Southern Maine campus.
Good morning, I'm Adam Lee. I represent downtown Auburn and New Auburn, which is District 89, and that is a far smaller list than Representative Henderson, who I am impressed can recite all of the towns that she has without looking at them alphabetically.
Good morning. My name is Ellie Sato. I represent House District 109 in the beautiful city of Gorham.
Good morning. I'm Mark Babin. I represent House District 3, Northeast Aroostook County.
Good morning. I'm Amy Kuhn. I represent House District 111, which is most of the town of Falmouth, and I serve as the House Chair of the committee. Welcome.
And I'm Ann Carney. I represent Senate District 29. That includes South Portland, Cape Elizabeth, and some of Scarborough. And I serve as the Senate Chair. And I'll be starting out chairing today's first public hearing. But please know that even though it's early in the session, legislators are being pulled in a lot of different directions. And so you may see various members of the committee leave and return when they're done with their other work. And so at this point, we are going to start the public hearing. And this is the public hearing on LD 1911 being presented by our colleague, Senator Talbot Ross. Welcome, Senator.
Sorry.
Well, good morning, everyone. Good to see everyone. Senator Carney, Senator Kuhn, and esteemed colleagues and members of the Judiciary Committee. My name is Rachel Talbot Ross. As I just stated, I represent Senate District 28, which includes part of Portland, the part of the Casco Bay Islands, and the University of Southern Maine campus. I'm proud to be the sponsor of LD 1911, an act to automatically seal criminal history record information for certain crimes. LD 1911 is a carryover bill from the first session of the 132nd legislative session. As you will hear during my testimony, the time in between the first and second sessions have been extremely beneficial, very busy, allowed me to take the time to work with a diverse group of stakeholders, and the amendment before you is based on the work with the numerous parties. So I'm presenting testimony on the amendment.
Thank you.
Before I outline the amendment, it is important to understand the genesis of how we arrived at the document before you. As you are aware, the Criminal Records Review Committee was created to review the issues involved in clearing or sealing arrest and conviction records, and to explore various options for assisting those who have been convicted of crimes and are serving their sentences to become constructive members of the community. As you will hear today, after people who've served their time or have simply experienced an arrest, the resulting record can follow them throughout their daily lives, creating additional, sometimes lifelong barriers. Whether this means being unable to rent or obtain decent housing, or not being considered for quality employment or higher education in an effort to provide for their family, an old arrest or conviction record can be an albatross around people's necks. Individuals who have paid their debt to society should not continue to be penalized. The original draft of LD 1911 was based on the merger of two recommendations from the Criminal Records Review Committee, namely a proposal to automate record sealing for cannabis offenses that are no longer considered crimes, and another proposal to expand the types of low-level offenses that are eligible for record sealing generally. After further discussion with multiple stakeholders on LD 1911, we have made a series of changes to ensure a more effective and implementable policy for all parties involved in the process. These changes have been made based on discussions, again, with diverse stakeholders in Maine and on the experiences of other states that have implemented clean slate policies. To date, 13 states and Washington, D.C. have passed clean slate legislation. If you'd like a list of those states, you should refer to your Criminal Records Review Committee report of 2024, Appendix E. These states are very different from one another, and they span the political spectrum from Oklahoma, Utah, Virginia, California, New York, and Connecticut. Yet each of these states, like Maine, is taking an individualized approach to clean slate legislation, ensuring that the legislation works effectively within its unique political, cultural, and administrative context. To start, the bill actually follows, again, the recommendation of the Criminal Records Review Committee in identifying and expanding the number of offenses eligible for record sealing generally. As you're aware, criminal records in Maine never truly go away. The terminology and process used is record sealing, not expungement. So if you think of sealing hides, expungement would completely erase. So we're talking about record sealing, not expungement. Other states will sometimes expunge eligible records, which again erases them from the databases and even physically destroys them, treating them as if they never existed. In Maine, these records are simply sealed, and they are kind of put on a shelf, if you will. Access to sealed records is then restricted. In this amendment, law enforcement and court officials are still permitted to access these records when appropriate, whereas a background check company would not. The offenses that have been added for eligibility for sealing include most Class D and E misdemeanors, as well as certain drug-related felonies. These offenses are listed as eligible criminal convictions in paragraph 5 of the definition section in the amendment. This language comes directly from Appendix L of the CRRC's 2024 final report. So this language is directly from the report, which included draft legislation proposals. And I will just remind you that the CRRC membership, which you can find in the report, was 29 people, and it included a great spectrum of people across all of the various systems. So this language comes directly from that group of people. Where the CRRC proposal in this amendment begin to differ is based on feedback received and the need to exclude certain offenses from automation. So this is where we part ways. Automation is a process that requires things to work at a large scale using computers and coding, while the CRRC proposal would have allowed for individual review of marginal cases. The automated process is necessarily limited to offenses that should clearly be sealed as a matter of public policy. So the difference in those proposals, you can see. Looking at paragraph 5 of definitions, starting with subparagraph A, we begin to see that things should not be sealed. We begin to see what things should not be sealed in an automated process. This language already excluded sex offenses, but in subparagraph B1, for instance, you will see that all offenses against the family of Title 17A, Chapter 23, have also been excluded from automated sealing, and it is very explicit that such offenses are not eligible. The original CRRC proposal was more nuanced. With the remaining of exclusions you see here, any assault, domestic violence, sex offense, or adjacent activity is explicitly excluded and would not be eligible for automated sealing. Overall, the eligible offenses outlined here stem directly, again, from the recommendations of the committee. Expanding access and eligibility for record sealing would put Maine on par with the practices in other New England states by allowing these offenses to be sealed only after a specific period of time following someone being held accountable for their past mistake. So this is not, this is on par, the offenses are on par to be sealed, again, after a specific period of time and other conditions have been met. The next section, 2402, sets out appropriate waiting periods based on Maine's existing practices and available data. The waiting periods are also informed by national research on recidivism, which suggests that it is appropriate to seal records 2 to 3 years after serving a sentence for a misdemeanor and 5 to 7 years after serving a sentence for felony. That's national research. To create effective data points for automation, this bill uses available court data from the date of sentencing rather than from the completion of a sentence, so the date of sentencing when you've been found guilty, and it increases the waiting period accordingly. So for a Class E crime, you're guilty on the date of conviction. That's up to 6 months. We use, to calculate the waiting period, we use the maximum. So it's up to 6 months. Class D would be up to a year. We use that maximum sentence and incorporate it into the waiting period. So for a Class E crime, you would have to wait a period of 5 years. For instance, with misdemeanors, which carry a maximum sentence of 1 year, the existing waiting period would be increased from 4 years to 5 years. So there is an existing waiting period, as you all well know, of 4 years. We have increased it by a year so that we use the date of conviction as the starting point, the date you've been found guilty. Some low-level drug-related felonies will be eligible for sealing after longer waiting periods appropriate to those offenses. So we built in additional time. Class C felonies with a maximum sentence of 5 years will now have a 10-year waiting period. Class B felonies with a maximum sentence of 10 years will now have a 15-year waiting period. So we've added time into those waiting periods. And of course, let us not forget that almost half of criminal cases result in a non-conviction. And I really want to just pause for you to take that in. Almost half of criminal cases result in non-conviction, yet still produce a record. It is essential to note that non-convictions in Maine still appear on individuals' background checks. Now, you've not been convicted, and it still appears on your background check. Just to imagine having to walk around with that, right? It is amazing to think that someone could be disqualified from meaningful employment or good housing, even though they have never been found guilty of wrongdoing by a court of law. This legislation will appropriately seal these non-convictions 6 months after disposition of the case. So for non-conviction, we have waiting periods for post-conviction, and then for non-conviction, the waiting period would be 6 months for that automatic sealing. A person would not be eligible for record sealing if they've had any subsequent convictions in this state or have any pending charges during the waiting period. So we're talking about essentially crime-free, right? You cannot have another conviction. You cannot have a subsequent charge during the waiting period. That makes you ineligible. The fidelity of court data is also the key point to the final provision here. Working with stakeholders. Working with stakeholders, we have identified that one of the unique administrative concerns is the ability to track restitution owed to victims through the courts. So while the judicial branch has reliable data on whether an order of restitution has been issued in a case, the data is far less reliable regarding whether that restitution has been satisfied. So you will see in this part of the amendment, I'm now, just so I can get you there, I'm now on page 3. At the top of the page, it says order of restitution. We just covered pending criminal charges. So the page starts with, so 5, order of restitution. The eligible criminal conviction does not contain a court order of restitution. So as you will see in the amendment, cases that include an order of restitution will not qualify for their records to be sealed under clean slate. This is a small but significant number. There's approximately 7% of convictions, or 3.5% to 4% of all criminal cases involve such an order, but we have exempted that they will not qualify. Any case that has a restitution, I'll be clear, will not qualify for clean slate. The remainder of the bill, sections 2403 and 2404, set out the process by which automated reconciling will occur. So several changes in language have been made after meetings with the judicial branch. We engaged in several meetings with the judicial branch just to understand their process, to fully understand, to better understand the e-filing system and when all of that will be online. So we made changes after meeting with the judicial branch. We've adjusted the timeline to enable the judicial branch more time to implement this legislation appropriately. As this committee is aware, the judicial branch is currently updating its software system to streamline court records. That update is expected to be complete by 2027. That is why clean slate automated reconciling is set to begin in 2028 in this amended bill, and deadlines for reconciling are staged, they're staggered over several years after the law is fully implemented in order to make sure that we have the flexibility to adjust according to them getting fully online. This bill outlines, it was initially thought that there may need to be a manual review records or paper files as part of the clean slate process. This is a common misconception that almost all states share initially, but it is not true. This bill outlines a process for managing electronic records, mimicking existing court rules for the electronic court system. These rules have been in effect since 2020, and in particular, Rules 9 through 11 govern record sealing, as well as public access to records. The judicial branch can utilize their existing presumptive sealing approach as part of the clean slate process. Here, the judicial branch can put an electronic flag on any record and presumptively seal the access to the general public and background check companies. They currently can do that, presumptively seal. Should the public inquire about the details of a particular historical case via the press or any interested party, the court can then do an individual review under its rules to determine if any information from the case can be released in compliance with the clean slate law. This is a process that will save tremendous resources of time and money while delivering record relief to hundreds of thousands of Mainers. There's just a few final points I want to make about this legislation, and I appreciate your attention and this time. What is abundantly clear is that any commutation or pardon is a power exclusively reserved to the executive. However, the criminal record itself, after the completion of a sentence, is not a punishment requiring commutation. So the record lives. Instead, a record of a past conviction is a collateral consequence, a public indicator of a past that we deem worthy of judgment and scrutiny. The legislature has purview over the public policy regarding these records, specifically when and how these indicators, this collateral consequence, these indicators can be removed from background checks. Maine's existing record sealing was the starting point for this legislation, and this bill will expand upon the grace offered to Mainers who are held accountable for a past mistake and do everything the court has required of them. That's a really key point. They do everything that the court has required of them. The last point I want to make about this legislation, and I want to be very clear about it, is that even though these records will lead the public eye, law enforcement will still have necessary access to the records of people who have been convicted of a crime in this state. Criminal records will be sealed, not expunged, not destroyed. I understand very well that there is nothing automatic about the process of automating record sealing. This is why I've devoted considerable time to work with stakeholders to try to develop an effective policy as possible. I will say, as common and quite common in this committee, this is a starting point. Please believe me when I tell you that. We have worked so many bills that have complications in them, and we've worked them hard in order to get to a reasonable conclusion in which we take a vote. So I just ask your indulgence. This is a starting point. And I really hope that you understand that. I'm grateful to the business community, the recovery groups, the judicial branch, experts at the Clean Slate Initiative and Code for America, district attorneys, domestic violence victim advocates for their openness and willingness to work with me on this legislation. Thank you for your time and consideration.
Thank you so much for your presentation of this legislation, Senator. Committee members, are there questions for our colleague? Yes, Representative Lee.
This is going to be sort of a wording thing that we can work on at the work session. I just
Please.
want to make sure I understand the
Mhm.
intent. One of the exclusions deals with orders of restitution. And the way it's worded presently seems to indicate if there is an order of restitution that's existed at any time in the case. Is the intent to say if there has ever been an order of restitution, you're not eligible? Or is it if there's an order of restitution where there's still amounts owed?
It's any. It
Okay,
would be, yeah, at the way this is written, it would be any.
and that's the intent?
It is.
Okay. Is there a reason that it wasn't, did you guys consider in the process whether a fully paid order of restitution would make someone eligible.
We did, and, we had conversations specifically with Andrea Macuso from the Maine, Coalition to End Domestic Violence, and this was a condition that, they asked in order to not oppose the bill. And, she gave me permission to say that. But because of the lack of data, that we, can access from the courts, it may be something that we eventually get to, but because of that lack of data on where those cases reside, where they are, who they are, it would be difficult at this time to put a time date stamp on it.
Representative O'Halloran and then Representative Kuhn and then Representative Sinclair.
Hi, I have two questions, if that's okay. If not, I can wait. But the first one is, you said that law enforcement has access to those records. Now, they would have to physically go look for them, correct? They wouldn't actually come up when they pull somebody over on a traffic stop.
No, law enforcement has complete access to those records.
When you say complete access, though, what I'm trying to find out is typically when records are sealed, when you pull somebody over in a traffic stop and you run their license and their name, sealed records do not come out.
We are not changing the current law regarding law enforcement's access to records at all. So whatever your interpretation is of that, we are not changing
Okay.
it.
So then for some crimes that could possibly be wiped out, law enforcement may or may not be at risk by not having immediate information.
I do not believe that that is true.
Okay.
We are not changing any part of the process regarding law enforcement or the courts through this bill. No changes at all. So whatever they currently have access to or do not stays the same. That's, if we want to change that, it'd probably be a different bill.
So you're saying they have access to sealed records on a traffic stop?
I'm saying whatever they currently,
Okay.
whatever the current protocols are, stay in place. This law, if we enacted this law, it would not change whatever currently exists for law enforcement's access to records.
Then can you hold your next
yeah.
question until we let others ask? Okay, Representative Kuhn.
Thank you. Thank you for presenting the bill. I had a question. One of the eligibility requirements is that there's not a subsequent conviction in the state. And I wondered, how does the bill address subsequent convictions in other states? Like, do those databases talk to each other so that Maine could even find that information? How does that work?
I'll bring some more specific information to the work session. There are others who can speak to that. But this, because of the way that the systems work, they don't talk to one another. You'll see that other convictions in the state, we have limited this to just convictions in the state of Maine. But others can talk about the difficulty in trying to access information of other states.
Just ask a follow-up.
You may ask.
But
a
this is
follow-up.
definitely limited to convictions in the state.
Okay, thank you. And then you identified that this similar law exists in many other states. And I'm just wondering, is that also the condition in those states that they're addressing subsequent conviction in their
Yeah.
own state because of these challenges?
Thank you, Representative. What I would do is refer you to the appendix in the CRRC's 2024 report, and it has every state that has enacted some form of sealed records. It shows you to the extent of what they're able to do. So I would,
Great.
refer you to that. It's a pretty detailed chart of sealed records in other states and what they're able to do. But we also have someone here from Clean Slate Initiative who could answer that question.
Great, thank you.
Next, Representative Sinclair.
Thank you, Madam Chair. Senator, I really appreciate your continued work on this. It's certainly a policy area that I support. I'm proud to co-sponsor with you. I wanted to talk with you about, in the initial draft, there was an exception for VCRs that happened where there was a domestic violence or a sex crime underlying. In this amendment, it accepts all VCRs which is a much broader swath of conviction that would not be eligible for automatic sealing, even though that is one of the most plentiful and one of the least severe of all possible criminal convictions. Is that again owing to a failure of the court's information system to disaggregate a type of VCR from others, or some other cause?
It is, simply put, yes. Thank you.
Additional questions? Representative O'Halloran, did you have a second question?
But I do have one other, there's no victim input on this.
On sealing records,
So, because they're automatically sealed, so it's not going to allow for victim input.
there's currently, Representative, no victim input in current law for sealing records, both
Right.
by petition or automation.
But we're talking about convicted criminals, and some of these, I mean, I guess I have concerns that, one, are they able to?
Representative O'Halloran, I just want to make sure that we're focusing on clarifying questions for the public hearing
That's what I'm
versus
trying to do.
debating policy,
I'm
which
not
is for
trying
the
to
work
debate, I'm
session.
trying to understand.
Okay,
That's
go
what
ahead.
I'm doing, I'm trying to understand.
Mhm.
So my question is, considering victims, are they going to be allowed to retain a copy of those records? So maybe they might need to take action in the future. Will they be allowed to retain copies of those types of records?
Current law allows one to petition the court for a copy of a record. That will not change in this bill.
And who makes the decision whether that?
The courts. It's a form that you fill out
Yeah, no, I
to the
understand that it would
courts,
be.
and then a judge has a hearing, and then
Yeah.
there's motions either granted or not
Yeah,
granted.
I get it, but I still feel for the victims and some of them.
I join you in feeling for the victims as well, but this is about criminal history records. And so the current law does not allow for that process. So we are not changing that piece of current law.
Did you have additional questions?
No, but I was just thinking our current law doesn't automatically seal records either, so.
Our
You
current
can respond to that.
Our current law does allow for some automation and for petition process. If you have a Class E crime or a crime in which you were convicted for what we then would call marijuana, which is now legal, you would have a waiting period, and then the records can be sealed. There's also a 4-year waiting period for other types of crimes within Class D, as long as there's been no new criminal activity or any pending charges. And so I would just say to the good representative that we currently have this in Maine law. And so we're not changing the current law as it relates to victims and record sealing. We're not changing anything at all.
Representative Henderson?
Thank you, Madam Chair. So this is actually an information request, which I typically wait for till the end, but we have a lot and I want to make sure I remember.
Okay, go ahead.
Is it possible to get the CRRC's report for the work session? If it's going to be referenced back to, is it something that we have a hard copy of that we could get for the work session?
You already have a copy.
I don't see one in front of me. Maybe I have it stored somewhere else.
Madam
Go ahead.
Chair, we presented this to the committee. So the committee definitely has a hard copy of not only the 2024 report, but several other reports. But we can make sure that you all have new reports should you need
Representative
them.
Pugh was holding on to it for me. So thank you. Thank you.
For members of the public who are listening, those reports are also available on the legislature's website.
And on the committee's website.
Yes, thank you. Any other questions for the sponsor, recognizing that she will be with us for the work session? All set, thank you.
Thank you very much.
We're now going to hear from members of the public who wish to speak in support of LD 1911. Yes.
I may have missed this at the beginning, but I know that there is the lead co-sponsor that is wanting to speak on behalf of it. Are we taking co-sponsors at the end of public testimony?
I need to check our committee rules, actually, just a minute. Thank you for raising that. So before we turn to members of the public, if there's any co-sponsor who wishes to speak in support of LD 1911, please step forward. Okay. And so we have a representative who is available online to provide testimony. Representative Boyer, could you please activate your audio and video? Thank you for doing so. And you can begin your testimony. And just a reminder, since you're the first person other than the sponsor who's testifying, we do have a 3-minute clock that I will let you know, because obviously you cannot see it from where you're sitting, but we'll let you know when that time has elapsed. Go ahead.
Senator Carney, Representative Kuhn, distinguished members of the Judiciary Committee. I just want to come here today and express my support for the policy of clean slate and second choices. Excuse me, second chances. I'm the second choice, second choices. We worked hard on this on the CRC committee. I was a member of it. We learned a lot about the processes of expungement versus sealing, the governor's powers versus the legislature's powers, the petition process, how many people know about the petition process since that has became law a couple years ago. Those numbers are really low. We know that there's just not a general awareness about this opportunity to seal records. So I think this legislation makes a lot of sense. I think, and I hope that you guys work it. I'm sure there's room in there for input, and there's a lot of moving parts in the text of the language. But I support the premise of, non-violent, kind of fraud and deception and those types of crimes. Victimless crimes, generally speaking, those lower class crimes, they should be sealed. Cannabis, obviously, I'm partial to. Worked on the campaign to make that legal, and the idea that there's hundreds, if not, I think thousands of folks with those convictions still on their records doesn't make sense. We have a labor crisis, with our state, and preventing people from working or discouraging them from working doesn't make sense for our economy. On the human trafficking side, with the bill that was passed the last session with sex workers, and those should be expunged as well, since we have changed that law, I think. So I think this is a common sense initiative that other states already do. We've tried to think about ways to let the public know about the sealing process, but it's been a struggle. If you look at those numbers, they are low. Folks just don't know about it. And I think a lot of my colleagues on the Republican side, not all of them, I'm sure, but some of them would be interested in this legislation and want to learn more about it. And I know a lot of my colleagues on my side of the aisle also believe in redemption and second chances. So I think this is an important issue that deserves to be worked this session. I know it's a short session and everything's rapid, but I do believe that this is one of the bills that is deserving of your time. So I want to thank the committee. I'm happy to answer any questions. I'm not completely read in on the latest amendment, but do support the text and premise, and a little bit more than premise too. Thank you.
Thank you very much for your testimony. Committee members, any questions for Representative Boyer? Yes, go ahead, Representative O'Halloran.
Hi, it's nice to see you.
Hi.
In your work on this bill, aside from the marijuana convictions, which I agree with you should be expunged, and sex trafficking, victims and stuff like that. But aside from that, do you have any idea of like how many it would be a year that would be being sealed?
For all the issues or just the cannabis?
Aside from the marijuana and, you know, the sex trafficking one that we passed already for those victims, their records being sealed. But do you have any kind of an idea of how many that would be a year?
I think the sponsor might have that data a little more readily available than I
Okay.
would.
All right, thank you.
Any other questions, committee members? Seeing none, thank you very much, Representative.
Thanks. Take care.
There are any members of the public present in the room who wish to speak in support of LD 1911, please step forward.
Hello, everyone. My name is Stephen Schaff. I want to thank you guys for allowing me to come to speak to you today about something that's really important to me. It's kind of personal too. It's kind of personal for more reasons because I know a lot of other people that it affects. You spoke about legislative intent initially. You didn't quite get it out of your mouth, but I'm one of them nerds that reads legislative intent before I read the law. And it's really an important thing when you guys get to that point that you understand that legislative intent doesn't just mean what you do, it's also inaction. It's intent. Your inaction might be have a consequence for people that you might not understand or fully have heard from people like me. Although I was born in Portland and I was raised in Lyman, Maine, when somebody asks me these days, I just tell them I'm from Maine. And as I keep speaking, you'll understand why I do that. Until a few years ago, my experience as a Mainer was pretty common. I mean, I graduated from the University of Maine. I went to Bowdoin. I started a business here. I had children here. I have grandchildren here. My siblings live here. All of my family lives here. I don't live here. I live in Pennsylvania. I drove 10 hours to get here yesterday in a storm. And that's because between 1996 and 2022, I was in the Maine State Prison. I'm a felon. I belong to a class of Americans who it's perfectly legal to discriminate against in matters of employment, housing, and education, believe it or not. And I've experienced it in banking too. Maine law right now just allows the discrimination to fester and people don't really understand how. And I'm going to tell you how. Right now, I have to self-defame myself on a job application. I have to self-defame myself when I go to apply for an apartment. I put my children in a private setting one time, and I got an inquiry about my background that affected my children. It's akin to the 21st century of the Scarlet Letter, which a lot of people don't read these days. But I write this letter in support of the clean slate law, and I have a lot to say about the parole bill and the commutation law, but Rachel said, imagine if you had, and I'm going to put words in her mouth, a monkey around you, a monkey on your back. I've had a monkey on my back for something that happened 30 years ago. And you spoke about the victim. Now, the victim is always going to be the victim. I've changed. I couldn't make a life in Maine. I had to make a life in Pennsylvania. I'm a business owner. I'm a good person, but this has weighed me down. And a weaker person could have turned to drugs or more crime or something like that. But, I didn't. When I was released from Mountain View in 2022, I had good reason to think things were going to go smooth for me, but they didn't. My degrees in business and finance and it didn't matter. You know, so I asked, was it wrong to me to expect my debt to society was paid? Was it wrong to expect that? I mean, I thought it was reasonable. You know, that first month I had dozens of job interviews. They went seemingly well. I got callbacks and second interviews and silence.
Could you please wrap up in a sentence or two? The 3 minutes elapsed.
Yep.
Thank you.
Okay, I mean, I left Maine 3 years ago. I live in Pennsylvania. I mean, I want to come back, but I'm only going to come back for issues like this and until things change. And I just want you guys to recognize that people change and I'm a good person and I want to come back to Maine, but I won't till it's done. Thank you.
Thank you. If you can just wait there because committee members may have questions for you.
Okay.
And also I noticed that you have some written notes. Did you
I
provide?
submitted them online. I kind of
Perfect.
ad-libbed a lot, but
Okay, that's fine. We
Yeah.
just want to make sure we have the written statement as well. Committee members, are there any questions?
I'm sorry, I should take my hat off.
No, you're done fine. Go ahead, Representative.
I just want to thank you for coming today and sharing your story.
Thank you.
Any other questions, committee? No, thank
All right.
you.
Thank you.
The next person who wishes to speak in support, please step forward. Yeah.
Good morning, everyone. My name is Angel Cirillo.
Welcome.
I'm originally from New York City, and I moved to Maine. I have two boys. Unfortunately, I've made some mistakes in my past. Went to prison for them. I identify as a person in recovery. I've changed my life around. Right now, I'm currently living in a sober living house. Volunteering at the Access Center, volunteering at local churches, just trying to be a successful, productive member of society again. Unfortunately, I do have a background. You know, there are times where I applied for, you know, housing voucher or, you know, employment, you know, like the recovery house is just a stepping stone, so I can move forward with my life. But you know, eventually I'm gonna have to look for a job and try to get my own place. Because of my background, it's put a stop on that a little bit. I think that this bill is very important for people like me and other people that have the same situation. So yeah, if this bill could get passed, it'll definitely help me out and many others that have the same situation. Thank you.
Thank you for your testimony. Could you let us know your town of residence and just for everybody who's going to be speaking, if you can let us know the town and state where you reside?
Yeah, I live here in Augusta, Maine.
Thank you.
Yep, thank you.
Wait, just one moment. Committee members, are there questions? Seeing none. Thank you very much.
Thank you.
The next person who wishes to speak, please step forward. Welcome.
Thank you. Good morning. Distinguished members of the Judiciary Committee, Senators Carney and Representative Kuhn. I am Jackie Sartoris, the District Attorney of Cumberland County, and I testify in that capacity today in support of LD 1911. As a prosecutor, when I review a case to file charges, I consider a lot of things. I check to see that I have the police reports I need, whether what is reported supports the charges they recommend, whether the other evidence I have, victim and witness statements, medical and video evidence, whether that supports the charges, whether someone has a criminal history. Maybe different charges are supported altogether. Above all, I am concerned with telling a true story to the best of my ability. Telling the truth is essential to the job we prosecutors do. Then I have to make a plea offer. What would the conviction, fine, any jail or prison time or probation include? What dismissals or deferred dispositions are appropriate? Will this person be better off if I include substance use or mental health treatment? Is there a need for restorative justice, restitution? These are the questions I'm asking myself, but at no time as a prosecutor do I ask myself whether I should charge someone with a crime at all because there are harmful collateral consequences that last a lifetime. My job is to ensure the truth is told, the whole truth and nothing but the truth, and to make sure I can elicit those truths at trial and get a conviction. Or, armed with those truths, tell the defendant, take this plea offer because it's better than what you're going to get at trial, and you can make something of your life one way or the other. That's what I really believe. Defendants do conduct their lives differently going forward, very often getting into recovery and making amends to their loved ones. But as a prosecutor, I don't think about the life sentence of being denied housing or employment, education, or access to financial aid. When I think about those things, I can see that the person who needs to move on to do well has permanent barriers to doing just that. The collateral consequences of merely being charged can harm people for a lifetime. I know that I will be able to access people's criminal history if this bill passes, and that is one of the primary reasons why I support this bill. I need to protect the public. That is my primary job. And so I need access to criminal history to know whether or not there should be an upcharge to a crime, or whether or not I really need to insist on greater treatment and access to recovery resources for someone. I can make people do things as a prosecutor. I take that job very seriously. However, it's not okay to say to prosecutors that rather than telling the truth, making sure that people are held accountable, and then move on with their lives, what we really ought to think about is the fact that people are going to struggle with a lifetime of consequences. That's not what I signed on for as a prosecutor, and that's not a consequence outlined in our laws. It does not help my work to think about that. I'm glad you are thinking about that. Please carefully consider adopting the Clean Slate Act here in Maine. Let people move forward after a reasonable time, after paying their debt to society, so I can focus on my job of truth-telling and accountability, not hidden lifetime collateral consequences. Thank you. I'm happy to take any questions, and I have submitted my testimony electronically.
Thank you very much. Committee members, are there any questions? Seeing the, oh, yes, Representative Kuhn.
Thank you. I asked a question earlier about access to information about subsequent convictions in other states. Presumably all the states that have this law experience similar conditions with that because the databases don't talk to each other. Is that a relevant concern in your viewpoint for the committee to consider in evaluating this?
Not for the work that I do. We have access to all criminal history records. Pennsylvania, for example, adopted this law quite some time ago. I think it might have been in, I think 4 or 5 years ago. I have access when I do my work to a III report. I can access every state's records. It does not matter whether they've adopted the Clean Slate Act or not. And so we do that for every single crime that we review, to be perfectly clear. And we take that very seriously. If, for example, you are being accused of a drunk driving offense here in OUI in Maine, I have access to every state's records, and I can see all of the records of whether or not you've been accused and convicted of that crime previously. So it's one of the big reasons why I support this. I mean, my primary job is public safety. But part of public safety is making sure that people actually can go on to be safe in the community and do well. So having that criminal history, not something I'm concerned about. I believe that is also true for law enforcement at the side of the road, for example. So if they're looking to see whether or not someone, maybe they're doing an investigation for an OUI, it is my understanding after reading this bill that they will be able to access criminal history as well in other states. That will tell them, for example, whether or not what they're referring to my office is a request for a second-time OUI. And that's critical to doing the work of public safety.
It's very helpful. Thank you.
Thank you.
Representative Lee?
Who collects restitution in Cumberland County?
The district attorney's office.
Okay.
We collect restitution, as does every district's office in the state of Maine.
Is there a absence of uniformity in the way it's collected? Such that there's not communication between the different district attorney's offices?
That's a great question. So there isn't uniformity in the way that it's collected. I can tell you that because we adopted a very recent change in Cumberland County, finally allowing people to use credit cards. That has resulted in an incredible increase in restitution going to victims, which I'm thrilled about. It took a long time to get there. However, whether or not someone has paid restitution in full, I don't believe that I can just see another county's information right now on the software that we use. We are moving to other software, I've been told, in 18 months for the last 5 years. So now they're saying in 12 months. So hopefully we'll have greater uniformity in our ability to access that information at that time.
Any additional questions? Representative O'Halloran?
I have a curiosity question that you may or may not be able to answer for me. So if somebody's record is accidentally sealed, it should not have been sealed. Is there, in this process, is there a way to determine that that's happened, and how is that corrected, and who, at whose expense?
That's a great question. I will tell you that'll be a question I really can't answer. In my work, whether or not someone's record has been sealed will not matter. I'll be able to access their full criminal history. I am not sure if this is adopted, if there's going to be an indication on a criminal history that something has been sealed. So that, would be the opportunity I would have to notice, oh, hey, this has been sealed and maybe it's accidental. I will tell you, though, that given that the criminal histories will be fully available to me, the primary concern I have, which is for public safety, is something that I'm really not concerned about if this bill passes. The accidental question of if there's a mistake, I don't really know who would point that out to the courts.
Thank you.
Thank you.
Any additional questions? Seeing none, thank you for your testimony.
Thank you for your time.
Would the next person who wishes to provide testimony please step forward?
Hello.
Welcome.
I have two to read, my own and one from an incarcerated individual. All right. Senator Carney, Representative Kuhn, and the Judiciary Committee. My name is Nicola May, and I am a resident of Lewiston, Maine. I am here today in support of LD 1911. In my professional and personal life, I have the privilege of supporting youth and adults who often have legal system involvement. Individuals who are deeply committed to rebuilding their lives and strive to become contributing members of their communities. Maine has a strong and growing workforce of justice-impacted individuals. Many of them work in the helping professions, supporting recovery, mentoring young people, and giving back to their communities. I'm constantly inspired by their dedication and resilience. Yet, despite years of hard work and personal growth, I've also witnessed how old criminal records continue to be a barrier. I've seen people lose job opportunities they are fully qualified for. I've seen doors to housing close. I've seen individuals forced to repeatedly explain mistakes from long ago that no longer reflect who they are today. These ongoing barriers do not improve public safety. Instead, they undermine stability and make it hard for people to fully contribute to their families, workplaces, and communities. When people are given a real opportunity to move forward, they succeed. They work hard, they lead, and they strengthen their communities. LD 1911 reflects that reality. It maintains accountability while recognizing growth, time, and change. I stand before you today as a person who can testify to the power of second chances and reduce stigma. Over a decade ago, I was prescribed a medication, and that changed the trajectory of my life. I became addicted to opiates, which led to horrible consequences and incarceration. I am fortunate to work in communities where my assets and integrity matter more than my past mistakes. However, DoorDash will not hire me, believe it or not. Our policy should reflect the belief that people are more than poor choices and mistakes they made several years ago. I respectfully urge you to support LD 1911. Thank you for your time and consideration.
And that was your testimony?
That was mine.
Okay, so let's see if committee members have any questions for you. Are there any questions, committee members? Seeing none, we typically don't let people read more than one piece of testimony, but I know you came prepared to do so, so.
I mean,
please.
I could come back after.
No, go ahead and
Okay.
read it, please.
All right. This is written by Darlene George, a resident of Wyndham. My name is Darlene George. I am incarcerated in the state of Maine, and I will be preparing to re-enter society within the next 12 years. I am writing in strong support of the Clean Slate Bill. Maine has made important strides in justice reform by recognizing that accountability must be parallel with rehabilitation and reentry readiness. The Maine model reflects that an understanding that public safety is strong. Sorry, it's very nice cursive, but it's hard to read. Is stronger when parole when people are given the correct tools and opportunities to succeed after incarceration. My own experience reflects this approach. During my incarceration, I have taken responsibility for my past and have worked intentionally toward personal growth, education, and prepared for a productive return to the community. The Clean Slate Bill offers a measurable, evidence-based response. It does not erase accountability. Instead, it provides relief after a substantial period of low abiding behaviors and only in eligible records. This approach respects the role of the courts, supports judicial growth, and rather than imposing lifelong consequences that never intended as a part of the sentence. I respectfully urge the Judiciary Committee to support the Clean Slate Bill. The legislative reflects it affirms the accountability and that redemption and I'm sorry, I just can't read some of this writing. Together with a strong, effective justice system. Thank you for your time, Darlene George. Apologies for the errors.
Thank you. Do you know if she filed a copy of that online?
I'm not I'm not sure,
Okay, could you?
but I will leave this.
Leave that for us and then we
Yes.
can, thank you very much.
Perfect. I'll leave one of mine too.
Thank you. Would the next person who wishes to speak in support of this legislation, please step forward? Welcome.
Senator Carney, Representative Kuhn, and distinguished members of the Joint Standing Committee on Judiciary. My name is Catherine Reagan. Am I allowed to take one of these?
Yes, please do.
My name is Catherine Reagan, and I'm a resident of Topsom. I'm speaking today in support of LD 1911. Not only am I a Maine native, but I am a mother, a person in long-term recovery, and someone who has a criminal record. I've spent the last 10 years of my life creating a life that I never imagined could be possible. I have bought a home, earned a degree, and have had 3 children. Despite my growth and engagement in community, my past follows me. I battled substance use for 15 years before I entered recovery. While battling addiction, I made choices that caused shame, embarrassment, and harm. I made choices that ended with my photo in the newspaper and choices that motivated me to change. My record has prevented me from employment opportunities without consideration of who I have become. I fear the day my 1st and 3rd graders ask why I can't go on their field trips. My community is small, and many of my children's friends' parents work in the school system. I fear my daughters will lose friendships and face community stigma because of my background. They should not be punished for my past. There is an emotional toll experienced when I have to explain the mistake repeatedly when it no longer reflects who I am. These barriers don't just hurt me, they hurt my family, my employer, and my community. I have repaired the harm I have caused through fulfilling legal obligations and by making living amends. I should no longer be judged by an incident that happened so long ago. Each day in both my personal and professional lives, I help others with similar experiences by using mine as a strength. Whether that be through a 12-step recovery program, assisting the unhoused with resource navigation, or supporting women with re-entry into their communities. The current legislation to petition the court for record sealing is unattainable because I can't afford an attorney to help me navigate the process. LD 1911 would create an automated system that would be accessible for people like me. It would also allow me to move forward and be more present in my children's lives. I am no longer an unsafe or irresponsible person. I have been given the name Fun Police by my family because of my level of integrity. To be clear, my record does not need to be erased. That part of my journey forced me to grow and alter my life in positive ways. I'm seeking freedom from my past so I can volunteer and become a chaperone at my school. My story is not unique. There are thousands of Mainers just like me that have worked hard to heal and to change. LD 1911 is not about giving second chances. It's about opening the doorway for earned second chances. I respectfully urge you to pass LD 1911. Thank you.
Thank you for your testimony. Committee members, are there any questions? Seeing none, thank you. The next person who wishes to speak in support, please step forward. Welcome.
Good afternoon, Senator Carney and Representative Kuhn and other distinguished members of the Joint Committee. It's good to see you all again. My name is John Reynolds, and I'm a resident right here in Augusta. I am here today in strong support of LD 1911. I am a person in long-term recovery. Up until 2018, my life was defined by substance use disorder. And during that time, I accrued some criminal charges through my interactions with law enforcement, some directly and some indirectly related to my substance use disorder. When I entered recovery, I had no driver's license, no education beyond the 7th grade, a massive amount of unpaid fines, no stable housing, zero employment, and very little hope for my future. Throughout the years of recovery, I have decided to change my life, but it did not happen quickly and it did not happen easily. I went back to school and earned my GED. I went on to college and completed the education required to become a certified alcohol and drug counselor. I later passed the ICRC state exam. Even after meeting and receiving some of the requirements of the state, I was denied licensure because of previous criminal history. But instead of giving up, I kept going. I earned my associate's degree in mental health and human services, and then went on to complete my bachelor's right here at the University of Maine at Augusta. I have been steadily employed throughout the last 5 years through local nonprofit organizations serving people in recovery, people experiencing homelessness, and people living with mental health challenges. I have paid every fine that is owed to the state of Maine, and at the age of 32, I finally obtained a legal driver's license. I lost that privilege when I was 15. Before I could even get a license, I lost my privilege. Understandably so. I worked extraordinarily hard to rebuild my life with intention, accountability, and humility. I did not do this alone. I had a rare privilege of being submerged in connections to the recovery community. This is not the case for most of the people with similar experiences of mine. Still today, my past involvement with law enforcement presents significant barriers in my life, especially when applying for something that requires a thorough background check. Many of the opportunities that I've received only came because somebody decided to see me as who I am today and not just what a piece of paper says about who I am. They decided to connect with me and get to know me instead of just believing some black and white on a piece of paper. I've been stably housed and gainfully employed for over 5 years now, providing services to vulnerable people like me. This was not attributed by some happenstance, but solely on the fact that I advocated heavily for myself and was able to gain trust in my peers. Today, I serve on many local advisory boards for nonprofit organizations. I was appointed to the task force on homelessness by the mayor here in Augusta. And I'm currently serving my second consecutive commitment on the board of advisors at Riverview Psychiatric Hospital. I was recently elected to.
Excuse me, could you please wrap up in
Oh,
a
yep.
sentence and then we'll see if there are committee questions for you?
Yes, absolutely. Sorry about that. A significant privilege I was afforded to due to my work with the community and building the trust of my neighbors. I support LD 1911. I will get my testimony sent to you electronically later this afternoon.
Thank you. We're very appreciative. Committee members, are there any questions? Seeing none, once again, thank you for your testimony. Would the next person who wishes to testify please step forward? Welcome. You could put those right in the basket.
Thank you so much. Good morning, members of the Judiciary Committee. My name is Courtney Gary Allen. I'm the Executive Director of MERAP. I'm a person in long-term recovery. This bill would actually also help me, but I am going to actually read a testimony from Tia Wright, who is a member of lifelong resident of Oxford County. She writes, "My name is Tia Wright, and I am a lifelong resident of Oxford County, Maine, and I am a 40-year-old single mom of two beautiful children. I'm also a person in long-term recovery. During my active addiction, I made poor decisions that landed me in jail, and as an embarrassing as it was then, it was no reach on the embarrassment and shame I have today, now that I have done everything in my power to better my life for me, my kids, and my community. My life today is 1000% different than it was in active addiction. I've been sober since February 9th of 2023. Have had the opportunity, accomplished a lot since then. I have custody of my children. I'm a homeowner. I volunteer. And more importantly, I'm an active part of my community. I have a full-time job as a certified peer support specialist for the Hills Recovery Center, where I help people in active addiction find their pathway to the life that they deserve. During my own recovery journey, I realized how much of a struggle it was to acquire necessary things due to background checks, things like jobs and housing. And now, being a peer support specialist, I work with so many people who face that same struggle. It's hard to do and watch someone overcome the fight of their lives just to struggle yet another battle, being turned down, job opportunities and housing, and so much more, due to the poor decisions in active addiction long ago. Not only is it difficult for me to have hope about the future, but it's difficult to instill it into others when there are poor choices from active addiction in the past still follows them today. When does the sentence stop? From my personal experience, it does not stop. It follows you no matter how long or how big of an obstacle you have overcome. I'm writing this to show my support of LD 1911, and I beg you to do the same. It's not about second chances. It's about giving an opportunity back to those who have already fought to change their lives in better ways. Thank you.
Thank you so much. And since that was not your testimony, we won't ask for questions, but
Thank
thank
you.
you for reading the testimony today. The next person wishes to step forward.
Good morning, Senator Carney, Representative Kuhn, and members of the Joint Standing Committee on Judiciary. My name is Duncan Pierre. I live in Lewiston, Maine with my wife and two sons, and I'm here today to speak in support of LD 1911 and the principle behind it. We live in a time when people are often permanently defined by the worst decisions they make early in their life. But the reality is most of us are not the same people at 40 that we are when we're 14, 20, or even 25. Growth happens, maturity happens, change happens. My own involvement with the justice system began when I was very young. Like many people, I made impulsive decisions and poor choices before I had the judgment and stability I have today. Over time, I took responsibility for my actions. I grew up and I chose a different path. Today, I'm a husband and a father. My wife and I serve as youth and young adult pastors at our church. And for the past several years, I've worked with organizations across Lewiston and throughout Maine to support young people. I often tell them that their past does not have to define their future. But I also know how hard it is to believe that when our old records continue to close doors long after someone has changed. Even after people have paid their debt, criminal records can still affect employment, housing, education, and full participation in community life. That ongoing punishment doesn't always make our community safer, but it does make it harder for people who are doing the right thing to keep moving forward. I want to be clear, accountability matters, public safety matters, and where lines are drawn is a serious responsibility that belongs to this legislature. My reason for being here today is not to speak to specific eligibility, but to speak to a larger truth, that people are capable of real, lasting change, and our laws should recognize that reality. LD 1911 represents a thoughtful step toward balancing accountability with opportunity. By allowing for relief after long periods of lawful behavior, it reinforces the idea that rehabilitation is possible and worth acknowledging. Thank you for your time and for the work that you do on behalf of Maine people.
Thank you for your testimony. Committee members, questions? Seeing none, thank you. Would the next person who wishes to speak in favor, please step forward. Welcome.
Senators, my name is Jill Horn Carey. I'm a local resident here in Augusta in the Enzo program. I was arrested on July 13th, 2023. I was released from jail and I got out trying to make the next right choice. I applied for hundreds of jobs a month. I wouldn't even get a call back. I continued to try to get employment or get help. I went to the Career Center. The doors always seemed to be closed to me because of my record. Then I was down here at Enzo. I got hired on the spot at a couple jobs, but after they pulled my background check, I then lost my job that I was hired on the spot with. I support this bill. I think it would give people like me an opportunity trying to do the next right thing and continue my careers. I also was filling out some information in an interview to get help to finish my business management degree. I was asked if I had a felony on my record, and I said yes, I was disqualified. So I support this bill as well. Thank you.
Thank you for your testimony. Committee members, are there questions? I'm not seeing any. Thank you.
Thank you.
The next person who wishes to speak, please step forward.
Good morning. My name is Will Clark. I'm a person formerly incarcerated, long-term recovery. I got sober in 2016. And I'm a person that's greatly affected by, being a felon and having felonies on my record. And, I've had a lot of dreams and aspirations while in recovery, right? It's like these little epiphanies of like, oh, I want to do this. I want to make this move. And then I go and look, oh, background check. No, there's no way. It's like, I don't have one felony. I got a bunch of felonies, right? I was, all from addiction, all possession charges. But, and that's one thing, right? But one thing I do know that's greatly affected is I have two kids and they're 5 and 7. And I live in Portland, Maine. And if you ever try to find an apartment in Portland, Maine, the majority of the places are property management. They all do background checks. One felony, you're disqualified. Now, with me and the place I am in my life, I'm okay with that. I will find a way, right? But I'm not the only one paying the consequences here. My children are also paying the consequences for what I did. And, for housing, just to be such a privilege and not a priority is where my mind says, wow, things need to change, right? I did, get into a job, became a yoga teacher. Why? Because it's a place where they have a lot of compassion, right? They don't do background checks to be a yoga teacher. And it's great and I love it. But I also have more dreams and I want to go places. And yeah, I mean, it just kind of seems simple to me from this end. Why anyone would want to support this film. Thank you.
Thank you. Committee members, are there any questions? Seeing none, thank you for your testimony. Would the next person who wishes to speak in support, please step forward?
I have a testimony from someone who's currently incarcerated that's quite short, and then I have my own. I want to prioritize theirs. Am I allowed to read both or come back?
I think I'm a little concerned about people providing multiple testimonies. Why don't you go ahead and present your own and then prioritize whichever one you would like. And then just, we'll see how much time and
Okay, this is
make a
very,
decision.
very short.
Okay, go ahead.
Testimony in support of LD 1941, an act of implementation recommendations of the commission to examine reestablishing parole. Actually, she's writing about 1911, but she wrote the wrong beginning. Distinguished members of the Judiciary Committee, my name is Tia Ludwig. This person now goes by Orion, and I am writing in support of the Clean Slate Bill. The benefits of this bill are as follows. Incarcerated individuals who are reintegrated back into society look for jobs, housing, and opportunities to change and live productive lives. I myself will soon be one of those people. I go into prison, and it was supposed to be a penance that you pay to society for violating society's laws. That is the basic premise of incarceration. However, upon release, people are continually subjugated to more punishment. Job opportunities are few and far between, housing even harder to find. The challenges these people face add an additional difficulty for the rest of their lives. Let the punishment be the punishment and let people try to prosper without the additional challenge.
Then you can continue with your own testimony.
Okay. So my name is Jenny Ferrari. I'm a resident of Portland, Maine, born in Bangor, and I am an intern with the Center for Effective Public Policy with Erica King. And I have the opportunity of weekly writing with some women at the Maine Correctional Center. And I wrote this with them on the Clean Slate Bill. It's called Housing is Freedom. It's based on my own experience. Although I've never been incarcerated long-term myself, I've been affected directly by how unstable housing is for folks who have been. When I found out I was pregnant with my first child, his father was just over a year out and couldn't pass a single background check. I searched Craigslist and Zillow every day to find something we could afford in our area that wasn't managed by a company with background checks as far back as 20 years at times. We would show up at apartment after apartment, explain our situation, my big pregnant belly and all, and would receive another no, I'm sorry. We settled for a tiny one-bedroom run by a slumlord who didn't check us, but also didn't check the apartment. It was full of bed bugs, a shower that didn't drain, and a shattered third-story window. I took care of an infant in this apartment. I remember sobbing while stripping the bed, spraying the mattress with bedbug spray over and over, postpartum and raw and scared. The freezer broke and I lost all of my breast milk. After several years, we finally got out. A landlord who was a friend of a friend willing to give us a chance. But I worried about the next time the house got sold or the rent went up. With his record, we would never be able to find a place quickly. Would we end up on the street? Would we have to move north? And so on. Apartment after apartment, a rent raise, a new baby, a new school district, a tiny house in the woods with no running water, just a place to go with the kids, complete instability. Today, I am under contract with the same partner for our own condo in Portland. We actually just closed. This is a massive achievement for both of us. We're both people in long-term recovery, and hopefully for the first time in all of our lives and our family of four, housing stability. A clean slate bill would have given us more housing stability from the get-go. Our children are 5 and 7. The ability to rent a decent apartment, affordable housing projects for justice-impacted people would also be a big step. But housing stability in general should be a right for everyone. Our family deserves a stable home, and so does yours.
Thank you for your testimony. Committee members, are there any questions? No, seeing none, thank you very much. The next person who wishes to speak in support, please step forward. Welcome.
Morning. Senator Carney, Representative Kuhn, distinguished members of the committee, my name is Peter Lehman. I'm a formerly incarcerated citizen and person in long-term recovery. I'm testifying on behalf of the Maine Prisoner Advocacy Coalition, promoting restorative practices to increase public safety and the health of our communities. Excuse me. As you're well aware, any criminal conviction is a life sentence. With recent development of cheap and easy criminal records and the development of business screening services making money using them, any criminal record follows a person like a shadow, whole families like a shadow, haunting their efforts to find work, find housing, and even recreation. Over and over, I've come to this committee about various record sealing bills, complaining that they were not automatic. And telling you about the problems of petition. This bill, and I also want to provide some perspective on what this bill entails. 84% of Maine criminal cases in 2018 were for misdemeanors. Most people who have criminal records have misdemeanor records. This bill is primarily concerned or primarily focused on those people. Most of those people never come back to court. Most of those convictions are their only court record, but it goes on forever for life. This clean slate bill mostly applies to people with misdemeanor records who never got into trouble again. Not only, but mostly. We estimate that 163,000 people will have their records sealed if this is implemented. Thousands in your district. Really, thousands in your district. 163,000 people mean most families in Maine. That's a lot of people. That's a lot of families. Ordinary people in ordinary families with an unjust anchor around their necks. How can you explain to them opposing this bill? Honestly, this is a way of benefiting a huge number of people. We're not talking about sealing records of serial criminals or the stereotypical bad guys from television. We're talking about people convicted mostly of misdemeanors. The important point here is that we're stopping the lifetime punishment of people long after they've completed their sentence. Thank you very much for your generous attention. I'll be happy to try to answer questions.
Thank you for your testimony. Committee members, are there any questions? Seeing none, thank you.
Thank you.
I just wanted to let people know, if you are hoping to testify for another person who submitted written testimony, if you could just please put the written testimony of the other person in the basket. We have a lot of folks here today for this legislation and for other legislation, and we want to make sure that we're able to hear from all of the people who have appeared in person. And we will, I promise you, take the time to read all of the written testimony of others. So with that, would the next person who wishes to provide testimony, please step forward. Welcome.
Good morning, almost afternoon. Senator Carney, Representative Kuhn, and distinguished members of the Joint Standing Committee. My name is Nikki Merrill, and I am a person in long-term recovery and the MDOC Recovery Program Coordinator for the Portland Recovery Community Center, also known as PRCC. I'm speaking on behalf of Nicole Proctor today, PRCC's Executive Director, in strong support of LD 1911. An act to automatically seal criminal history record information for certain crimes. I'd like to also say I've submitted written testimony already personally, as I am a sister directly impacted by what this could be helping. So PRCC is a peer-led recovery organization serving Greater Portland and supporting communities statewide through the Maine Recovery Hub. Every day, we work with individuals who have rebuilt their lives, people in recovery supporting their families and contributing to society. Yet old criminal records continue to create barriers to employment, housing, and stability, even after years the sentences are complete. In Maine, 1 in 4 adults lives with a criminal record, often from low-level nonviolent offenses. These records undermine recovery by limiting access to safe housing and work opportunities, making it hard for people to fully participate in their communities. When stability is out of reach, recovery becomes harder to sustain, and the ripple effects impact families, employers, and communities. In 2022, the legislature created a petition-based process to seal certain misdemeanor records. While well-intentioned, it has proven largely inaccessible, requiring time, legal knowledge, and resources that many Mainers don't have. And as a result, very few eligible people obtain relief. With LD 1911, we have opportunity to modernize Maine's approach by creating an automated record sealing process, aligning us with other states that have adapted clean slate policies. Automation ensures relief is applied consistently and equitably, regardless of income or access to legal counsel. This bill maintains public safety while removing outdated barriers that prevent people from moving forward. From a recovery perspective, LD 1911 is critical. Long-term recovery is supported by access to stable housing and meaningful opportunities, including employment, which strengthens personal agency, dignity, and self-determination. On behalf of PRCC, I respectfully urge you to vote ought to pass on LD 1911. Thank you for your time and consideration.
Thank you for your testimony. Committee members, are there any questions? Not seeing any, thank you. And at this point, we've been joined by a couple of committee members who weren't here when we did introductions. Representative Caruso, would you like to introduce yourself?
Yes, thank you, Madam Chair. Welcome. I'm Elizabeth Caruso. I represent the people of House District 72, which is much of northern Somerset County.
Thank you, Madam Chair. I'm Jennifer Poirier. I represent House District 70, which is Skowhegan. Apologize for being late. Had a family emergency this morning, but I've been listening to testimony on my whole drive here.
Would the next person who wishes to speak in support of 1911, please step forward? Welcome.
Senator Carney, Representative Kuhn, and members of the Judiciary Committee. My name is Lonnie Graham. I'm a physician and former Chief Public Health Officer for Maine. I'm submitting testimony in support of 1911 and the proposed amendment to it on behalf of the Maine Medical Association and the Maine Osteopathic Association. I speak today from a medical and public health perspective. LD 1911 is not only a justice reform bill, but also a health intervention with measurable benefits for individuals, families, and communities across Maine. As clinicians, we understand that health is shaped far beyond the walls of hospitals and clinics. Stable housing, reliable employment, access to education, and freedom from chronic stress are among the strongest predictors of physical and mental health. A criminal record, particularly for low-level, nonviolent offenses, directly undermines these foundations. Research consistently shows that a conviction reduces a job seeker's chances of employment by nearly 50% and nearly 90% of landlord checks. These barriers translate into housing instability, food insecurity, untreated chronic disease, depression, anxiety, and substance use relapse. From a medical standpoint, the benefits of record sealing are clear. Studies show that individuals whose records are sealed experience significant increases in employment and wages, about 23% rise in average quarterly earnings within a year. Employment is one of the most powerful predictors against poor health outcomes and recidivism. Stable income improves access to primary care, medications, preventive services, and mental health treatment. It reduces reliance on emergency departments, crisis services, lowering long-term health care costs borne by taxpayers. Mental health is also central to this discussion. The lifelong stigma of a criminal record perpetuates toxic stress, an established risk factor for cardiovascular disease, depression, substance use disorders, and early mortality. Automatic record sealing helps relieve this chronic stress burden and restores dignity, autonomy, and hope, therapeutic effects that cannot be prescribed but are deeply consequential. The current petition-based system has failed to deliver these health benefits. Despite legislative intent, only a small number of Mainers have successfully obtained record sealing. Automation corrects this inequity and promotes health equity statewide. We urge you to vote in favor of 1911 and to support a system that allows individuals who have earned a second chance to fully reclaim their health and well-being. Thank you.
Are there any questions, committee members? Seeing none, thank you.
Thank you.
The next person who wishes to speak in support, please step forward.
Good afternoon, Senator Carney, Representative Kuhn, and honorable members of the Judiciary Committee. My name is Tess Parks, and I am the Policy Director of Maine Recovery Action Project, a statewide grassroots network working on community and policy-based solutions to substance use. I recently had the privilege of serving on the Criminal Records Review Committee as a representative of Maine's recovery community, who you've heard a lot from this afternoon. I'm here today to testify on behalf of our statewide team of organizers in support of LD 1911. This was actually one of our top 4 policy priorities for this legislative session. We are a listening first organization. Between legislative sessions, we travel from Aroostook County to York County and everywhere in between to hear directly from people with lived experience. One message we consistently hear that you've also heard today repeatedly: legal records make it harder for people in recovery to find jobs with livable wages and secure housing. These barriers do not exist in a vacuum. They are among the many social and economic costs of our opioid epidemic. In response to this crisis, our Maine Attorney General and 39 litigating subdivisions filed suit to hold these pharmaceutical companies accountable for their role in widespread overprescription of opiates. They knowingly and intentionally underplayed the addictive risks of opiates. At the peak of this crisis, Maine had the 6th highest mortality rate for overdose deaths in the country. Maine will receive approximately $230 million in opioid settlement funds through 2038. Millions are already being invested in prevention, treatment, and recovery services. As a state, we invest significant funds every single year into programs such as recovery residences, drug treatment courts, and many other services to bolster recovery and healing. Lives are being saved, fatal overdoses are going down. These investments are not just critical at the individual level. The economic toll of the opioid crisis has been staggering in Maine. According to UMaine researchers, we lost approximately $270 million in market and non-market activity due to drug-related morbidity. Other researchers estimated that the combined cost of opioid use disorder and fatal opioid overdose totaled more than $6.8 billion. I'll say that again, $6.8 billion in Maine, and that was just for 2017. Our budget and our spending show that we value recovery. By enacting LD 1911, we can ensure our significant investments in recovery services are not in vain. The costs of not doing so are high. We all benefit when earned second chances are available to our community members. I thank you for your time and consideration, and I'm happy to answer any questions.
Thank you very much for your testimony. I want to start with one question. Excuse me, Tess, I just have one question for you.
No questions.
Thank you for presenting us with data, and you did cite 3 different articles in your footnotes. Could you please email PDF versions of those to our committee clerk?
I would be happy to.
Thank you very much. Are there any other questions, committee members? Thank you. The next person who wishes to speak in support, please step forward. Welcome.
Senator Carney, Representative Kuhn, and distinguished members of the Committee on Judiciary. My name is Heidi Lester, and I am the Deputy Director of Equality Maine, which has been advocating on behalf of Maine's LGBTQ+ community since 1984. We strongly support LD 1911 because we believe that people and their families should have the chance to move forward with their lives without forever being defined by something in their past. Lesbian, gay, and bisexual people are more than twice as likely to be arrested as straight people, and lesbian and bisexual women specifically are more than 4 times as likely to be arrested as straight women. LGBTQ+ adults broadly are incarcerated at 3 times the rate of the total adult population, and their overrepresentation in the carceral system is due to their experiences of high rates of homelessness, poverty, unemployment, discrimination, and violence. In fact, LGBTQ+ people, particularly those who are low income and or people of color, are overrepresented in all stages of the criminal justice system, from their high rates of juvenile justice involvement to the long sentences they often receive as adults. Rates are especially high for transgender women of color, who are frequently targeted by police for simply existing in public spaces. People with records face significant barriers that hinder their ability to thrive, affecting employment, housing, education, and overall quality of life. The situation is particularly challenging for LGBTQ+ people who already face difficulty in getting jobs and finding housing because of discrimination based on their sexual orientation and gender identity. For LGBTQ plus people of color, the well-documented discrimination based on race and ethnicity can make finding a job and housing even more onerous. Ultimately, the intersection of overlapping and interdependent stigmatized identities, such as being LGBTQ plus and having a criminal record, can compound discrimination, social stigma, and the pressures of minority stress. And in addition to causing and exacerbating health problems, substance use, and food insecurity, a lack of stable housing and employment opportunities significantly increases recidivism rates. But by passing LD 1911, a streamlined automated record sealing process can remove barriers and promote dignity for thousands of Mainers. We urge you respectfully to vote ought to pass on this bill and give people who have served their time and demonstrated change a second chance to rebuild their lives. Thank you.
Thank you. Questions, committee members? Thank you. The next person who wishes to speak in support, please step forward.
Hey there.
Hello.
My name is Nicola Verdier, and I'm from Norway, Maine. Senator Carney, Representative Kuhn, and members of the Joint Standing Committee on Judiciary. My name is Nikki Verdier, and I'm a proud lifelong Mainer and a mother in recovery from substance use disorder. I am very proud to work at the Hills Recovery Center in Norway, Maine, where I was born and raised. Every day I sit with Mainers who are doing the challenging and rewarding work of healing and changing their lives. They show up for recovery meetings, rebuild relationships, apply for jobs, and try to find stable housing. They're trying to do what we want all people to do when they have made mistakes: take responsibility, grow, and contribute. And again, I watch a past record become the wall they cannot get around. For people in recovery, stability is the difference between staying on track and falling back into survival mode. It is having a safe place to live. It is being able to work. It is being able to go to school or training. It is being able to show up for your kids. It is the ability to move forward without being punished forever for something you did years ago, sometimes decades ago, when you don't even feel like that person anymore. The people we serve are not asking to erase the past. They are asking for a fair chance to build a future. Right now, even when someone is eligible for record sealing, the process can be confusing, time-consuming, expensive, and intimidating. Many people do not even know where to start. Others give up because it feels like one more hurdle they can't clear. In recovery, we talk a lot about removing barriers because barriers can become triggers. When someone finally has momentum and hope, and they are turned away from housing or employment because of something that occurred years ago, that hope can collapse fast. I've seen how quickly that discouragement turns into isolation, shame, and giving up. LD 1911 matters because it creates an automated process for sealing certain eligible records after a person has remained conviction-free for a set period of time. In plain terms, it makes record sealing something that happens for people who qualify instead of something they have to navigate alone. That change is huge. It means relief is not limited to those who have money, legal help, transportation, internet access, time off work, or the confidence to walk into a courtroom and argue their worth. This bill is about public safety and community health. People do better when they have steady housing, steady work, and a real reason to believe their future can be different. Removing unnecessary barriers helps people stay stable. It helps Maine's workforce and its families and entire communities. One of my favorite things about working in recovery, the recovery community, is that it reflects the true diversity of our state. This includes diversity of thought and beliefs and politics. Addiction and recovery impact every type of person. I see supporting redemption for past mistakes and poor choices as a truly bipartisan issue. This bill is a practical, bipartisan solution that states across the country have already pursued. Similar clean slate laws have passed in more conservative states like Utah and Texas, Oklahoma, and Kentucky, and more liberal states like Massachusetts and New York. Maine would not be reinventing the wheel here. At the Hills, we know that recovery is possible. We see it every day. LD 1911 recognizes that people can change and that our system can evolve to better support that. This bill would give thousands of Mainers a better shot at stability, productivity, and hope. It would help people in recovery move forward instead of being pulled back by their past. I respectfully urge you to support LD 1911. Thank you so much for your time and consideration.
Thank you for your testimony. Committee members, are there any questions? Not
Thank
seeing
you.
any. Thank you. The next person, please step forward.
Senator Carney and Representative Kuhn and distinguished members of the Joint Standing Committee on Judiciary. My name is Julia Lester, and I'm the Community Engagement and Peer Support Specialist at Western Maine Addiction Recovery Initiative, WMARI, and the Hills Recovery Center. We testify today in strong support of LD 1911.
Wamari was founded over a decade ago by law enforcement officer frustrated by the way that they had been responding to overdose and substance use related calls. Since then, we've become a coalition of medical providers, law enforcement, our local school district, faith leaders, recovery centers, behavioral health providers, community nonprofits, and small businesses. Each in their own ways and responsibilities has shown a commitment to an investment in our communities to help end the stigmas directly and indirectly associated with substance use disorder. Western Maine has the second highest rates of poverty, food insecurity, and unemployment, and the highest rates of people working part-time and seasonal jobs and earning less than a living wage. Opportunities are limited. If you're being denied housing in one town or lose a job, there may not be another option down the road. People are doing exactly what we ask of them: complete treatment, remain conviction-free for years, trying to stabilize their lives, support their families, and contribute to their communities. A single background check can undo months or years of progress, as well as making less effective the significant investment made through the state grants, opioid settlement funds currently, and federal funding in the past. We see people offered jobs and housing and have those offers pulled in the last minute. We see people stuck in unsafe or unstable living situations because landlords rely heavily on background checks. We see people cycling through short-term work, not because they are unreliable, but because their past continues to disqualify them from long-term stability. When someone cannot secure housing in rural Maine, they are more likely to end up in emergency rooms, jails, or in crisis. When someone cannot access employment, it undermines recovery, family stability, and local workforce needs. The current record ceilings process does not work for the people we serve. It assumes time, money, legal knowledge, and flexibility that many working Mainers simply do not have. The result is that relief exists on paper, but not in practice. This bill will strengthen rural communities by increasing access to stable housing and employment, reducing recidivism, and helping local employers fill persistent workforce gaps. It would also reduce the strain on emergency services and systems that are already stretched thin in counties like ours. We believe accountability matters, but so does proportionality. LD 1911 is a practical step toward a system that works for real people in real communities. For Western Maine, it is not just about fairness. It's about stability, health, and keeping our communities whole. We respectfully urge you to vote yes on LD 1911. Thank you for your time and consideration.
Thank you for your testimony. Committee members, are there any questions? Yes, Representative Lee.
Just out of curiosity, is Wamari's coverage area, is it just Oxford County? Or does
Just as this year, it's Franklin and Androscoggin as well.
Any other questions, committee? Seeing none, thank you. I want to let people know that we're going to continue committee until 12:15, and then we're going to take a half-hour break for lunch. So I just want to let people know, and with the next person who wishes to speak in support, please step forward.
Hello. All right. Good afternoon. Senator Carney, Representative Kuhn, and members of the Judiciary Committee. My name is Cage Johnson, and I'm a resident of Winslow, Maine. I'm here today testifying in favor of LD 1911 on behalf of Healing First, as well as an individual. I'm also a steering committee member of the Maine Restorative Justice Coalition Merge. I'm the Maine State Chapter Representative of the Global Coalition Survivors for Justice Reform, and I'm a survivor of serious harm, including assault and rape. And we are in full and earnest support of LD 1911. Healing First, a Maine-based transformative justice collective led by survivors of serious harm, including sexual assault, intimate and domestic partner violence, and gun violence, has come to be because we see an immense need to claim a public collective voice as survivors who want restorative approaches and healing-based alternatives to incarceration in the wake of harm. This includes the destigmatization and decriminalization of those who have committed past crimes. God forbid we each had our life trajectories forever defined and limited by the worst thing we've ever done or the worst mistake we've ever made. After decades of overcriminalization and mass incarceration, 25% of Mainers now have a criminal record. This presents massive and permanent barriers to education, employment, and housing stability. Communities are no less safe when eligible records are sealed, even for crimes of violence. Data has proven that these individuals are no more likely than the general population to commit a new offense 4 to 7 years after their most recent offense. States such as Michigan and Minnesota we can look to, which pair record sealing policies with robust reentry support, have some of the lowest recidivism rates in the nation, which clearly illustrates the strategic value of clean slate laws in advancing public safety goals and reducing our failing reliance on the criminal legal system while also benefiting our economy. As survivors of serious violence, what we would like you to hear the most is we who have overcome the impossible of healing from tremendous harm and trauma, with no thanks to our punitive criminal legal system, we know firsthand that tremendous transformation for all people, when given the necessary conditions and support, is possible. We, as survivors of serious harm, are acutely aware that we are never defined by the worst of our experiences, our mistakes, or harm we've caused, intentional or not. This stands for every human being. I passionately restate Healing First position of being in full support of LD 1911. If overarching goals of a justice system are to prevent or reduce crime and to foster rehabilitation, let's allow people their rehabilitation. Allow people who have already paid heavily for their mistakes and who have transformed for the better the opportunity to live and experience life and new opportunities with a clean slate. We urge you to invest in healthy and whole communities and not prolonged harmful stigmatization by voting in favor of LD 1911. Eternal stigmatization and discrimination is not public safety. It's damaging. We say not in our name. If you feel for victims, then please listen to us. To be clear, we support these bills into the future that would expand this to violent crime as well. On behalf of Healing First, we thank you for your time and consideration.
Thank you for your testimony. Are there any questions, committee members? Seeing none, thank you. And would the next person please step forward? Welcome.
Hello, Judiciary Committee. Hello, Senator Ann Carney. Hello, David Sinclair. My name is Maine Attorney Theodore Berry Esquire. I work at Berry Advocacy PLLC, and I'm here to support this bill. However, I'd like to also stress the importance of having this committee really take the time to focus more on the racial stigma of non-conviction arrest. We have never codified a definition for descriptive racial stereotypes. Descriptive racial stereotypes are stereotypes about what members of a specific race are like. There's a very prevalent descriptive racial stereotype that exists in Maine, that all African Americans are criminals. And so taking a special look at non-conviction arrest and allowing the police to engage in this non-conviction arrest information and using it to sort of create a racial bias against drivers. I have a perfect driving record. I have been stopped as many as 40 times in a
Attorney
year.
Berry, I just wanted to ask you if you have anything that you'd like to share with us specifically on 1911.
Yes, so
We do take up bills related to the topic that you're
Yes.
addressing, but for today's public hearing, please keep your testimony to the bill related to record sealing.
yes, so I'd like to add to Representative Sinclair's point on VCR. So I'm from Rockland. In Rockland, November of 2014, we had a VCR in the Knox County Jail that ended up in the person's death. The VCR was a death sentence. And so issues related to sealing, issues going beyond sealing, it's just there's a real unfairness with how racial minorities exist. For me, I'm afraid to drive. I'd like to live a long life, and sealing related to employment, related to trying to apply to education. These have been real barriers for individuals. And right now in Rockland, the present wait time to actually have a motion to seal hearing, it's about 4 months. And then even if you have a hearing, you may have a prosecutor that comes unprepared and requests a continuance. And then you're looking at 6 months or longer. And for individuals that don't have, without this automatic stay, it forces individuals to have to relive the nightmare of the process itself, which is why I think a lot of people don't come forward and file these motions to seal presently. Thank you.
Thank you for your testimony. Committee members, are there any questions? Not seeing any. Thank you. The next person, please step forward.
Hello.
Go ahead.
Well, good morning, Senator Carney, Representative Kuhn, and distinguished members of the Judiciary Committee. My name is Linda Small. I'm the Executive Director of Reentry Sisters in Portland. And today I'm here in strong support of LD 1911, an act to automatically seal criminal history record information for certain crimes. And I want to begin with a brief personal story that illustrates exactly why this bill matters. 3 years ago, I applied for a professional position at the University of Southern Maine. I was selected from a competitive pool of candidates and formally offered the job. As part of the hiring process, I was asked to complete a background check. I disclosed my conviction, including the date, the charge, and my name at the time. I also went a step further and wrote an email to Human Resources and flagged this disclosure and asked who should I speak to if further clarification was needed. 2 days later, I was notified that my background check was cleared and instructed to sign my employment contract. I did, and my first week was extraordinary. For the first time in years, I had economic stability, health care, and access to tuition support to complete my PhD. 1 week later, I was fired by Human Resources for withholding information about my background. This was despite disclosing it in writing and proactively. The message was unmistakable. My qualifications were acceptable, but my past, now more than 17 years behind me, wasn't. This experience is not unique. Approximately 72% of colleges and universities use background checks in hiring practices. Now, in Maine, where roughly 1 in 4 adults has a legal background, this kind of discretionary screening becomes a permanent barrier long after a sentence has been completed. Automatic sealing matters because it removes arbitrary and inconsistent decision-making from systems that aren't equipped to assess rehabilitation, context, or time passed. LD 1911 recognizes that people should not be forced to repeatedly relitigate their worst moment in order to work, pursue education, or provide for their families. This bill doesn't eliminate accountability, nor does it apply to all offenses. What it does is acknowledge that perpetual punishment through public records undermines economic stability, workforce participation, and educational opportunities. LD 1911 is smart and fair policy, and I urge this committee to vote ought to pass to ensure that completing a sentence truly means having a second chance. Thank you. Happy to answer any questions.
Are there any questions, committee members? Seeing none, thank you very much.
Thank
The
you.
next person who wishes to speak in support, please step forward. Welcome.
Thank you. Senator Carney, Representative Khan, distinguished members of the judiciary. My name is Joseph Jackson. I'm the Executive Director of Maine Prisoner Advocacy Coalition, and I'm the Co-Executive Director of Maine Inside Out. I'm an individual who spent 20 years inside the Maine Department of Corrections, and I work every day with system-impacted people. I'm here in support of 1911. I believe that this bill is in the right direction of where we want to go. I would just say I would like to see all criminal records at some point eventually be sealed, automatically sealed at some point. One of the things that for me also sat on the Criminal Records Review Committee, I was one of those members, and we got to hear about how many different individuals can come and petition for many different ways to have their records sealed, but there were really very few times where we saw where that happened. But one of the things that was clear is that there were collateral consequences to when people do receive a felony conviction. So once a person receives a felony conviction, there are collateral consequences that last a lifetime. This bill is really close to me because I started working with young people out of Long Creek. And there was this one young man, I'm gonna tell this quick story, where he was held to the point where he was 18 or 19. And he was released full of hope. He started engaging in our community programming. And then he found a job at UPS. He was really happy. He was like, I finally got to the place where I can make it. And 2 weeks in, his boss was telling him he was doing good. And then they did a background check and he lost his job. He fired him. That turned into him reverting back to the street. To this day, 10 years later, he's still in and out of the criminal justice system. But imagine if he had received that job and was able to keep that job, the trajectory of his life could have been different. For me, it's also been was the same way when it came to looking for housing. I had the fortune of having a family take me in when I first got out, and they allowed me to live with them for 3 years. So I was able to build up and save some money for myself. But when it came time for me to move out and find my own place, I couldn't find a place. I would apply, and I was wondering why this lady that came before me always got the place. And it happened over 12 times. And I started to realize I was being steered toward particular communities. Even though I had resources, even though I had education now, I had to end up buying my own house to find my own place to live. So LD 1911 is really important, it's vital. And hopefully, and my story and the story of that young man is just a story amongst many that folks we work with. We work with people on a regular basis, and they're experiencing this on a daily basis. And so we're pulling communities together of young people and adults to support each other to overcome these barriers. But we need legislation like this to help us with that. So thank you. And I'm free to answer any question.
Thank you for testimony. Committee members, are there any questions?
Thank you.
And also thank you for your service on the Criminal Records Review Committee.
Thank you.
Next person, please step forward.
Hello, this testimony is in support of LD 1911. The esteemed members of the Judiciary Committee. My name is Nicole Lund. I'm a certified alcohol and drug counselor, and I live in Wilton, Maine. I'm here in support of LD 1911. A criminal record continues to punish a person long after they have successfully repaid their debt to society. A criminal record can severely limit a person's access to employment, education, housing, civic engagement, and public assistance. And digital access to criminal records have made it easy for employers and landlords to discriminate viable candidates based solely on a prior criminal conviction. Similarly, lenders and educational institutions use this information to disqualify applicants. Spouses and children whose parents have criminal records are punished also by being denied access to these resources. This contributes to the generational pattern of criminality. Record sealing allows people an opportunity to develop the social capital that deters them from future law violations, improve outcomes for their family, and contribute to the economy. Research shows that people who remain crime-free for a certain period are no more likely to commit a crime than anyone else in the general population. In fact, individuals with sealed criminal records commit fewer crimes than the general adult population. Clean slate policies recognize this reality while maintaining the necessary checks and balances to ensure fairness and security. Research also shows that recidivism rates for sealing recipients are extremely low. Recidivism rates are drastically lower in states with clean slate policies. Clean slate policies hold strategic value in advancing public safety goals while reducing the strain on an overburdened criminal justice system. Records in Maine will be sealed rather than destroyed and remain available to law enforcement and legitimate purposes, such as background checks when legally required for specific employment, such as childcare. This aspect of the bill acts as a safeguard to ensure safety for the community. The biggest barriers to a person's recovery are related to an inability to get their needs met. When a person is struggling to find housing, with job insecurity, and feed themselves due to stigma related to substance use and other mental health issues that have led them to be system impacted, they are significantly more likely to reoffend. Clean slate legislation would allow a person an opportunity for a fresh start once they have paid their debt for harm they have caused. By continuing to punish a person for the remainder of their life, their chances for recovery and successful reintegration is seriously diminished. Thank you for your time and consideration, and I urge you to vote ought to pass on LD 1911.
Thank you.
Yeah.
Are there any questions, committee members? Seeing none, thank you. The next person who wishes to speak in support, please step forward. And if those who are in the committee room who plan to testify in support, if you have not yet provided your testimony, could you just raise your hand so we have an idea of how? Okay. And then those who are planning to testify in opposition? All right. And then neither for nor against? Okay, just that helps us with timing. Go ahead.
Senator Carney, Representative Kuhn, and distinguished members of the Judiciary Committee. My name is Jan Collins. I am Assistant Director of Maine Prisoner Advocacy Coalition, an organization committed to ethical, positive, and humane changes in Maine's prison system. You have all heard my story before, the experience of my childhood when my father was incarcerated, which actually thrust my family into deep poverty. That poverty didn't go away. I did not achieve even lower middle class status until after I'd gone to college. And that was true for my family members because that record is a stigma. And in our family, it was also meant that my mother became a single parent. That's what's important about today's testimony. We can all see that having someone in your family incarcerated is a terrible burden for the family. But the data that you are receiving momentarily from this report actually studies what the long-term economic effects are for families and for communities, because when a family is not doing well, the whole community suffers from that. If you can picture a community where everyone has housing, everyone has food, and everyone has medical care, that's a kind of soothing picture in my mind of seeing everyone's needs satisfied. When I picture a community where lots of people are unhoused, large numbers of people do not have health care, and many people cannot have their daily needs for food and heat met, that's a totally different picture in my mind. It's a picture that's chaotic. And it's a picture that actually breeds the kinds of things that we try not to have happen in our communities. It's an unsafe community. The billions of dollars that are not part of our economic engine because people cannot get jobs, because they cannot find adequate housing and they can't feed their children, affects all of us. It's not just those families. I hope you will take the time to read over this study and see how many billions of dollars we are losing each year because we choose to punish people for a lifetime instead of for the sentence they were given by the courts. Thank you, and I'm
Thank you for
more
your
than willing
testimony.
to take any questions.
Are there any questions, committee members? Seeing none, thank you.
Thank you.
There is a fire alarm that's gone off in the cross building, which is where the cafeteria is. So I'd like to keep going with the testimony for a few more minutes until at least that situation is clear. So please step forward if you are here to testify in support of this legislation.
My new friend.
Welcome.
Thank you. My name is Pam Moss, and I'm here in support of Maine's Clean Slate legislation. At this stage of my life, sealing my own criminal record would make little difference to me personally. I'm not here out of self-interest, but out of concern for fairness and long-term consequences of a justice system that imposes on people who have already paid their debt to society. Clean slate is not about excusing wrongdoing and eliminating accountability. Accountability is essential to justice, but it must have an endpoint. When individuals have completed their sentence, paid their fines, applied with probation of court-ordered conditions, the punishment should end. Without the endpoint, we impose ongoing informal sentence that was never ordered by a judge. I am currently working on a documentary focused on Maine's Clean Slate Initiative. And through the work, I have listened to people whose lives continued to be shaped by low-level convictions from years or even decades ago. And you've heard those stories today. Again and again, I hear how an old record, often for a misdemeanor or low-level felony, creates barriers to employment, housing, education, and economic stability. These barriers are not applied equally. People with fewer resources, less access to legal counsel, and limited support systems suffer the harshest and long-lasting consequences. This is not only a question of individual fairness, it's a matter of public interest. Stable housing and steady employment are among the strongest predictors of reduced recidivism. Policies that prevent people from working or securing housing after they have completed their sentences do not enhance public safety, they undermine it. Maine benefits when people are able to support themselves, contribute to their communities, and move forward with dignity. Clean slate reflects core Maine values and personal responsibility, fairness, and the belief in second chances. It does not erase the past. It recognizes that people can and do change, and that our laws should not permanently trap individuals in their worst moment. I may not personally benefit from this legislation, but many working age Mainers will. From them, Clean Slate can determine whether they ever receive a fair opportunity to rebuild their lives. I respectfully urge you to support passage of Maine's Clean Slate legislation.
Thank you for your testimony. Committee members, are there any questions? I am not seeing any. Thank you. The next person who wishes to speak in support, please step forward.
Well, good afternoon, Chairs Carney and Kuhn and honorable members of the committee. My name is Ryan Ewing. I'm a campaign strategist with the Clean Slate Initiative and a one-time resident of Brunswick. It's a thrill to be here with you today. The Clean Slate Initiative is a national nonprofit organization that's working across the country and in the Congress to pass and implement laws that automate record sealing for people with eligible records who have remained crime-free. I join you today to ask for your support on LD 1911. As you've heard, currently 271,000 adults in Maine have a past record. That's 1 out of every 4 Mainers. Most of these records are old arrests, non-convictions, or low-level offenses. Even after completing their sentences and remaining crime-free, these constituents are often denied a fair chance at jobs, safe housing, educational opportunities due to these old records. But studies show that when people can access stable jobs, recidivism drops and wages rise, thus strengthening the community. Passing Clean Slate in Maine is a common sense approach to ending this vicious cycle of stigma and exclusion without compromising public safety. 13 states and the District of Columbia, including such diverse places as Utah, Connecticut, Pennsylvania, Oklahoma, have already enacted Clean Slate laws, and the positive impact has been substantial. One of the key advancements in the sealing process is the use of software automation to determine record sealing eligibility. By leveraging technology with human oversight to determine eligibility and grant record relief, states that have passed Clean Slate have successfully streamlined their sealing process, reducing the burden on both the judicial system and the eligible individuals who are seeking record relief. In fact, it was reported to the Criminal Records Review Committee that in the short time Maine has allowed for petition-based sealing, only about 36 petitions had been received at that time, a very low uptake of that process. LD 1911 addresses this by automating and streamlining. Through 1911, Maine has the opportunity to not only join, but also lead in this growing national movement, as Maine is particularly well suited to implement automatic record sealing. Maine operates a centralized court system with the Administrative Office of the Courts managing case data, which means that the process of accessing case information and determining eligibility can be easily streamlined. Also, with Maine's courts currently transitioning to a modern case management system, now is the perfect opportunity to build in clean slate implementation. With centralized systems and automated workflows, Maine is in an optimal position to implement clean slate and serve as a leading example for others on how to deliver record sealing as a public service, all while reducing administrative red tape. If LD 1911 passes, 163,000 Mainers would be eligible to have their records fully sealed. That's 163,000 whose potential could be unlocked through access to secure employment, safe housing, and education. In conclusion, I urge the committee to recognize these benefits and implement clean slate legislation in the state of Maine.
Thank you for your
Thank you.
testimony. Are there any questions, committee members? Seeing none, thank you.
Thank you.
The next person who wishes to speak in support, please step forward. Having heard from everyone who wishes to speak in support, we do actually have some who have signed up online to speak in favor. I think we're going to ask the online people to wait until toward the end of the public hearing so that we can take up those who are present in the committee room. So we'll next move to those who wish to speak in opposition. If you wish to speak in opposition, please step forward. Yes. I just have a question for colleagues. I'm sure that members of the committee all know that our committee rules ask legislators who are non-sponsors to wait until the end of the public hearing to provide testimony. Senator Bibi Center has been waiting with us all day. She has a meeting at 1 p.m. Would it be all right with the committee if we allowed her to provide her supporting testimony now? It's agreeable to all members of the committee. And Senator, thank you so much for your patience. Yes, Representative Henderson.
Thank you, Madam Chair. And I just wanted to state on the record for those who have testified today, it would have taken up too much time to share this with every single person that testified, but I speak for myself. I know many members of the committee on how thankful we are that you came today, that you put yourself out there, you're transparent with your stories. And these matter very much when it comes to us forming public policy. So thank you. Thank you. Thank you.
Thank you. Senator, thank you so much for your patience.
Thank you. Senator Carney, Representative Kuhn, and distinguished members of the Joint Standing Committee on Judiciary. I am Senator Bibi Center. I represent all of Knox County except for Idaho and the town of Washington. I'm here today in support of LD 1911, sponsored by Senator Talbot Ross. As Senate Chair of Criminal Justice and Public Safety Committee, I work to advance policies that strengthen public safety, improve community well-being, and ensure our justice system is fair and effective. LD 1911 meets all these goals. 25% of adult Mainers live with a criminal record in a rural state like Maine, particularly in counties like Knox. This affects nearly every family, employer, and community. Most people with records are not dangerous. They are parents, workers, and neighbors who have completed their sentences, paid their fines, and moved forward. Yet old convictions often remain lifelong barriers to employment and housing. Studies show that people who have access to stable housing and employment after involvement with the justice system are less likely to be rearrested and tend to remain crime-free for longer periods of time. People who can work and live securely are far less likely to reoffend. Public safety for everyone depends on expanding opportunities for stability. LD 1911 limits eligibility for sealing criminal records to those individuals who have remained conviction-free for long periods of time. Serious and violent crimes are excluded. This bill does not erase accountability. It recognizes rehabilitation. This legislation also supports Maine's economy. According to a 2025 Maine Center for Economic Policy report, 10% of Mid-Coast Mainers live below the federal poverty level. Yet many qualified Mainers are excluded from jobs because of old, low-level records that have no connection to the work they seek. Clean slate policies help employers fill open positions, decrease wage disparities, and support a stable workforce. LD 1911 balances accountability with opportunity. It strengthens public safety, supports rural employers, and gives families who have already paid their debt a fair chance to move forward. I urge the committee to vote to ought to pass on LD 1911, and thank you for your time and consideration.
Thank you very much, Senator. Committee members, are there any questions for our colleague? Thank you.
Thank you.
I believe we've heard from everyone who wished to speak in favor who is present. And as an announcement for those who are online and wish to speak in favor, we're going to continue to take those who are here in the committee room, and we will come back to all of the online testimony as soon as we're able to. We're thinking that will be within the next half hour. At this point, would whoever's in the committee room who wishes to speak in opposition, please step forward. Opponents who wish to speak, please step forward. Welcome.
Good afternoon, Senator Carney, Representative Kuhn, members of the committee. My name is Judy Meyer, and here representing the Maine Press Association now this afternoon in opposition to this bill. The Maine Press Association, as you have heard from me before, has consistently opposed bills calling for automatic seal almost entirely on First Amendment grounds. I want to take a moment to acknowledge the pain and trauma we heard this morning. It was real and it was raw, and it is to be contemplated for sure. When the Criminal Records Review Committee was established in the last session, the Maine Press Association had a seat on the committee, and we were tasked with coming forward with a recommendation on sealing criminal records, if there was a recommendation to be had. And during that committee's work, there was great unease about sealing any felony level crimes, including C and B crimes, which are now in the amendment before you. We did not contemplate those higher level crimes. Our discussions were almost entirely relegated to the lower misdemeanor crimes. There was robust debate during those committee meetings. I think we met 7 or 8 times over a period of 2 years surrounding other issues, including whether sealing should be crime specific and not classification specific. And there was some agreement around those issues about very finely tailoring the crimes that could be sealed. But the recommendation that came forward, and it's on page 40 of my testimony from the report that's just being passed around, there was a recommendation to come forward to look at this issue more seriously in terms of sealing the lower misdemeanor crimes, but it is not a standalone recommendation. It was tied to a recommendation on page 40 asking for additional contemplation, additional study, and additional advice on the First Amendment issues. The bill before you also allows for sealing of non-conviction data, which also carries potential constitutional challenges. In 2016, the judicial branch here in Maine began automatically sealing all dismissed court cases, a move that was done without public notice and was challenged by the Maine Press Association, the Association of Broadcasters, ACLU, the Maine Freedom of Information Coalition, and a number of other public access advocates. And based on that challenge, the court quickly reversed itself, acknowledging there were clear constitutional boundaries around automatic seals as a First Amendment violation. There are decades of case law, including in the First Circuit, on First Amendment guarantees that the public has a right to court records and court proceedings. There are centuries of common law as well, upholding the same thing.
I am happy to provide statutory or case law references to that. I didn't want to overwhelm you today. But I also wanted to point out that the records that we have access to now and the historic records that we have access to give us the demographic data that we've talked about today that prove that low-income people, people of color, other underprivileged members of our society are prosecuted at rates that don't match people of more privilege, and we can't lose access to that data. So that, along with the First Amendment concerns, I urge you now that the Criminal Records Review Committee has been reinstated, thankfully, that this go back for further study. Again, we looked at it for 2 years. We did not come to a conclusion. It is a big topic to talk about, but the conversation is real. We are informed, and I can only speak on behalf of myself, but Senator Talbot Ross seems perfectly willing to get ready to get back to work and make this happen. Thank you very much, and I'm happy to answer questions.
Are there questions, committee members? Yes, Representative Lee?
I'm trying to understand, there's two threads in your testimony, and I'm trying to understand sort of your position. You talk about the type of crimes that are sealed in this bill automatically, and then you also sort of generally talk about the issues with sealing and its effect on First Amendment issues. So is it that you're against all sealing, all automatic sealing, or are you just against the sealing of things like C and D crimes?
There's not an easy answer to that question, but in very broad terms, an automatic seal brings into question public access on a large scale. The issue with felony crimes being added to the amendment, I believe just this week, this was not a conversation that came before Criminal Records Review. We did not talk about it, and I'm sure that there were people on that committee who would have wanted to weigh in. And I don't remember the makeup of all the members of the committee. We had a number of lawyers at the table. That's not the same thing as getting legal advice on these questions, and certainly not constitutional legal advice, which is a very precise practice of law. So we didn't go down that road. I think it merits discussion to avoid a challenge in the future, because all that good work then would be laid open.
Additional questions, committee members? Yes, Representative Caruso.
Madam Chair, thank you for your testimony. So your question about the constitutionality of it, yet in the clean slate testimony, they said that there are 13 states as well as DC that have enacted this. Are you familiar with any challenges to those?
There have been challenges to them, and they don't match this exactly. Many of them don't go to the extent that this bill does. Many of them have elements of this, but not this bill in its entirety. And that question came up during Criminal Records Review. We did get the list of states. I think we had, Senator Talbot Ross can correct me if I'm wrong, we did have somebody, an expert, maybe from Pennsylvania, come in via Zoom, of course, and talk to us. But we did not drill down on the machinations of each one of those statutes. They're not all the same.
Thank you.
Additional questions? Before you ask your question, Representative Lee, I have a simple question for you. Would you please join us for the work session?
Absolutely.
Okay.
That was precisely my question.
So I'm sorry that I scooped you. Other questions, committee members? Seeing none, thank you for your
Thank you
service
very
on the
much.
CRC
Thank
as well. Next person who wishes to speak in opposition, please step forward. Welcome.
Thank you. Good afternoon. Senator Carney, Representative Kuhn, and members of the committee. My name is Christina Lunner. I'm the newly appointed Deputy Commissioner of the Department of Professional and Financial Regulation. This is my first testimony, so hang in with me. I've provided full copies of our testimony, but I'll summarize some of the high points. We appreciate the opportunity to share the department's concerns with the LD 1911 as amended. The department is an umbrella regulatory agency that includes the bureaus of insurance, consumer credit protection, and financial institutions, the offices of securities and professional and occupational regulation, and 5 affiliated licensing boards, including the boards of medicine, osteopathic medicine, nursing, optometry, and professional engineers. Collectively, the department's mission is to protect the public health through effective professional licensing, financial regulation, and consumer protection. The department opposes LD 1911 because it would significantly impair the ability of department agencies and affiliated boards to conduct meaningful criminal background checks on individuals seeking licensure or renewal. Maine law provides that a criminal conviction shall not operate as an automatic bar to state licensure. A licensing board may take criminal history into account, but only if the licensing board determines that the applicant has not been sufficiently rehabilitated. The applicant is always given the opportunity to prove rehabilitation. We believe the current discretion afforded licensing boards to determine if an applicant is sufficiently rehabilitated is working well, as evidenced by the overwhelming majority of applicants becoming licensed despite past criminal history. The department recognizes that LD 1911 raises an important policy question: how to balance the goal of providing a fresh start to individuals following criminal convictions against the need to give regulators sufficient discretion to make informed decisions on the relevance of that past conduct to protect the public. I'll go through a few of our top concerns. They include that the LD 1911 calls into question our ability to continue to use national standard applications that facilitate state reciprocity in fields where many licensees hold licenses in many jurisdictions, for example, the Bureau of Insurance and Office of Securities. Number 2, as originally drafted, LD 1911 preserved the existing ability of criminal justice agencies to share confidential criminal history record information with department agencies and boards. However, as amended, the bill would explicitly prohibit criminal justice agencies from giving certain department agencies information. We're concerned about the automatic sealing of certain convictions on the ability to use comprehensive background checks, that it would impact our ability to participate and meet the requirements of multi-state licensing compacts. I recognize I'm over time. I'm scanning. We have concerns with fingerprinting exemption, which we can go into greater detail if you'd like.
Could I just ask you, do you plan to be with us for the work session?
I'd be happy to.
Okay, I feel like maybe the best thing to do is to let us continue to read through your testimony, and then we will reach out to you with follow-up questions so that you can prepare them in advance of the work session. Does that sound?
That
all
sounds
right?
great.
Okay, committee members, are there any questions you wish to ask now? Okay, thank you. And committee members, as you read through this testimony, and I know there's a lot more than could be covered in the 3 minutes, please reach out to Representative Kuhn and I with your questions, or you can send them directly to Eli, and we'll make sure that all of those get forwarded. Thank you. Would the next person who wishes to speak in opposition please step forward? Seeing none, is there anyone who wishes to speak neither for nor against? Welcome.
Good afternoon. Senator Carney, Representative Kuhn, members of the Joint Standing Committee on Judiciary. My name is Julie Finn and I represent the judicial branch, and I would like to provide some brief testimony, neither for nor against LD 1911. Several months ago, as she mentioned, Senator Talbot Ross contacted me and my colleague Amanda Doherty about this bill and requested our feedback. We provided detailed analysis and at her request met with outside advocates and individuals from national clean slate organizations, including Mr. Ewan here, who I've never seen in person. Hello. It is clear that their intent is to make the process as streamlined and technology-based as possible, and for that we are appreciative. To that end, Senator Talbot Ross proposed the amendment that was circulated earlier this week. However, given the pervasive usage of paper files that will continue to some extent until enterprise justice is fully implemented in early 2027. And for cases that predate enterprise justice, there is a limited amount of work that can be accomplished electronically. Specifically, in the proposed legislation, Title 15, Section 2403 requires the judicial branch to electronically compile a list of criminal history record information that meets the requirements of Section 2402. On January 1, 2028, the start date of the automatic reviews, these eligible criminal convictions would include Class D and E crimes 5 years after convictions, Class C crimes 10 years after, Class B crimes 15 years after, and eligible non-convictions. Because of the lag times included in the statute, the dates of conviction would be between 2013 and 2023, and the files would be in paper format, not electronic. The tasks involved would occur roughly in this order. Archived paper files would have to be gathered from multiple storage locations, forwarded to the court of jurisdiction, reviewed by a law clerk for compliance with the statute, forwarded to a judge to issue a sealing order if appropriate, docketed by a court clerk with a copy to the defendant in the file, and finally transmitted to the State Bureau of Identification, or SBI. In addition, there is another section that talks about phased sealing of historical criminal history record information that goes back as far as 2005. And again, I'm not going to repeat myself, but that process would be very paper-based and time-consuming. I've also included in my testimony a specific example of something that would be difficult for us. I'm not going to read through that part, but we are, of course, willing to work with the committee and the senator and others to provide assistance and funding estimates for this bill. Thank you very much for your time.
Thank you for your testimony. Committee members, are there questions for Julie Finn on behalf of the judicial branch? Representative Lee, do you have a question regarding the work session?
Well,
I
shall
feel
be
bad.
you've been asking those, so.
Go ahead.
Will you be here for the work session?
Of course I will. Thank you for asking.
Thank you so much.
Thank
I don't
you.
think there are any questions at this time. Is there anyone else in the committee room who wishes to speak neither for nor against? Welcome.
Thank you. Good afternoon, Senator Carney, Representative Kuhn, and members of the Joint Standing Committee on Judiciary. My name is Sam Zuckerman. I'm the policy coordinator of the Permanent Commission on the Status of Racial, Indigenous, and Tribal Populations. I'm here today to testify neither for nor against LD 1911, an act to automatically seal criminal history record information for certain crimes. The Permanent Commission's Policy Committee broadly supports legislation that would make systemic reforms to Maine's criminal legal system and mitigate collateral consequences for impacted individuals. However, due to the timing of the Permanent Commission's Policy Committee meetings, the members have not had sufficient time to adequately discuss the details on this bill. That said, I can provide relevant information and context about disparate impacts of the criminal legal system on communities of color to help you in your consideration of the bill. Racial disparities in drug-related arrests in Maine are clear and outpace racial disparities in the enforcement of other types of laws. The data shows that Black people use illicit and illegal drugs at similar rates to white people, but they are 3.5 times more likely to be arrested for drug possession and charges as white people who use drugs. Data analyzed by the ACLU shows that in Maine, the racial disparities in marijuana possessions were larger in 2018 than in 2010. In 2010, the arrest rate for Black Mainers for marijuana possession was 2.1 times the rate for white Mainers, while in 2018, this disparity grew to Black Mainers being 4 times more likely to be arrested for marijuana possession. These disproportionate arrest rates then in turn result in disproportionate conviction rates. Indigenous people in Maine are twice as likely as white people to be charged with drug possession and 3 times as likely to be charged with the lowest level of drug possession. Maine's incarcerated population also increased by 163% between 1983 and 2015. This means more Mainers with criminal records struggling to get their lives back on track. A criminal record makes virtually every aspect of day-to-day life more difficult, from finding housing to getting a loan to finding a job to getting an education. A study of 50,000 people released from federal prison in 2010 found that 33% were not able to find any employment for more than 4 years after being released, and that at any given time during those 4 years, no more than 40% of those people were employed. And Maine makes it especially hard for formerly incarcerated people to get back on their feet, ranking 44th out of 50 states for laws restoring rights and opportunities after arrest and conviction. We hope that you will take these disproportionate impacts on Mainers of color into account when considering the bill before you. Thank you for your time and attention. We have further resources on racial disparities in Maine on our website, and I'd be happy to answer any questions.
Thank you very much for your testimony. Committee members, are there additional questions? Yes, Representative Halloran.
Hi, thank you for coming. I have a curiosity question and I might have missed it, but you talked about the percentage differences between white and black on drug offenses, but what about poverty?
Yeah, so those disproportionate impacts are also seen in poverty statistics. I don't have those in front
You
of
don't
me,
have
but
that,
I can
okay.
get you more information about that. I can get you our full report on the state of racial disparities in Maine.
Great, thank you.
Would you be willing to join us for the work session?
Absolutely.
And if you could bring that report as well.
Yeah, and I can even bring, our research specialist if that would be helpful.
Yeah, that would be helpful. Thank you for that offer.
Yeah.
Committee members, are there any additional questions? Thank you.
Thank you very much.
Is there anyone else who wishes to speak, who's appearing in person, who wishes to speak neither for nor against or in any regard on LD 1911? You are here on 1911 and you haven't had a chance to provide testimony, please step forward. I'm not seeing anyone to provide in-person testimony. So at this point, we're going to take a break. We've concluded all but the online testimony. We will resume and conclude the public hearing beginning at 1:20, and that is when we will complete the online testimony. And that, so committee members, please, if you're able to return by 1:20, that would be much appreciated. Thank you, everyone.
Committee members, we're going to continue our public hearing on LD 1911. And we're going to turn to, we're continuing our work. Thank you, though. We're going to turn to testimony from individuals waiting online. If you are participating on Zoom and you would like to testify in support of LD 1911, please raise your electronic hand and leave it raised until you've provided your testimony. Who's first?
It's possible that I'm looking at their computer. Samantha. Samantha.
All right. Samantha Janest, I think you are up first.
Hi.
Welcome.
Thank you.
Please go right ahead.
Okay, thank you. Senator Carney, Representative Kuhn, and distinguished members of the Joint Standing Committee on Judiciary. My name is Samantha Janest. I appreciated the opportunity to share in my experience at the Criminal Record Review Committee, and I'm grateful for the opportunity to share with you today. I am a resident of Portland, Maine, and I am writing in strong support of LD 1911, an act to automatically seal criminal record history information for certain crimes. Like 1 in 4 adults in our state, I live with a past criminal record. I have worked hard to rebuild my life, and I've held steady employment, supported myself, contributed to my family, paid my taxes, went back to college, and I've stayed out of trouble. Yet despite everything I've done to rebuild my life, my path continues to follow me. While I am fortunate that my past legal record is in another state where I will eventually be eligible for expungement, I have still faced the frustration of being turned on by job after job. Once the job is offered and I explain my background and they complete them, I am disqualified regardless of my competence or dedication to the role. These barriers don't just hurt me, they hurt employees and society as a whole. More recently, I was a temporary employee at a company for a year before they offered me employment. I told them about my record and they deliberated for 2 months.
These two others.
Finally deciding they opted to hire me based on my work ethic, but it could have easily gone the other way. In 2022, the legislature created a process to allow people to petition the courts to seal certain misdemeanor records. While the intent was good, the reality is that the system does not work for most Mainers. The petition process is confusing, time-consuming, and intimidating. Many people don't even know they are eligible. Others can't afford an attorney or take time off of work to go to court. The result is that record relief exists on paper, but almost no one can access it. LD 1911 would break down barriers and expand relief for those that have earned second chances. It does not erase records or compromise public safety. Law enforcement and courts would still have access. Only people who have remained conviction-free for many years would qualify, and serious and violent offenses are excluded. I cannot overstate how important obtaining gainful, meaningful employment is to people in recovery from substance use disorder that are working towards building a new life that they will work hard to keep. Maine believes in accountability, hard work, and second chances. LD 1911 reflects those values. I urge you to vote ought to pass. Thank you for your time and consideration. Respectfully submitted, Samantha Janest.
Thank you. Committee members, do you have any questions? I'm not seeing any. Thank you for joining us.
Okay, thank you.
Next, Evan Moody, if you could please activate your camera. Hello, welcome. Please go right ahead.
Hello. So I was just writing, I hadn't finished writing it down, but I'm planning on speaking for incarcerated people in regard to LD 1941, reading their testimonies aloud. And as I listened today, I realized that I
Sir,
also
could you
give my...
please start with your name and where you
Yes.
reside?
My name is Evan Moody. I live in Lincolnville Center, Maine.
Thank you.
Well, I realized I should give my personal testimony in favor of this as well. I was born in Belfast and I've lived in Waldo County my whole life. When I was 23, I was charged with 2 felonies and I'd never been even given a parking ticket or any other crime. I've never committed any crimes before that. Um, and they were theft by deception and unlawful use of public benefits instrument. I have I've lived my life entirely in poverty from when I was born till today, and I've been on food stamps for most of my life. My charges stemmed from the passage of new laws which branded certain people as able-bodied, and I was one of them. Despite my doctors filling out the proper paperwork explaining my mental health diagnoses were disabling, eventually my benefits were taken away. My benefits were on the same EBT card as my father, who I lived with at the time. And my father left the country and my mother left the state. And they both told us they didn't plan on returning. They abandoned my younger siblings who were 18 and 15. And I, considered them to be in my care. I used the card to feed my siblings, my girlfriend, and myself. I took a plea deal, which my court-appointed attorney presented me with from the prosecutor. It reduced the charges to misdemeanors as long as I pled guilty. I believe I was innocent. I was sentenced to 2 concurrent sentences of 30 days at Two Bridges Regional Jail in Wiscasset. I think that the entire process was a series of affronts to my inherent dignity as a human being. These things happen every day in this country, and I think that poor people are really being brutalized by this system. And so this is why I think that what ought to be done is to mitigate as much as possible the harms that are being done to poor people. And it doesn't make it right, but it does help a little bit. So I actually have the paperwork filled out to seal my record, but the cost involved it feels as though I could just be wasting my money. And so I have it filled out, but it's just in the drawer. I haven't done it yet. So thank you for your time and consideration.
Thank you. Any questions, committee members? Oh, all right. Well, thank you for your testimony.
I'm still here, sorry.
Oh, okay. I'm
There's
not seeing any questions, but thank you for staying with us.
Yep.
Next, we have Maggie O'Donnell. If you could activate your camera, please. Hello, welcome.
Hello, thank you. Good afternoon, everyone. My name is Maggie O'Donnell, and I am the Director of Policy and Advocacy at an organization called RBIJ, or the Responsible Business Initiative for Justice. Thank you for the opportunity to testify in support of LD 1911, what I will refer to as Clean Slate Maine. RBIJ, we are a nonprofit that mobilizes businesses to be a force for good. Since our founding, we have worked with hundreds of companies from multinational corporations to entrepreneurs across the country. We advocate for practical policy reforms that expand workforce opportunity and stimulate economic growth. You've heard, but I think I need to restate it again, that the impact of having a criminal record on a person's ability to obtain a job is enormous. 9 in 10 employers use background checks to screen applicants, and having a record reduces the likelihood of getting a call back for a job by nearly 50%. You're almost always at a disadvantage. Companies and their employees understand that impact and understand the impact of automated record sealing. For one, businesses just can't afford to exclude great talent. I have spoken with tons of businesses across the state of Maine, as well as chambers. They all agree they want to fill open jobs. Meanwhile, this outdated petition-based system keeps those people out of jobs. This worsens labor shortages, reduces consumer spending, and shrinks tax revenue. Clean Slate would allow new pipelines of talent to fully participate in society, reducing turnover costs and easing labor shortages. It would also have a huge impact on the state's economy because the U.S. loses more than 80 billion with a B in GDP each year for the underemployment of people with records. And removing those barriers, however, reduces the need for long-term government support and saves tax dollars. Clean Slate would, of course, also reduce recidivism. You've heard, and we all know, that having a job is one of the most important factors about whether or not someone will reoffend. I'll end by reiterating that the business community stands in strong support of Clean Slate in Maine. It's been backed by the Portland Regional Chamber, the Lewis and Auburn Chamber, Strength in LA, Maine Black Chamber, Maine Works, and countless local businesses. It's also been backed by similar organizations and corporations like JP Morgan Chase and the U.S. Chamber of Commerce in similar states across the country. A criminal record just should not be a life sentence to economic hardship. Everyone, regardless of their past, wants the opportunity to work, support their families, and to build a good and stable life. I urge you to vote in favor of LD 1911 and support this important and economically sound bill. Thank you for your time.
Thank you. Committee members, are there questions? Yes, Representative Lee.
Thank you, and thank you for your testimony. There's no universal background check that businesses use for folks' criminal records. And so I've heard anecdotally that even those instances in which records have been sealed, there are some background checks, because obviously the original, crime, the original charge may have been recorded in a newspaper, and some of the systems incorporate that. Can you tell me experientially, is there still the risk that sealing is not effective for those folks who are trying to get a job and are getting background checked?
Yeah, thank you for the question. It's a great one. Great question. And happy to sort of contribute more via written testimony if that's useful. I mean, the honest answer is that clean slate is the right step. It's in the right direction. There will always be problems. I mean, the internet exists, right? There will always be problems beyond record sealing, but we believe very strongly and have seen from other states that have passed clean slate that by passing clean slate, you take a huge step in the ability for people to actually run through that hurdle essentially and move past it. So we think it's a step in the right direction. It's never going to be perfect, right? But that shouldn't be the enemy of the good. And certainly the internet exists, but we have seen that implementing clean slate is, again, one step in the right direction.
Just follow up. Yep.
It also seems to me, and I'm wondering if you have experience with this, is that in those instances where a background check picks up a past conviction, the ability of the employee to say, hey, that's a sealed record now. Have you experienced that that's also helpful for that employee in that situation?
Yeah, I'll be really honest. The impact of when, the impact of how often this happens is actually quite small in terms of, when this is actually caught up in the system. If your record was sealed, it shouldn't be showing up for an employer on a background check. And so, occasionally there'll be instances, but it should not be the vast majority of instances, but it should help individuals regardless. Yeah.
Thank you for your testimony.
Thank you.
Next, we have Kelly Merrill. Kelly, if you could please activate your camera. Hello, welcome.
Hi. Good afternoon, Chair Senator Carney, Representative Kuhn, and distinguished members of the Joint Standing Committee on the Judiciary. Thank you for the opportunity to testify in support of LD 1911, the Clean Slate Act. My name is Kelly Merrill, and I live in Stratton, Maine. I'm here today in my capacity of the co-chair of the Maine Green Independent Party, representing 37,000 members in our state. 25% of Mainers have a criminal record. That record continues to punish people long after they've completed their sentence, creating permanent barriers to education, jobs, and housing. And though there is some form of record relief, it is largely inaccessible to most people, creating a two-tiered system of justice, creating unjust inequities. And as bill sponsor Senator Talbot Ross said earlier, half of criminal cases result in non-conviction, but still appear on one's record. This is an issue of restorative justice, and it is an issue of racial justice. For example, Black people in Maine are incarcerated at a rate of over 9 times higher than white people. Automating record relief will help reduce this shameful disparity. The Clean Slate Act would provide relief to an estimated 163,000 Mainers, enabling them to achieve more stability and security in a hostile world. Data shows that average quarterly wages rise about 23% within a year of record sealing. And I'd like to put this into some context. We are living in a time when people, everyday people, are getting squeezed in every part of their lives. There is an astonishing rise of people who are living on the edge or who have fallen off the edge of poverty, the edge of homelessness, the edge of despair. People struggle to earn enough to live. It's often not enough to retain housing, not enough to feed or clothe their kids, not enough for medical care, not enough to survive. A 23% increase in earnings could have a significant impact on people's lives. Sealing records will also free people from re-experiencing the shame of their mistakes and the weight of that anchor that punishes them over and over and over again. We respectfully urge this committee to vote LD 1911 ought to pass and join the 13 other states plus the District of Columbia in providing Mainers with much needed record relief. Thank you so much.
Thank you. Committee members, any questions? Not seeing any. Thank you for joining us.
Great, thank you.
Next, we have Brandon Brown. If you could please activate your camera.
Hello, I'm Brandon Brown.
Oh,
I didn't want to interrupt and say that I was here in person.
thank you for joining us.
Yes, thank you for making time.
1 second.
Oh, sorry about that.
Thank you,
Um,
Representative Sato.
My name is Brandon Brown. I live in Bethel, Maine, and I want to thank you for letting me come in person, even though I was late to the party. I'm here to testify in favor of LD 1911, what we call the clean slate legislation. And you've heard from dozens and dozens of people today. So I'm not going to retell the stories that you've told. I'm a justice impacted person, somebody who has to click that box that, yes, I have a felony on my record and I spent a significant amount of time in prison and I have to be victim to all of the consequences that will follow me for the rest of my life as a result of that. But what I want to tell you today is really a question. In light of everything that you've heard, nobody has asked the question, what will happen if we don't pass this bill? We've heard about the effects of criminal records, especially misdemeanor records and lower level felony records that are included in the legislation. We've heard the stories of people who have been discriminated in housing and employment. We've heard the stories of people's children who have suffered from mistakes that they made when they were young people. But what we haven't heard is what will happen if we don't pass this legislation. And what will happen is that Maine will continue down this path that we're on of being one of the worst states in the country when it comes to our criminal legal system. We don't have parole. You'll be hearing about that bill later. We are the 6th worst state when it comes to racial disparities. We're the worst sentencing state. We're riddled with problems when it comes to our criminal legal system. And we're also one of the epicenters for the opiate crisis. And you heard from a lot of recovery advocates who spoke about that today. So what I pose to you is just a simple question. Why not pass this bill? What will happen if we pass the bill that will be bad? I don't see it. I don't see the ramifications of not passing this bill. I don't see any worse off that we could possibly be than where we are today. When people join the workforce, when people have stable housing, when people have access to education, it gives them hope. And what our state is devoid of, especially in our criminal legal system more than anything today, is hope. We have no hope when you get sentenced. We have no hope of ever shaking off the stigma that comes with crime. And we have a severe misunderstanding of what structural factors lead to crime. So I ask you to vote ought to pass on this bill because there's really no reason not to. It can't get worse than it is, but it can get a lot better. And if not for me, if not for my constituents and my colleagues, if not for the hundreds of thousands of people in Maine that this will positively affect, I ask you to do it for our children because my daughter doesn't deserve to have a harder life because of the mistakes I made as a young man. Thank you very much.
Thank you.
I know. Shh.
Committee members, any questions?
Thank you for your
Not any.
time.
Thank you. And thank you for bringing that special guest with you. All right, we're going to resume our online testimony. Next, we have Doug Dunbar. If you could please activate your camera. Welcome. Please go right ahead.
Hi there. Thank you all. It's difficult to follow Brandon. I've known him for a while. You've heard compelling stories. You've heard from much smarter people than me, like Peter Lehman, who I can see is spending another long day in the committee room. My name is Doug Dunbar. I live in Herman outside of Bangor. And I often tell people I had a life before going to jail and becoming a criminal and becoming a felon. And I have a life afterwards. The life I had before was something you will be familiar with. I spent 10 years at the Department of Professional and Financial Regulation as the Legislative and Media Affairs Director. I was former Governor John Baldacci's press secretary. I was his communications director for 8 years in Washington. I worked for George Mitchell. I was Maine's chief deputy secretary of state. For many of those years, beginning on 9/11, when the terrorist attacks occurred and I lived near the Pentagon and my lifelong OCD spiraled out of control and I began self-medicating, for a lot of those years when I was in government in Augusta, sitting in those committee rooms, I was drinking myself to death and I was driving drunk every day. And eventually, my alcohol use disorder, led to those bad choices and then led to legal consequences. On my sixth arrest, I went to jail for 136 days, 4.5 months. And I mean this sincerely. You all should go to jail. And people laugh, but I don't mean it in a silly way. I tell people I have two great regrets in life. One, that I drove drunk hundreds and hundreds of times, put all of your lives in danger potentially. Number two, that I spent 30 years in government not realizing how we punish endlessly, lifelong punishment, particularly of the poor and the ill. I was not a bad person. I was a good person, but I was a sick person. And when I went to jail, it opened my eyes to how government and society punishes people who are primarily sick and poor. And we do that in a lifelong fashion. When I got out of jail, I was fortunate to become a recovery and reentry workforce development specialist at Eastern Maine Development Corporation in Bangor. And I spent years, unfortunately, telling people, you know what? I know you want to be X, Y, or Z in the workforce, but it'll be almost impossible for you because background checks will be run. And I know in some cases you weren't even convicted. You were not even convicted. You were innocent. But you're going to have a hard time working in that field. And that is wrong. And if you don't see it as wrong, come talk to me. I'll talk to you anytime. We punish people who are sick and poor. Those are the people who end up in our jails. And I'm proud in a way that I went to jail because I know things and have experienced things that you don't. So
Sir,
listen.
thank you for your testimony. I know you can't see the clock where you are, but if you could wrap up your testimony in a sentence or two.
I just say, listen to the people with the lived experience. We need to stop punishing people endlessly. People primarily who are sick and poor. Thank you.
Thank you for your testimony. Are there questions, committee members? All right, not seeing any. Thank you. Next, we have Patrick Pertil. If you're there, Patrick, could you please go right ahead.
Thank you. Thank you for the opportunity to speak to you today about the benefits of sealing low-level criminal records. My name is Patrick Pertil. I'm coming from Washington, D.C. I'm not a Mainer, so thank you for your hospitality in having me. I'm the Executive Vice President and General Counsel of Unify.us, which is a nonprofit organization that brings together faith-driven and economic conservatives with the goal of finding common sense solutions to some of today's pressing problems. I'm mostly here today because I've spent a good deal of my career in criminal justice. As Special Assistant to the Deputy Attorney General at the U.S. Department of Justice, I served on the Attorney General's Prisoner Reentry Working Group, President Bush's Prisoner Reentry Initiative, as well as the Strategic Management Council's Subcommittee on Violent Crime and Gangs. I've also served in the Office of the U.S. Attorney for the District of South Carolina and as a clerk to a federal judge. I want to thank you for considering LD 1911. In our opinion, this legislation will reduce recidivism, increase employment, strengthen families and communities, and provide a pathway to redemption for those who have demonstrated that they want to reform their lives. Essentially everything that you've heard today already. I will say that we strongly believe that crime should be punished, but that punishment should not last forever. Those who have paid their debt to society for low-level or nonviolent offenses and who've reformed their lives deserve to be given a second chance and fully welcomed back into society. We have to remember that at the end of the day, rehabilitation is the final goal of the criminal justice system, and we want offenders to pay their debts and amend their lives. Those who do should be recognized for doing it and restored to society. And record sealing promotes public safety, in our opinion, by increasing and improving employment opportunities for people with criminal records. Meaningful work is the surest route to successful reentry, supporting your family, and remaining law-abiding. There are a few things about this legislation that we particularly like. I really like the automation feature because I think that it preserves valuable judicial resources for actually moving backlogged caseloads forward and frankly focusing on people who are a current threat to the community rather than folks who are coming there to petition to have records sealed because they've remained crime-free. Automating that for low-level offenses just makes sense to us. We also like the fact that LD 1911 requires that people must demonstrate their rehabilitation by remaining crime-free for 5 to 15 years based on the nature of their conviction. This requirement ensures that record sealing is not a gift, but it's a recognition of the fact that the person has complied with all aspects of their sentence and/or period of supervision, and they've successfully reintegrated into society. Also, I think it's very important, I think the previous speaker mentioned this, LD 1911 would seal records of persons who were arrested but never convicted or even acquitted. In the modern world where job applicants are screened by algorithms and not by people, someone who has never been convicted or was even acquitted of a crime should not be screened out of job opportunities by having to disclose this information. Finally, we strongly support the fact that law enforcement still has eyes on all of these records, as does the court system. This bill simply limits the public disclosure of low-level convictions after a long period of law-abidingness, which demonstrates rehabilitation. So we
Sir,
just
if you
think-
could wrap up your testimony in just a sentence. Thank you.
I think I'm done. Thank you so much for considering this, and if there's anything that we can do to help you, let us know.
Appreciate that. Committee members, are there any questions? Not seeing any. Thank you for your testimony. Patrick Pertil, Unify US. Next, we have Lisa Parisi. If you could please activate your camera. All right, is there anyone online who would like to testify in support of this legislation? Please raise your electronic hand and leave it raised. Okay. Lisa Parisi, I believe you're next. If you could activate your camera. Okay. Lisa Parisi, if you would like to testify, you have to accept the prompt that's being sent to you. All right. If there is anyone online who would like to testify in opposition to this legislation, please raise your electronic hand and leave it raised. All right, there's no one left online to testify. So we're going to close the public hearing on LD 1911. Thank you, everyone, for your participation. We're going to start the public hearing in 1941 in just a few minutes. I know there are folks in overflow rooms. We do have some space available here in the committee room. So if particularly folks in support could make their way here, that would be great. And if you were here just to testify on the prior bill, if you could please leave the room and make space for others who are coming for the second bill, that would be appreciated. We'll just give it a minute.
You don't have a sign in? Thank you.
Welcome, everyone. We will now be opening the public hearing on LD 1941, an act to implement recommendations of the commission to examine reestablishing parole. First, we'll welcome the bill's sponsor to the podium, Representative Milliken.
Thank you. Good afternoon, Representative Kuhn and esteemed colleagues on the Joint Standing Committee on the Judiciary. It's very nice to see you all. Happy New Year. My name is Nina Milliken, and I'm honored to represent the people of Blue Hill, Brooksville, Castine, Sedgwick, Surrey, and Trenton in the Maine House. I'm also very happy to be here before you today to present my bill, LD 1941, an act to implement the recommendations of the Commission to examine reestablishing parole. I'd also like to take a quick moment to say good afternoon to the men and women who are confined to Maine's prisons. I understand that this hearing is being live broadcast at each of the prisons in Maine that requested access. Many men and women in our prisons took their time to write testimony in support of this bill, and I appreciate their efforts. And I hope that the members will take time to read their words. I believe some of them will be read today in this hearing as well. If prisons made us safer, the United States would be the safest place on earth. We're not even close. The so-called land of the free has the largest incarcerated population in the entire world, larger than any other nation and larger than many nations combined. And Maine, unfortunately, has not been immune from this national failure. In 1976, Maine became the very first state in the country to abolish parole. 16 others followed suit. The result has been entirely predictable. Sentences ballooned by roughly 20%, and Maine became one of the harshest sentencing states in the country, already addicted to incarceration. These facts have consequences. Since parole was abolished, Maine's prison population has tripled. The men and women in our custody are getting older, they are sicker, their medical needs are more acute and far more expensive. All of this comes at an enormous cost to the Maine taxpayer. But beyond the dollars, it reveals something deeper and more troubling, that as a state, we have built a system that no longer believes in redemption and rehabilitation or, frankly, in corrections at all. Several months ago, I stood in the chapel of the Maine State Prison and I listened to a group of men who spoke about what parole would mean if it was to be restored here in Maine. One man, likely in his mid-70s and confined to a wheelchair, told us about a counseling group that he had participated in the prison in the mid-90s. At the time, then Warden Martin Magnuson, not to be consumed with Matt Magnuson, who is his son, who went on to be warden of Maine State Prison more recently, met with the group and told this man directly that he supported parole and that he believed that this man would be a good candidate for a release. By then, the man had already spent years in prison. I want you to sit with that for just a moment. I was standing in the chapel at Maine State Prison in 2025. In 1995-ish, this man was told by the warden at Maine State Prison that he believed that he had been rehabilitated and could safely return to community. 30 years later, he's still there, confined to a wheelchair, and he will almost certainly die there. Bill Clinton was president when he was told that he was ready to go home. 9/11 hadn't happened yet. I was 7 years old. If this man had been healthy that entire time, the state of Maine has likely spent $3.6 million incarcerating him since he was deemed rehabilitated. Given his age and his obvious medical needs, I suspect that the true cost of incarcerating this gentleman was much higher. And to what end? What public safety benefit do we gain from keeping him there? He told us there were nearly 10 men in that group. Almost all of them had been told the same thing by Warden Magnuson, that he would trust them in his community. Some were eventually released successfully. The rest had died in prison. He was the only one left. Millions and millions of dollars spent, lives wasted, families broken apart. And for what?
This committee knows better than anyone else of the state of Maine's indigent legal defense system, indigent criminal defense system. And that crisis has existed for years, and the real world consequences are devastating. There are people in our prisons today who are simply there because they were too poor to hire or afford effective counsel. I was recently told by a man at Mountain View Correctional Facility that he had pleaded guilty to crimes he did not commit just to get out of jail. He sat for weeks or months without consistent access to a defense attorney. Prosecutors would offer him deals, plead to a lesser charge, get time served, and go home. So he did, again and again. Not because he was guilty of the crimes, but because he was trapped. That should horrify everyone. Last year, this committee made an important and thoughtful change to sentencing law by requiring judges to consider a defendant's age. That was the right thing to do, and I thank you all for that decision. This committee has made many such decisions over the years as our understanding of justice has evolved. But here's the problem. When we change our understanding of justice, we don't look back. People remain incarcerated under standards that we all now openly acknowledge were unjust. I recently spoke with a prosecutor who told me that if certain defendants were sentenced today for the same conduct, they would never receive the sentences that they are currently serving in our prisons. That honesty is so appreciated, but it offers no relief to the men and women who are languishing behind bars. That's not justice. It is unconscionable to know that we are keeping people in prison who do not need to be there. When you really sit with what that means, your heart will break. We keep dying men from their families. We keep sons from their mothers, and we keep mothers from their children. At the Women's Center in Windham, nearly every woman is herself a survivor of abuse. Many committed the acts that brought them there while being abused by the men in their lives. Some are incarcerated for harming the men that hurt them. Parole does not guarantee release. It guarantees review. It provides a mechanism for accountability, for mercy, for wisdom, informed by time and growth. And it restores incentive for rehabilitation and meaning to the word corrections. The bill asks us to believe again in people, in change, and in justice that isn't frozen in a moment in time. A couple things before I wrap up. I asked your amazing analysts to draft a big amendment for me to try to meet some of the needs that were articulated by the Maine Coalition to End Domestic Violence. After they came in here in November, we had a quick hearing in November in here on this bill. I'm sure you recall that. I appreciate Mr. Murphy's quick turnaround during a very busy and chaotic season. I was very sick over the Christmas holiday, and I missed a couple of things in that amendment. Totally my mistake. So just a few things that were not in the amendment that I would hope the committee could rectify in an amendment. One is in the part of the bill about revocation, there's currently listed a clear and convincing evidence standard. I think that should be up to a preponderance of the evidence standard. Number two, parole should be able to be revoked for technical violations, though I believe the least restrictive measure should be taken. That language is in the bill also. And then currently the bill indicates that a third of the sentence would need to be served before a person could apply for parole. I think that should be increased to half or 20 years, whichever comes first. So someone doing a life sentence should serve 20 years before they would be eligible for parole. That said, I urge this committee to support restoring parole in Maine. Please vote in support of LD 1941. I appreciate your time. I will do my best to answer any questions that you might have. And I know you guys have had a busy day and I appreciate you all so much. So thank you.
Thank you, Representative Milliken. Committee members, are there questions for the bill sponsor, Representative Lee?
As reasonably as possible, can you email us those changes to the amendment?
Yes, I'd be happy to.
They're also in the test. They're described in the testimony.
I described them in the testimony. That's in my testimony. There are a couple others too that might be coming from other testimony, but anyways, I'm really grateful to your analyst I know all of the nonpartisan staff work very hard over the holiday season, and I'm really grateful for all their work. So
maybe for the work session, we could get it all possible amendments in one.
I'd be very
document
happy.
would be
I will try to actually get
helpful.
that to you before the work session. So
Great.
Yeah.
Any other questions, committee members? Okay, not seeing any. Thank you.
Oh, easy. Thank you.
Are there any co-sponsors, legislators who are co-sponsors here in the room like to testify? Not seeing any. So we will move to members of the public who are here to testify in support of this bill. I would note we are going to be running a 3-minute clock, just so that folks are aware. Try to limit your testimony to that time period if you're able, and there may be follow-up questions for you.
Thank
So,
you.
welcome.
Thank you. Dear esteemed members of the Judiciary Committee, I'm here in strong support of LD 1941, an act to implement recommendations of the Commission to examine reestablishing parole. My name is Catherine Besteman. I'm professor of anthropology at Colby College, a co-founder of Healing First, which is a survivors collective, a member of the Maine Restorative Justice Coalition, the coordinator of Freedom and Captivity, and a proud board member of Reentry Sisters. I was also deeply involved with the 2023 founding of Parole for Maine and have published about Maine's criminal legal system in the Maine Law Review. As I testified in 2023, Maine ranks near the bottom in many measurements of the success and fiscal responsibility of our criminal legal system. We are at the bottom nationwide with our approach to harsh, lengthy, and non-reducible sentences. 34 other states have parole, and all other states except Maine, including those that do not have parole, have established legal pathways to reduce sentences and provide for early release through resentencing units and robust executive clemency. These pathways are designed to recognize rehabilitation, the problem of unnecessarily extreme sentences, long sentences given to young adults, compassionate release, and the exorbitant cost to taxpayers of keeping people in prison who do not need to be there. Maine is the only state in the country with none of these. We do allow executive clemency, but since 1976's criminal code revision, it hasn't been used to recognize rehabilitation or release on geriatric grounds. We owe it to our taxpayers to do better. In 2023, I offered testimony before the Parole Commission that was based in facts and figures about the comparative success of parole relative to straight release, the fantastic cost savings afforded by parole, and the need to correct the failures of the 1975 criminal code reform in Maine that eradicated parole, as as Nina said, Representative Milliken said, increased the length of sentences by half, expanded the number of things for which people could go to prison, lifted the cap on sentences for young adults, and increased the rate of incarceration by 90% in just over a decade. These facts and figures are an embarrassment to Maine, an abdication of our responsibility to taxpayers, and based in outdated, dangerous myths about the necessity of long prison sentences for ensuring public safety. We're often told that survivors want harsh punishments for those who have harmed them, including long sentences, life sentences, and truth in sentencing. We're told that such forms of retribution will make us feel safer, healed. As a survivor of different forms of harm and co-founder of Healing First, I can tell you that survivors want a lot of things from our criminal legal system that we do not get, and that enacting punitive, vengeful forms of harm on people who have caused harm does not, in fact, lead to healing for anyone. National survivors organizations are clear that our current system is not working for survivors and is, in fact, costing huge amounts of money while causing more harm. Thank you.
Thank you. Committee members, are there any questions? Nothing. That's okay. Thank you.
Hello again.
Welcome.
I'm Linda Small of Reentry Sisters. I've uploaded my own testimony, but this afternoon I am reading the testimony of someone else, and I have the copies right here. Senator Carney, Representative Kuhn, and distinguished members of the Judiciary Committee, I am reading testimony from Ms. Darlene George in favor of LD 1941. My name is Darlene George, and I am writing today because the parole system has shaped my life in ways that statistics and policy language can't capture. I am currently incarcerated in Maine. I also am a college graduate, a programs coordinator, and someone who works daily to support the education and growth among our women who are incarcerated. Yet despite the work I have done and will continue to do, I live with the reality that change alone does not guarantee a meaningful opportunity for release. During my incarceration, I have witnessed 2 older women leave this earth while still in custody. Their deaths left a gaping hole in my heart. These women who carried wisdom, regret, love, and hope. Yet they never had a chance to be seen again as who they have become. I often ask myself, what if it were me? What if my growth, my accountability, and my humanity are never given a chance to matter? Without parole, time becomes something we serve until it runs out, sometimes until life itself runs out. Families lose mothers and grandmothers. What has been lost cannot be restored. But what's still at stake is whether our justice system allows room for redemption before it's too late. I am reminded that the 13th Amendment was meant to end systems that reduce human beings to something less than fully human. Yet when people are denied any meaningful opportunity for review, no matter how much they grow, age, or change, it can feel as though we are serving time without recognition of our humanity. Parole does not erase accountability. It affirms that people are more than the worst thing that they have ever done. Please support LD 1941 to help ensure people who have demonstrated growth are given a meaningful opportunity for parole review. Thank you, Ms. Darlene George.
Thank you. And since you are reading for someone else, we won't ask for questions at this time. Thank you. Welcome.
Good afternoon, Chair Carney, Chair Kuhn, and the honorable members of the Committee on the Judiciary. My name is Dean Rikerson of Kittery. I'm here to testify in favor of LD 1941. One outstanding quality of humanity is our ability to change. If we expect a person will remain the same, there's a good chance that those expectations will be met. If we aim for hope in life, a positive outcome is much more likely. So why do we keep wrongdoers in a training ground for criminal activity? Why do we segregate them from the society we hope they can return to? Our system of justice emphasizing punishment instead of rehabilitation is outdated. I understand that victims also have rights to rectify the wrongs that they have experienced, and there are so many wrongs in society that do need to be settled. But there is an emerging system of reconciliation that has been tried worldwide and is very successful. I met a man in Nicaragua whose wife had been tortured and killed in front of his eyes by the military junta. Through reconciliation, he was able to move on, understand, and still filled with pain, but anger not consuming his life. I am sure you will be shown that this bill makes sense for our budgets and communities, but I have seen so many bills that make sense fail to pass the main legislature. I will ask that every committee member think, have you ever made a mistake? What is the best way to learn from your mistakes? I urge this committee to follow the recommendations of the commission and vote ought to pass on LD 1941. Let's join the many other states that recognize that people can change and that our communities are safer when we support that change. Thank you for your time, for your service to the people of Maine, and I'm happy to answer any questions.
Thank you. Committee members, are there any questions? Not seeing any. Thank you.
Senator Carney, Representative Kuhn, distinguished members of the Judiciary Committee. My name is Peter Lehman, live in Thomaston. For me, this this work in the legislature and reentry is a ministry. This is a deeply personal and spiritual enterprise for me. I'm offering myself as an example when I do this work of redemptive potential, that I'm not the worst thing that I ever did. I'm an illustration of how people can grow and change. And I think that it's important that we all see that. The issue in parole for me comes down to whether you believe in justice as vengeance or as redemptive opportunity, whether you believe in punishment as the goal of justice or believe, as I do, that punishment is a mechanism and opportunity for change and growth. Parole is not for everyone. Parole is for those who take advantage of the opportunities to learn and grow and become better people. Parole is for those who have done the work of recovery and redemption. I've advocated for there to be peer support in the Department of Corrections. These would be experienced residents who meet with new residents as they come to the prison and ask them or challenge them, how are you going to take advantage of this time? When I was in prison, I met some men who scared the hell out of me, who I never want to see again. I also met some of the best men, and you know some of them. I also met some of the best men that I've ever known, men whose light and example lit up the place and inspired others. Those are the men who have taken advantage of this opportunity to grow and change. Parole is not a way of rewarding them. It's a way of rewarding us. It's a way of rewarding us by having these such amazing people, in our communities to contribute their skills, their growth, and their industry, and their faith, and their courage, and their taxes. Parole's the right thing to do. It's the effective thing to do. Parole is not being soft on crime. Parole does not increase crime. Abolishing parole was dumb on crime. And I enclose a graph that you can look at yourself to refute the notion that somehow or other parole increases crime and that abolition of parole decreased crime. That's simply not true. It's simply not true. In fact, just
Can
the
I ask you to
opposite.
please
Yes.
summarize in just a sentence?
Thank you so much, and I appreciate all of you.
Thank you. Committee members, are there any questions? Not seeing any. Thank you for your testimony.
Good afternoon, Chairperson Carney and Kuhn, and other distinguished members of the Judiciary Committee. Thank you for the opportunity to speak on a bill that I'm very passionate about seeing passed, LD 1941. My name is Kelly Taylor, and I live in South Thomaston. I'm a social studies teacher at Oceanside High School, and I have for nearly 40 years taught all social studies subject areas in grades 7 through 12. So today I want to speak to you from the point of view of a government history and law teacher whose students write legislative documents, hold committee hearings, and debate the pros and cons of their bills. And I ask, what makes a good bill? In the words of former President Obama, quote, a good compromise, a good piece of legislation is like a good sentence or a good piece of music. Everybody can recognize it. They say, it works. It makes sense, end quote. Reestablishing parole in Maine does make sense. In a government system where both the preambles to the U.S. and the Maine constitutions list as a primary goal of government to establish justice, not having an active parole board does not make sense, nor does it establish justice. The justice system's use of a parole board is a check and balance against injustice and against one branch of government, such as an executive branch, having too much absolute power over such matters as reprieves, commutations, and pardons, or a judicial system which hands out sentences of extreme and unwieldy lengths. A parole board would allow more voices to be heard, especially those voices who are the incarcerated members of our society and who want to become productive members of society after having served lengthy amounts of time in the carceral system. Today's world of restorative justice practices, incarcerated men and women are looking for ways that they can be restored, rehabilitated, and are eager to exercise what they've learned. Over the last 9 years, I've been a frequent visitor to events at Maine State Prison. I have observed how many men are actively involved in making the world they live in a better place through access to higher education, through hospice volunteering, through mentoring and tutoring others, and through sharing with others their hopes and dreams for the future. Reestablishing parole in Maine is the right thing to do. Our prisons are overcrowded, services are limited, and lengthy incarcerations are very costly. Parole originally was established in the justice system as judges knew that some people are rehabilitated slower than others, or sooner than others, excuse me. Maine was the first state to establish a parole system in 1913, I believe, allowing for release after serving up to half the sentence, and after 30 years for a life sentence. Then, as you know, in 1976, Maine got tough on crime and eliminated parole for Mainers. Through structured supervision, parole is a positive public safety issue, unlike unsupervised release after a full sentence is served. Then there are the economic benefits and the exploding costs of incarceration. Finally, reunifying families is a humane thing to do. As Governor Mills said in her second inaugural address, quote, "Hope is not an easy thing. It's not a mere wishful thinking. It's not just trying to do what we did yesterday in the same old ways. It challenges and changes the way we do things. It calls on us to advance and adapt while preserving who we are as a people and all the values we hold dear. Therefore, I respectfully submit and share my hope for change. Please reinstate parole in Maine because as human beings, we all deserve hope for the future. I strongly urge this bill ought to pass. Thank you.
Thank you. If you'll just pause one moment. Are there any questions, committee members? Okay, not seeing any. Thank you.
Hello, everyone. Senator Kearney, Representative Kuhn, honorable members of the Joint Standing Committee on Judiciary. My name is Scott Martin, and I live in Bar Harbor, and I support the bill that we're speaking of today. I stand before you today as my last day on supervision community confinement program. Today is my last day of home confinement, and it's yeah. So I'm very nervous, but I'm really honored to be here. I entered the prison system full of fear and an active addiction, having had 10 years of sobriety before relapsing, which led me to making choices that had consequences, like a 5-year prison sentence. I made a choice to have my experience be one of not going to prison, but one of going to an ashram. First would be surviving the experience and not doing any work to change my life, basically watching TV and playing cards. The other would be taking advantage of the time and doing the work so that I could become a better man and to be of service to fellows. I time myself outside and I got 3.5 minutes by when I cut this in half. So I will spare you and do the short version. It became very clear quite quickly that there were two basic types of residents. One that had a history of being institutionalized, of being in a revolving door, in and out of prison, with no plans to change this time. Then there were others who wanted to better themselves. That could be done in a number of ways, going to the gym, to church, to the classroom, to self-help groups, and 12-step programs. Before coming in, I had the belief that if you did the crime, you do the time. And after seeing the crime play out in the news cycle, I would never give that matter much thought again. Now these men were becoming my cellmates, my co-workers, fellows I was getting vulnerable with in support groups. So yes, it was unnerving to discover that this man I had been getting friendly with or working alongside with, or closing my eyes and sleeping next to had murdered someone. It was a huge opportunity for me to see how fast I judged people and held them in their worst mistakes. It had me reading the St. Francis prayer carefully and repeatedly. As I was trying to find my place and routine in prison, I noticed a young man who seemed to be everywhere. Every corner I turned around in the education department, every self-help group, there he was, and most of the time being of service. I became friends with John, and he guided me in my position as a prison recovery facilitator, of which there was 3 of us, and he was our go-to for any problems and issues. To walk from one area of the prison to another with John was a constant stop and go. You could not get 20 feet without someone stopping him and asking for help. He was
Excuse
gracious
me,
and humble.
I'm sorry to interrupt.
Yes.
Your time is up. Could I ask you to stop to finish up your testimony in just a couple of sentences?
Sure. I was known as the butterfly guy in prison. I released butterflies and I worked with these guys. And the last night I left, I said I wouldn't forget them and I would do my part to help. And here I am today. I hope you hear everybody's testimony with open heart. Thank you.
Thank you for your testimony.
Good afternoon. Senator Carney, Representative Kuhn, and honorable members of the Joint Standing Committee on Judiciary. My name is Martha Farley. I live in Bar Harbor, and I'm reading testimony written by an incarcerated person in support of LD 1941, an act to implement recommendations of the Commission to examine reestablishing parole. My name is John Oakey, and I'm a resident at Mountain View Correctional Facility. I have been incarcerated for 18 years and have 33 years left on my sentence. During this time, I have seen a change in the system and a change in myself. At 21 years old, I was sentenced to the Maine State Prison with 2 30-year consecutive sentences. The first few years of prison life were what most would expect. There were fights, time in the hole, drug use. There was hate, anger, and debauchery. And there was also severe depression, guilt, and shame. Then, in 2012, the MDOC began to introduce rehabilitative programs. I took one program, then another, and another. I started meeting regularly with a mental health counselor who encouraged me to journal. I began to reflect on the interplay between thoughts and emotions, what causes them, and how they affect me and my approach to the world around me. I began experiencing space between emotions and actions, and I practiced responding rather than reacting. I didn't realize it at the time, but I was growing. I started taking care of my physical and mental health, went to recovery meetings, and became a recovery coach and peer facilitator. Fear of losing what I gained pushed me to attend college while incarcerated. I wanted something different for myself. I hate the person I was. I've changed all of who I am, and I'm proud of the person I've become. I'm now a college student with a 3.98 GPA, but more importantly, I've grasped something I was missing all those years ago: purpose and meaning. If I were afforded the opportunity of parole, I would continue on this path because I know the purpose and meaningfulness of the experiences I'm involved in. I would continue with my college education and recovery coaching, maybe start a small business and continue to use the tools that have helped me cope over the past 18 years. Because of the time I've spent incarcerated, I have a different outlook and appreciation for life. I strive to be a force that is greater than the 18 years I've spent locked behind prison walls. Parole would provide an opportunity for applied growth and atonement, an opportunity to make up for the pain and suffering I've caused. If given the chance of parole, I would do my best to make up for the choices I made. I would live as a changed man in remembrance, respect, and honor of the hurt I once caused. Thank you, John Oakey, Charleston, Maine.
Thank you.
Senator Carney, Representative Kuhn, and honorable members of the Joint Standing Committee on Judiciary. My name is Charlotte Kramer. I live in Bodenham, and I speak to you today on behalf of Restorative Justice Project Maine's Legislative Committee in support of LD 1941. When considering parole, I believe we must start by asking ourselves a fundamental question. What do we really want our criminal legal system to be for? Do we believe it should truly be about correction, about helping people understand the impact of their actions so that they learn, change, and don't repeat the same harm? Do we believe in offering people opportunities to make up for their mistakes? Or do we believe in permanent punishment, labeling people as irredeemable and locking them away, even though those who end up incarcerated have disproportionately experienced poverty, racism, and trauma? Parole represents a choice between retribution and rehabilitation, retaliation and repair, punishment and prevention. The Maine Department of Corrections states that its goal is to, quote, rebuild and transform lives. But that goal rings hollow when we don't have a meaningful mechanism for release for those who have successfully rebuilt and transformed their lives. This bill creates that mechanism. It does not guarantee release, but gives people who have demonstrated meaningful change the opportunity to have their efforts reviewed by the parole board. It doesn't undermine public safety, but establishes a careful evaluation process requiring the parole board to develop administrative release guidelines and utilize an evidence-based risk assessment in its decision-making. In my work facilitating restorative justice processes for people facing criminal charges, I see firsthand every day that when people are given the opportunity to show accountability and make amends for their actions, they do. LD 1941 would allow those who have caused serious harm to demonstrate how they have changed and to return to their communities with insight and purpose. The youth I work with desperately need mentors and role models who both understand their struggles and who show through lived experience that it is possible to overcome those struggles. Returning citizens have a unique ability to connect with our at-risk youth, break cycles of trauma and harm, and strengthen their communities. Importantly, reestablishing parole would give incarcerated people even more of a reason to engage in rehabilitation and personal growth, knowing that their efforts may one day be meaningfully recognized. This bill is an opportunity for Maine to invest in hope, redemption, and the potential for people to be known not for their worst mistakes, but for who they have become since. If, like me and like my colleagues at Restorative Justice Project Maine, you believe in people's capacity to change for the better, I urge you to vote ought to pass on LD 1941. Thank you.
Thank you for your testimony. If you can just pause for a moment. Committee members, are there any questions? Not seeing any. Thank you.
I'm Jenny Ferrari of Portland, and I've got to go get my kids off the bus, so thank you for letting me push through. This is the testimony of Brandy Richmond, who's currently in Windham, Maine at the Southern Maine Women's Reentry Center. Dear members of the Maine Legislature, my name is Brandy Richmond. I believe parole should be reestablished in Maine because people are capable of profound change, and our justice system should recognize that growth. I am currently incarcerated at the Southern Maine Women's Reentry Center, serving a 3.5-year sentence. In my time here, I have seen women serving long sentences who have taken full responsibility for their actions and worked tirelessly to rehabilitate themselves. Currently, over 28% of all incarcerated women in Maine are serving sentences of 5 years or longer, yet they have no mechanism to prove that they are ready to return to their communities. Without the possibility of parole, their transformation remains unacknowledged, which often leads to a crushing sense of defeat. Parole is not a guarantee of release. It is a structured and thoughtful review process that considers behavior, rehabilitation efforts, and public safety. Allowing parole would give people an incentive to participate in programs, pursue education, address trauma, and maintain good conduct. When individuals know their efforts matter, they are more motivated to change and prepare for a successful return to society. Studies show that a lack of parole options can actually decrease prison safety as the incentive for good behavior is removed. Many women serving long sentences have histories of trauma, addiction, and mental health challenges. Over time, through counseling, accountability, and self-reflection, many people become very different people than they were at the time of their offense. A system without parole treats people as if they can never change, rather than evaluating who they are today. Research on aging out of crime shows that as people mature, the likelihood of reoffending drops significantly. For instance, recidivism rates for those released after age 50 are exceptionally low compared to younger demographics. Everyone deserves a second chance, especially if they have proven that it is deserved. Allowing people parole would also benefit the state by reducing the costs associated with incarcerating people who no longer pose a risk to public safety, particularly aging individuals. Keeping people incarcerated with no opportunity for review does not improve public safety and places unnecessary strain on resources. It currently costs Maine taxpayers an average of $111 per day, roughly over $40,000 to $75,000 per year, depending on the facility and medical needs, to incarcerate just one person, whereas parole supervision costs only a fraction of that amount. Most importantly, parole provides hope. It gives people something to work towards and reinforces the idea that rehabilitation matters. I believe Maine can uphold accountability while still offering second chances. Allowing parole would create a fairer, more humane, and effective justice system, one that values responsibility, growth, and the possibility of redemption. Thank you, Brandy Richmond.
Thank you for your testimony. And again, since you were reading for someone else, we won't ask for questions. Thank you. Our special guest is back.
Sorry. Thank you for letting me skip. I've got a hyper 2-year-old. Hello again, members of the committee. My name is Brandon Brown. I'm from Bethel, Maine. I'm here on behalf of the Maine Prisoner Advocacy Coalition, where I am the lead on public engagement, and also on behalf of myself and the thousands of people in the Maine Department of Corrections currently. I would need 30 minutes to tell you why we need parole at the very least. I'm going to try to give you 3 minutes of why I think the opposition is going to tell you we don't need parole. You're going to hear a lot of things about supervised community confinement. You're going to hear a lot of things about letting dangerous people out of prison. And you've already heard today that parole is not a guarantee. Parole is something earned. As I spoke about the clean slate bill, parole is a beacon of hope, which we need in our Maine Department of Corrections more than anything. I'd also like to speak today about my personal journey. At 21, I committed a crime. I was sentenced to 27 years with all but 17 suspended to the Maine Department of Corrections. I did approximately 13 years inside. And before I came home, I wrote the supervised community confinement bill that now exists today. And I was the first person in the state released under that new legislation. I was also the first person in the state to obtain a master's degree while incarcerated. I tell you this because one thing that you won't hear in the Department of Corrections opposition to parole today is about the progress that's made, not by the administration, not by the legislation, but by the people inside of our prisons. I know, I'm sorry. You know, the Department of Corrections is right now renowned in the United States of America for having the best programming in the country. We have the best education. We have the best work opportunities for people inside. We have a lot of really beautiful things. Say, hola. Okay. But what we don't have, like I said, is any hope. We have people working 40 hours a week, virtual from their cells, and they have 20 years left and they've been in for 30. We have people who are pioneering educational access. We have residents in the Maine Department of Corrections who help build the actual technical infrastructure that exists right now that gives people that access, and they have no outlet. So what the Maine Department of Corrections has effectively done is shown you that we have good people in our prisons. We have people who can live in an earned living unit. We have people who can work 40 hours a week and make a livable wage and support their families on the outside. We have people who effectively are citizens of our communities with one thing preventing them from being fully effective citizens, and that's the wall that exists between here and there. So what I ask you to really consider is that the opposition will have you believe that this is somehow guaranteed and given, and it's not, it's earned. And not everybody will be able to earn it. Some people won't be able to earn it because of the severity of their crime, because they haven't used their time the way that we want people in prison to use their time. But also that in Maine, we do not have any outlets. Supervised community confinement is not enough. It doesn't affect people with long-term sentences who have transformed their lives. It doesn't give them hope, and it really prevents people inside from actively engaging in the programming that the Department of Corrections, rightly so, tells you is so great. The last thing that I'll say, because I know my time is up, is what you don't know and you would never be able to know unless you went into the prison and you met some of the men that I became friends with, is that our communities are being robbed of their potential, their wisdom, and their kindness. And it's time that Maine catches up with the times and gives people an outlet to come home and contribute to our communities, as opposed to rotting in a prison cell with opportunities that they could be pursuing out here. Thank you for your time. And
Thank you. Thank you for your testimony. Are there
I
any-
love you.
Are there, excuse me, are there any questions? All right, I'm not seeing any. Just an announcement to the folks in the room. I appreciate that this is emotional testimony and it's moving for people, but it's very important that we maintain decorum in the room so that all voices can be heard from folks who came to testify today. So I appreciate if we could refrain from clapping or cheering. Thank you.
Good afternoon, honorable members of the Judiciary Committee. My name is A. Kuba Jackson. Like Brandon, I am a coordinator with the Maine Prisoner Advocacy Coalition. I'm an advocate, and though I've spent time in prison, use my time now to advocate and give voice to individuals who find themselves in the predicament that I was able to leave. And as such, it's my duty to read testimony from one of our sisters, Miranda Hopkins, which I'll read now. Honorable members of the Judiciary Committee, my name is Miranda. I am 41 years old, born and raised in Central Maine. I never thought incarceration would happen to me, let alone take away nearly a decade of my life already. From behind these walls, I've watched my aging father's health decline, his neurological issues from Lyme disease worsen, the likelihood of him no longer being able to stay in his home become more evident by the day. I was supposed to be the one to watch over him, to help him age with dignity and keep him at home. I've watched my siblings battle addiction, go through divorces, hardships, and traumas, raising their children. My pride and joy, my family, is now scattered in the wind, broken, lost. I was the glue, the matriarch who held them together. I never intended to complete this sentence. I came here to wither away. I didn't want to hurt them anymore, but something inside of me wouldn't lie down and die like I wanted. I wouldn't take this sentence as a defining moment in my life. So I got up and decided to take this as an opportunity and make the most of it. I stacked certifications and accreditations into piles. I will have a bachelor's degree in justice studies with a pre-law concentration from the University of Maine at Augusta in a few months. I'm on my way to law school to serve those in need like I once was, not for the money, for truth, justice, and being the person I didn't have when I needed them most. Since arriving, I've never had formal discipline infractions, always had a job, been a recovery coach, model inmate, and mentored those just entering prison. I've taken every class I was required to and dozens of more. Once I graduate, I will be stuck in limbo, a person who has met every rehabilitative requirement and more set for them and is unable to progress forward. Working from prison for prison wages, I was 27 years old and I must take I'm sorry, forgive me. And I must take a gap year before law school.
I'm
And
sorry
for
to
the-
interrupt you,
right.
but the time is up. If
And
you
I'll
could
go ahead
finish up.
and just wrap this up. Miranda is in support of this bill, so am I. Please reestablish parole, get me to law school and back to my family where I belong. Thank you.
Thank you for your testimony. Please go right ahead.
Yeah, my name is Mr. Ephraim K. Bennett. It's a miracle that I'm standing here. Yesterday, I was in the hospital getting treated. I have stage 4 cancer, been given a diagnosis of just 2 years to live. But I want to read something from a book. It should be noted in predicting Mr. Bennett's likelihood of committing future criminal acts that he presents with numerous risk factors associated with criminal recidivism, including but not limited to capacity for empathy, remorse, and guilt. lack of internal motivation for change, limited grasp of gravity of past crimes, minimization of past crimes, absence of social and coping skills, lack of understanding of triggers, poor quality of peer skills, lack of understanding of the risk that he put people in, and Mr. Bennett's distorted view of himself, rules, and court orders are for others. Then it go on to state, Bennett is resistance to treatment. He sees himself as a hero, a prominent African-American leader, athlete, and scholar who would be properly perceived if it wasn't for the jealousy and racism of others. That's what was said about me. Last night, I just received notice that my book just became not only a national bestseller, but it's been transferred over to be a New York Times bestseller. So I'm in support of the bill because many people that's here today, I've helped mentor: Cuba, Brandon Brown. Parole is not a gimmick. I think parole, you have to take measured steps to make sure that victims are taken care of. So what I did is I put in my book services to help victims. Every copy, this book just sold 1 million copies. So in less than 8 months. So I'm in favor for parole because there are men who are doing work just like me that's incarcerated. I believe that you have to give victims a voice in the parole bill, and you have to come together and come with a comprehensive plan to pass the bill, because there are men and women like me who, if given a second chance, they would do good, while they're out. And so I'm for the bill because I think it's necessary, because you have people like Leo Hilton, Brandon Brown, Joe Jackson, many of these guys are coming out doing great things. And I just want people who oppose the bill to understand that it can be passed with comprehensive. You have to have a task force of people. I'm working with Illinois legislators right now as I speak to you all and getting their parole back. I'm doing that. Elon Musk just reached out to me to get my nonprofit organization, the Believe in Hope Foundation, started right here in Maine.
Thank you.
Procter & Gamble, they also reached out to me, want to support my podcast, which is due to start in March. So
Thank you for
all
your testimony.
time.
Let's just see if there are any questions. Representative O'Halloran.
Hi, thank you.
Yes.
I'm going to check out your book.
Yes.
Did I understand you to say that you do believe that victims should have a voice in the?
Yes, because everybody have to have a seat at the table. One thing that's missing with the legislators, no offense to you all, but one thing that I'm helping to coordinate, and they reaching out to my people, because I have an agent, I have a publishing company that everybody supports the work, because I've been doing this work for a very long time. I grew up in the civil rights. My parents, they marched with Dr. King. I did some of the marches myself, so I can speak about this because I understand what it's going to take. Everybody have to have a seat at the table. You have to involve the victims, because they're victims. You cannot rob them, and they're being robbed of their chance and opportunity for their voices to be heard. Just because you give us time in the prison cell, is that really justice for a victim? No, it isn't. Because they hear about your sentence, but they don't get a chance to track. So I'm saying that you have to come together. I'm working with the Chicago police fraternity, that they do all this work with victims. So they're involving me to help usher in a person who was incarcerated, who shows that they can be rehabilitated. He got a seat at the table. You have legislators and everybody come together and come up with a comprehensive plan to ensure that you tracking the former incarcerated persons, every move, every step. You know what they're doing. The victims know what they're doing, and it'll give them a sense of power
Thank you for your response.
All
Let's
right.
see if there are
I
other
like that
questions.
answer.
Yes.
I didn't catch your first name.
My name is Ephraim K. Bennett.
Ephraim?
You can just pass it.
We're actually, okay, you could pass it. I'm
Oh,
not supposed to
pardon
wave
me.
around props, so I was
Pardon me.
trying to monitor that, but it's okay. You can pass that around. Are there any other questions for this witness? All right, not seeing any. Thank you for joining.
All right, thank you all for having us.
Thank you.
All right.
Senator Carney, Representative Kuhn, and honorable members of the Judiciary Committee, thank you for the opportunity to share my testimony regarding the profound impact that Maine's lack of parole system has on the families of incarcerated individuals. I am here in support of LD 1941. Maine remains one of the few states in the nation without a parole system. While this policy was initially intended to promote consistency and accountability in sentencing, its long-term consequences have extended far beyond the incarcerated population itself. The absence of parole affects families, children, and communities across the state who continue to bear the emotional, financial, and social costs of indefinite incarceration. Families play a critical role in rehabilitation and successful reentry. When there is no possibility of parole, it diminishes hope not only for incarcerated individuals, but also for their loved ones. Families witness their relatives work diligently to change, complete programs, and demonstrate growth, yet the system provides no pathway for that progress to be acknowledged. This lack of incentive undermines rehabilitation and weakens the family bonds that are proven to reduce recidivism. The emotional toll on families is significant. Without any opportunity for release review, families live with the sense of permanent separation and uncertainty about the future. The financial burden also cannot be ignored, covering travel expenses, phone calls, and commissary costs for years or decades with no clear endpoint. These ongoing hardships disproportionately affect women, children, and lower-income households, compounding cycles of poverty and instability. People with an immediate family member in prison are spending an average of nearly $4,200 annually to stay in touch with and support each of their loved ones behind bars. My husband is currently incarcerated at MSP, and the impact that this has on myself and my family is significant. I travel an hour and a half every weekend to see him and spend hundreds of dollars to be able to talk to him throughout the weeks. We have no hope for him to come home anytime soon. We have a family to raise and children to watch grow into the amazing humans that we intend them to be, but without him here, I'm the one facing the challenges of supporting my family. Reinstating parole in Maine would not mean automatic release. It would mean the restoration of hope, fairness, and accountability. A parole system provides a structured, evidence-based process for evaluating rehabilitation and readiness for reintegration. It ensures that those who have demonstrated true reform are given the opportunity to contribute positively to society while maintaining public safety through oversight and review. In closing, the absence of parole in Maine does not serve justice. It extends punishment beyond prison walls and into the homes and hearts of families. Restoring parole would strengthen families, promote rehabilitation, and align Maine with a more humane and effective model of corrections policy. Please give your unanimous support on LD 1941. Thank you for your time and consideration. Rachel Coleman.
Thank you. And can you share your place of residence, please?
Gray, Maine, sorry.
Thank you. Any questions, committee members?
Thank you.
Thank you.
My name's Emery Niles, and I'm going to be reading testimony by Earl Buddy Beeler. My name is Earl Buddy Beeler. I'm incarcerated at the Maine State Prison, and I'm here to support LD 1941. I was already using drugs and heading nowhere good when I dropped out of high school at age 14. In 2010, I was sentenced to 55 years in prison at the age of 24. I have hurt people. I have made serious choices that I take responsibility for. When I first came to prison, I didn't believe change was possible, or I didn't know it was possible. I kept using drugs. I spent my first 6 or 7 years going in and out of segregation for fighting. I didn't know how to live sober. I didn't know how to live any other way. I grew up around violence and addiction. That was normal to me. I had never had positive role models, and I didn't have the tools to do better. Things didn't start to change until 2020 during the pandemic. I got sick because of my drug use, and I ended up isolated. By then, I was in my mid-30s. I realized I wasn't a kid anymore, and if my life was ever going to be different, it was on me. No one was coming to save me, and I couldn't keep living the way I had been. Today, I am the first person in my family to attend college. I am working toward a degree in psychology. I learned about adverse childhood experiences and how trauma follows people into adulthood. For the first time in my life, I faced my past sober. It was painful. It cracked me open. There were moments when I wanted to quit. Instead, I used the skills I was learning and stayed in recovery. I've now been incarcerated for 16 years and sober for 5. I will turn 42 this summer, and I am not the same person I was at 24. Education, programming, and people who believe in rehabilitation have changed how I think, how I act, and how I am planning for the future. Parole is not about avoiding accountability. It is about recognizing growth when it actually happens. LD 1941 creates a path for people who have done the work to be seen as who they are in the present, not who they were at their worst moment. Parole matters for people like me, not because we were forced to change and not because someone made us. It matters because we chose to, because we wanted to take responsibility, live differently, and become better human beings. I respectfully urge the committee to vote ought to pass on LD 1941. Thank you for listening.
Thank you.
I'm gonna loosely follow this. My name is Joseph Jackson, and first of all, I want to thank Senator Carney and Representative Khan and respective members of the Judiciary Committee. I was here up here earlier. I'm the Executive Director of Maine Prisoner Advocacy Coalition, Co-Executive Director of Maine Inside Out. I'm one of the founders of the Maine State Prison Branch of the NAACP, and I've sat on the task force to re-examine parole. I'm here to testify in favor of LD 1941. And one of the reasons for that is that it became clear for me, when particularly sitting in the meetings that we were having around parole, is that parole doesn't change a person's sentence. I think that's what we got clear on. We got clear that the accountabilities that were imposed on folks for the crimes they committed wouldn't be changed by simply establishing parole, because the Department of Corrections has this thing called custody. It has so much power, it can have custody over a person while they're in the community. And so that was one of the things that was really clear to me when we were talking about that. As part of the contingent, I was with the sponsor of the bill, and we went inside the prison and we talked to some of the men and women in those facilities. And I think one of the things that was clear was we have this diverse background of folks. There's no monolithic group of folks who are incarcerated. They were very diverse. They were Republican backgrounds, Democratic backgrounds. But one of the things that wasn't divisive was that they all believed that parole was something that we needed. And I believe that parole is something we needed. I've been advocating for people, who've been impacted by the criminal legal system since I walked out the door. So I celebrated my 12th year of freedom on October 1st. When I was sentenced over 30-some years ago, it was declared that I was unrehabilitatable. Today, I run 2 organizations. I own my own home. I hire people that are system impacted, and I work with the DOC to try to change the conditions for folks that I live with. Over that time, the DOC has made tremendous amount of progress. And part of that progress is what they call the Maine model of corrections. Well, I believe that the Maine model of corrections is incomplete if you don't have the tool of parole. We have this tool where we're talking about rehabilitating and restoring people, but we don't have the ability to reward them when we recognize we've done our job. So if the DOC is doing its job right, we should be releasing people. And that's for me, I think that will be the end of how I would frame this. Obviously, hope and restoration and redemption are some things that we know that is required. We want to give people incentive to be able to start doing some of this programming. And I think having a mechanism like this tool for potential release will definitely an incentive for people to really try to improve themselves and better the outcomes for when they are released. Thank you. I'm out of time.
Thank you for your testimony. Are there any questions, committee members?
Thank you.
Not see any. Thank you.
Senator Carney, Representative Kuhn, and honorable members of the judiciary.
Could you please lower the mic a little closer to your, oh, it's also not on. Oh, it is on. It is.
Oh.
There we go.
Thank you.
Thank you.
I'm here to give testimony for my son that he's written out. My name is Sean Boyd, and I'm currently serving a 20-year sentence. Upon arriving in MDOC custody, I quickly learned that preconceived notions of prison and inmates was completely askew. I expected a lack of value for life, rules, and humanity. A portion of the population had a high regard for these values. Men who had violated legal and moral expectations and landed in prison. Because of shame, guilt over the crime, they often exhibit a higher regard for these values than those I knew on the street or even those who oversee us now. I believe that anyone, public, legislature, judges, or lawyers, would see the same if they took the opportunity to look. I have no greater guilt in life than the harm my crime has had on my victim, my family, friends, and community. I'm doing everything that I can to atone for my crime, live a highly moral, legally correct life. A second guilt I carry is the cost of incarceration on society. It's my belief that I deserve to be in prison for my crime. I question the length of my sentence. I believe people should pay a debt to society to atone for their crime. I don't believe that warehousing prisoners, especially as cookie cutter approach, serves the public or the prisoner well. For prisoners who take radical accountability for their crime, take great care and serve their time responsibly, who engage in pro-social behaviors, go beyond required programs, and routinely engage in selfless acts, they should have an opportunity to be vigorously evaluated to determine if a less confined correction environment is appropriate. Examples include being transferred to medium or minimum facilities, placed on community confinement or supervised release or parole, no matter how many years they're serving. The use of new age technology should be integrated so that tracking accountability can be assured and maintained. Examples would be GPS tracking, biometric monitors, cameras, other technology to monitor all aspects of inmates and public, which has many valuable benefits. One acknowledges that one size does not fit all approach is not justice. One size fits all approach is not justice. Rewards deserved behavior and confirms correction progress. Reduces cost of incarcerated individuals, which could also transfer monitoring health and other costs to the incarcerated individual, restores family units and reduces broken homes, recidivism, and our children from becoming criminals. Returns individuals to the community who have had vetted and deemed to be very low risk rather than dumping unvetted, unchanged, hardened criminals back on the streets with little to no chance of success.
Thank you for sharing that testimony with us. Can you wrap it up just in a sentence or two?
I'll give you his PS's. Thank you. I can't change my past, but I can take radical accountabilities for my actions and learn from them and be a better human being moving forward.
Thank you for sharing that with us.
I guess she already took it. And I just want to say, I've got to make it to 96 to see my son out of jail.
Good afternoon. My name is Ray Lightheart. I'm a resident of Rockland, Maine, and I'm here to read on behalf of Leo Hilton. Honorable Senator Carney, Representative Kuhn, and esteemed members of the Judiciary Committee.
My name is Leo Hilton, and I am writing in strong and informed support of LD 1941. Doing so as an incarcerated citizen in Maine State Prison, Warren. I caused serious and irreparable harm at the age of 18 that brought me to prison and have now been incarcerated for almost 18 years. I am not writing today out of a belief that incarcerated people can deserve the opportunity of parole or a second chance at life. Rather, I am writing from a place of responsibility to help lessen the amount of harm caused by the current system and persistent recidivism rate. The current system of straight release, good time, and SCCP is woefully inadequate in supporting public safety, Maine's economy, and victims and survivors of crime and harm. LD 1941 provides support in each of these areas, as I elaborate on in the December issue of the Ballard, which is here. I brought a couple copies if anyone wants to see that. First, this bill prioritizes increased public safety by one, utilizing a multidisciplinary board of professionals to thoroughly evaluate applicants. Two, implementing an evidence-based actuarial risk assessment to support the parole board in only granting parole to those who pose no threat to public safety. And three, requiring special guidelines to be developed for applicants convicted of sexual or domestic violence offenses for added layers of safety and protection. So if someone poses a threat to public safety or does not have a strong enough parole plan, they will not be granted parole. Second, this bill contributes materially to Maine's economy. Rather than continuing to strip Maine taxpayers of $1,200,000 each year per prisoner, this bill authors both a reduction of an estimated $13.3 million and an addition of $14.7 million to Maine's economy. Even though the direct savings per person won't be the full $120,000, that equals an approximate $28 million each year added to Maine's bottom line for every 100 citizens paroled. Third, and absolutely vital, LD 1941 provides rights and trauma-informed care to victims and survivors that was developed exclusively by victims and survivors. This includes their having choice and voice in parole decisions, support in addressing trauma, and trauma-informed notification from the DOC's Office of Victim Services at each step of the parole process. Victims and survivors can choose their level of involvement and choose to speak once and have their voice stand indefinitely. This parole process would empower victims and survivors in ways that no criminal legal process currently does outside of restorative justice. It is for these reasons of improved public safety, a stronger Maine economy, and new empowerment of victims, survivors of crime and harm that I respectfully implore you to vote ought to pass on LD 1941 today. Thank you so much.
Thank you. And again, we won't ask questions for folks who are reading from others. You
anyone
can just
wants
leave
this.
those in the basket.
Thank you.
We'll share that. Thank you.
Sorry. Hi, my name is Peter Ryan. I'm a current junior at Colby College who has spent the past year studying our criminal justice system. I've had the privilege of working with the Colby College Government Department, the Maine Indigent Defense Center, the Maine Prisoner Advocacy Coalition, and Parole for Maine, and have published an op-ed on LD 1941 in the Bangor Daily News. I am here to speak in favor of LD 1941. Imagine you are incarcerated. You decide that you want to change. You spend your time pursuing multiple advanced degrees to better yourself. You teach classes at local colleges to give back to your community. You begin wood carving and share your passion with others. Yet, when you apply for clemency, when you apply for a second chance, you are denied. Members of the Joint Standing Committee on Judiciary, unfortunately, these stories are not fictitious, but the reality for many Mainers, such as Leo Hilton, Charlie Jones, and countless others, who all share one thing in common. They were incarcerated, chose to change, and were denied a second chance at some point in their clemency review processes. I urge all of you to consider voting through LD 1941, an act to implement recommendations of the Commission to examine reestablishing parole. This would not only give Mainers a second shot at life, but it would make the state safer. Studies conducted by the Bureau of Crime Statistics and Research show that incarcerated people who undergo parole programs are less likely to be convicted of a crime or face jail time within a year of their release, demonstrating that parole programs are effective. The state of Maine consistently ranks around 39th for cost of living, 42nd for personal income, 43rd for business opportunity, 44th for job market, and 45th for economic outlook. Despite this, the Maine state government spends almost $200 million per year on incarceration facilities at an average of $117,000 on each person they incarcerate, which is the 5th highest in the nation. As their economic and living conditions continually rank as some of the worst in the nation, our state government pours hundreds of millions of dollars into a carceral system that has largely proven ineffective. It's time to try something new. Maine's prison system has a history of abuse and embraces violence over meaningful rehabilitation. Approximately half of Maine's prison deaths come as the result of an overdose or suicide, many of which were initially unreported but discovered by a report done by ABC News. These people are Mainers too, and no Mainer should be treated this way. We must not abandon our community values when it comes to incarcerated people and should all be supportive of avenues such as parole, which embrace justice and forgiveness over vengeance and punishment. 46 out of the 50 US states have some form of a parole system, yet Maine has none. What do we want the legacy of Maine's justice system to be, and how do we want our impact as community members to be remembered? I urge all of you to vote through LD 1941 and consider re-implementing parole. Thank you.
Thank you. Committee members, are there any questions? Yes, Representative Lee.
You cited some studies from the Bureau of Crime Statistics. If you have hyperlinks to those, could you send them to our?
Yeah, I'll be sure to submit
Thank
those.
you, appreciate it.
And also a lot of this, or some of these are excerpts from my op-ed, and on there you can click and it has the hyperlinks, but I'll be sure to put them in as well. So yeah, of course.
Thank you. Representative Crusoe.
Just curious, what town do you live in?
So Waterville has been my home for the past 3 years, but I'm from New Hope, Pennsylvania. So I come from far away, but we do have parole in my state. So it would be awesome to see it implemented here because I think it's been pretty effective. Yeah.
Thank you for your testimony.
Yeah, thank you all.
My name is John Courtney from Cape Elizabeth. Senator Carney, Representative Kuhn, esteemed members of the Maine Legislative Joint Standing Committee on Judiciary, speak to you in strong support of LD 1941. I'm the founder and coordinator of Shelf Life Project, a distribution program that for the past 5 years has supplied books and other educational resources to Maine correctional facilities. Since 2018, I've also served as a volunteer special projects coordinator with the Maine Prisoner Advocacy Coalition, bringing films, performers, artists, and workshops inside the residents of the Maine Department of Corrections. Most of the featured speakers focus on personal growth and transformation. The majority of the speakers featured are individuals who have served time, incarcerated, and now use their lived experience as credible messengers to transform the repair the lives of others. Additionally, in 2020, as part of a cohort that helped establish the Jericho Circle project at the Maine State Prison, program that prioritizes emotional awareness, accountability, and personal integrity through candid and vulnerable circle processes. Through these lenses, I've had the humbling, humanizing privilege of witnessing men and women demonstrate heartfelt empathy for caused harms, express sincere desire for repair and to make amends, to use their often painful life lessons to change the path of others. Many of them have appeared before you today. I write this testimony thanking my gentle friend and MPAC colleague, Andre Hicks, who recently founded his own nonprofit, Breaking Bread. Organization provides direct mentorship to system-impacted Maine youth, providing one-on-one support, steering them towards productive paths. I believe Andre's authentic experience as a youth in and out of Maine's correctional system, who later turned his life around, earns unique attention and respect from these impressionable young minds. I believe there are dozens of men and women like Andre currently incarcerated in the Maine DOC who deserve an opportunity to demonstrate their transformation and growth, earn an early supervised return to society as mentors, entrepreneurs, workforce members, caregivers, and citizens, rather than being warehoused at great taxpayer cost. I believe parole provides a safe, balanced, and incentivized path to that opportunity. I listened with great interest to the entirety of the 2022 Parole Study Commission sessions and appreciate the great rigor, debate, and diversity of opinion contained within that discourse. Input included voices from lawmakers, academics, social scientists, law enforcement, victims advocates, economists, system-impacted individuals, parole board members, scores of general public testimonies. I believe the findings to be carefully considered, reasonable, and well-balanced, especially highlight the primary recommendation approved by an 11-0 commission vote to establish new mechanisms not currently provided for in Maine law to open pathways for early release of incarcerated persons who no longer pose a threat to public safety. I urge this committee to review these recommendations and vote ought to pass on LD 1941. My sincere thanks for your time and consideration. And for your convenience, I imagine you have it, but I've attached the summarized recommendations from that study commission. So it's at your fingertips here and in the materials I provided. So thank you.
Thank you for providing that. Committee members, are there any questions? Not seeing any. Thank you.
Thank you.
Hi.
Welcome. Please go right ahead.
Thank you. Representative Carney, you, and distinguished members of the Joint Standing Committee on Judiciary. My name is Norman Hightower. I'm a restorative services support specialist with Restorative Justice Project Maine. Recently re-entered individual, and I have extensive experience with Maine's prison system. I'm here to testify in support of LD 41 on behalf of myself and RJP Maine, Restorative Justice Project Maine. We firmly believe that if parole were reestablished in Maine's prison system, it would greatly benefit the people of Maine. Statistics show that people who are granted parole are 36% less likely to return to prison than those who are quote unquote straight released. Maine has one of the highest incarceration states along with America of any democracy in the world, and lowering that rate would certainly save Maine taxpayers money, as it's 9 times more expensive to incarcerate an individual than it is to supervise them on parole. Experts estimate that $14.7 million would be a boost to Maine's economy for every 100 prisoners granted parole. I heard somebody with a higher number than that. But in addition to those fiscal advantages, parole can help to provide a rehabilitative transition back into public life. And since Maine abolished discretionary parole in 1976, more Maine prisoners are serving their entire sentences in a cell rather than being afforded opportunities to rehabilitate, transition home to complete their sentences while working and caring for their families. This prevents them from restoring relationships within their families and communities, and those relationships are crucial to helping people like me reduce my chances of recidivism. I personally have found myself in a situation where I was quote unquote straight released from a cell in a secure facility after a long period of incarceration, and I found it extremely difficult to readjust to societal norms. If I were afforded parole, that adjustment might have been much easier, and I might not have wound up reoffending back in prison time and time again. Reinstating parole could mean that fewer people are damaged by those long-term effects of incarceration. As an individual, I feel that if parole were an option when I was serving my time, I'd have had much more incentive to be on my best behavior. I would have tried to take every class and program I could have to get home to my family sooner. It would have given me incentive to make significant changes in my life, and those changes would have made a difference in my life, the lives of my family members, and the lives of those in my community. Not to mention that parole would be merit-based, and it would provide a safer, more stable environment for corrections officers and inmates inside the prison itself. I greatly appreciate the fact that we as a state are concerned with finding ways to help Maine's incarcerated individuals transition back to the community. And I urge you to support LD 1941 for the benefit it will have on all Maine communities and residents.
Thank you. Committee members, are there any questions? Not seeing any. Thank you for your testimony. Hello, welcome.
Hello, my name is Jasper Behrman Moore. I'm from Rockport. Today I will be reading testimony from the Maine State Prison branch of the NWACP in support of LD 1941, an act to implement the recommendations of the Commission to examine reestablishing parole. Dear committee members, thank you for your time this morning. We all know the well-documented critique of parole. There is no need for the NAACP to reiterate what has already been studied and debated for decades. Instead, we ask each of us to reflect on 3 fundamental questions. 1, do we truly believe in forgiveness? 2, do we truly believe in redemption? And 3, do we truly believe in healing? If the answer to these questions is yes, then passing a comprehensive parole bill is the correct thing to do. For decades, Maine has workshopped and examined parole Yet we are no closer to meaningful progress. We continue to hold today's Mainers accountable for the parole violations of individuals from 50 years ago. Individuals who, in many cases, are no longer alive. It is neither fair nor reasonable to allow the mistakes of the distant past to dictate the future of our justice system. The NAACP believes that this committee can begin a genuine healing process for everyone by taking the step to bring meaningful change to rehabilitation, education, and treatment with the passage of LD 41. Healing starts with forgiveness, and forgiveness opens the path to redemption. In closing, the MSP NAACP branch is tremendously proud of Governor Janet Mills for her courage and steadfast leadership in standing up to the President of the United States to protect the rights of Maine citizens. We respectfully ask that Governor Mills brings that same determination to the issue of parole. Governor Mills, you have a rare opportunity to shape a defining legacy in Maine's history by taking a step no governor has taken in more than 50 years, restoring a parole system in our state. Reestablishing parole would mark a bold and forward-looking commitment to meaningful criminal justice and prison reform. It'd be a signal to the nation that Maine is ready to lead with fairness, dignity, and accountability. Governor Mills, you made the memorable statements ever made by a sitting Maine governor. See you in court, Mr. President. If reflected, courage, conviction, and willingness to stand firmly for what is right. Today, the NAACP is hopeful to see the same spirit as you consider signing the legislation to bring parole back to the great state of Maine. This moment offers a chance to open a new chapter, one grounded in justice, rehabilitation, and hope. Respectfully submitted, Maine State Prison Branch of the NAACP.
I'm gonna ask you to come up next.
Thank you so much for the chance to be here right now, running up from agriculture. Really honored to be able to read Representative Jeffrey Evangelist's testimony today. I think, as some of us know, he served 8 years in this committee and puts his heart and soul into this every day in Warren at MSP, and so it's a real honor. Good afternoon, Senator Carney, Representative Kuhn, and other distinguished members of the Judiciary Committee. I'm sorry I'm unable to appear today in person to present this testimony. It's been almost 5 long years since I introduced the parole bill, which was amended into the study commission. To be clear, I'm reading this in first person as Representative Evangelist wrote it. In 1976, Maine became the first state in the union to abolish parole. At that time, Maine had about 10 women in prison and about 500 men incarcerated. The abolition of parole and the adoption of the new criminal code in 1976 led to a sharp increase in incarceration. Today, we have approximately 200 women incarcerated and roughly 1,600 men. Those are shocking numbers. You can see the attached DOC study. While I could go on with statistical information, I'd like to speak to you today about hope. Nearly half of all U.S. adults have a family member who has experienced incarceration. It could be you or me. Imagine a world that doesn't believe in second chances, a world without a second chance for a mistake you made when you were between 18 or 25 years old. Despite holding yourself accountable and seeking redemption, there's no pathway to redeem yourself. No matter what you do to hold yourself accountable and redeem yourself, the efforts are useless, killing hope. It's a very dark place. 34 states will have parole systems in place, including all of New England, still have parole systems in place, including all of New England and New York. Without parole, states rely mostly on the discretionary powers of governors, that of pardons and executive clemency. Truthfully, in Maine, while pardons are sometimes issued, often for politically connected individuals, pardons are never issued to incarcerated individuals who have worked tirelessly to improve their lives and have held themselves accountable for their mistakes. Shamefully, Maine pardoned Don Gellers, an attorney who was assisting the Passamaquoddy Nation in the 1960s and 70s. Gellers was framed by police in the Attorney General's office. Gellers died in 2014. He wasn't pardoned until 2019, a posthumous pardon,
We can't do better than that. In reference to the other executive power available since the abolition of parole, that of executive clemency, Maine's governors have never granted even one application. Since 1976, no one in Maine has ever been granted executive clemency, underscoring the failure of Maine's determined sentencing system. Since 1941 reestablishes LD 1941 reestablishes parole. It's a critical step in recognizing the good reform work being undertaken at our prisons, sponsored by our own Department of Corrections. Many of our incarcerated residents are in prison for 30 years, all the way to life for mistakes they made when they were 18 to 21 years old. We all know the brain of a teenager isn't fully developed. In one case in 2005, 2006, a 14-year-old boy was tried as an adult and sentenced to 25 years in prison. In 2013, he had this to say: "The person I was at 15 is almost unrecognizable from the person I am today. I've grown in ways emotionally, in ways I couldn't begin to describe. My relationships with people are so much better. I'm so much more of a calm person," said Patrick. "I wish that all of it could be taken back, knowing at the time the irreparable harm you've done to a person, to a family, to a community. There's no way to express that or put it into words. There's no action I could possibly do that could apologize for the damage that I've done." In 2019, the Prison Policy Initiative graded the prison release system in all 50 states. Maine earned an F-, the lowest grade due to the harshest determinant sentencing system in the nation, combined with no parole system. On February 13th, 2020, the New York Times entitled, "It Didn't Work." The Times reported that article entitled, "It Didn't Work." The Times reported that states which abolished parole are now examining the decision. "We thought we were fighting crime and it didn't work," said David Marsden, a state senator in Virginia, who has previously introduced bills to restore parole. But more recently, we've stopped trying to teach lessons and started trying to solve problems. People are now more likely to believe that people deserve a second chance. Senator Carney, Rep. Kuhn, I believe in the dignity of people. I believe, when earned, in second chances. I believe in accountability, and most importantly, I believe in redemption, the capacity of human beings to right the wrongs of the past. Yes, I feel deeply for the victims as well, but society is not made safer when Maine's correction systems frustrate hope and redemption. All this does is increase recidivism when a resident is released, and 95% of incarcerated people will be released someday. Maine state prisons are doing a great job of promoting college education and other training programs inside the walls, but this great work does not get recognized like it does in other states. In New York, the parole board carefully examines the progress made by residents each year when it examines applications. In Maine, you can earn a master's degree with a 4.0 average, work hard, and never get in trouble, and you get out of prison the same time as someone who refuses to work and gives the guards a hard time. I call Maine's prison and release system killing hope. Thank you for your consideration. Thank you for your time.
Thank you for joining. We won't ask any questions.
Appreciate it. Thank you for the time.
We'll continue with members of the public.
Well, good day, Senator Carney, Representative Kuhn, and distinguished members of the Judiciary Committee. I'm Julia Lester from Paris, and I'll be reading on behalf of an incarcerated person. My name is Pedro E. Santiago. I'm a resident of Knox County. I am writing in support of LD 1941, an act to implement recommendations of the Commission to examine reestablishing parole. Most Maine citizens are not aware that while their hard-earned tax dollars support public safety initiatives, including corrections, probation, and parole services, Maine does not currently provide a parole option for its own citizens. Instead, parole is available only for individuals who commit their crime in another state. This creates both a gap in fairness and a missed opportunity for our communities, since there is currently no parole for those sentenced under our laws after May 1st, 1976. This means many Mainers who have served long sentences cannot benefit from parole, even when they have transformed their lives. I'm living testimony that a person who has been incarcerated for 25 years or more is not the same uneducated person as when I committed a youthful or isolated mistake. During my incarceration in Maine, I have had access to education, from adult basic education through associate, bachelor's, or even master's degrees courses, vocational training in trades such as building, welding, coding, etc., behavioral and rehabilitation programming. These programs help people grow, heal, and rebuild. In addition, proposals under consideration in Maine include making those with 25-year or longer sentences eligible for parole after serving 20 years, or making those with short sentences eligible after they have served at least half of their sentence. Existing criteria for the supervised community confinement program require good behavior, participation in programming, and assessment of risk and need. These criteria will also apply for any reentry program. Successful reentry is not only about individual rehabilitation, it is also about strengthening public safety, reducing recidivism, and promoting healthier communities. Evidence shows that structured support, incentives for good behavior, and meaningful second chances can reduce the likelihood of reoffending and increase the chances of successful reintegration. Maine deserves a system that reflects these values and offers all its citizens a real path forward. Passing LD 1941 would recognize that people can change and many do change, given the opportunity. It would allow those who have invested time in education, work, counseling, pro-social relationships, and who have demonstrated responsible behavior to have hope. It's not about discounting the harm or forgetting the past. It is about fairness, safety, and public policy that strengthens communities. By supporting and passing LD 1941, you will be affirming that Maine believes in accountability paired with opportunity. This legislation can help individuals rebuild their lives, reunite with their families, contribute to the workforce, and ultimately strengthen the fabric of our state. Thank you for your time and consideration, and this important step towards a safer, more just, and more compassionate Maine. Respectfully submitted, Pedro E. Santiago, Maine State Prison, Warren, Maine.
Thank you for sharing that testimony.
Thank you.
Good afternoon. My name is Heidi Lester. I live in Paris, and I will be reading the testimony of Tracy Megison, who is at Maine State Prison. To the honorable members of the Judiciary Committee, my name is Tracy Megison, and I am writing today in support of LD 1941, the bill to reestablish parole in the state of Maine. I hope to offer my personal story as a reflection of why this legislation is not only fair, but necessary for justice, for rehabilitation, and for hope. I came into the prison system 34 years ago at just 19 years old. I was an addict, struggling with alcohol, emotionally immature, and had no real understanding of myself, others, or the consequences of my actions. I take full responsibility for the pain I caused and the choices I made. Nothing I say is meant to excuse the harm I've done. I carry it with me every day, but I also believe that people are capable of profound change. I know this because I've lived it. Over the last 3 decades, I've worked hard to rebuild my life from the inside out. I've been clean and sober for 23 years. That alone has been a mountain to climb, but in doing so, I found clarity, purpose, and the strength to keep growing. I've completed rehabilitative programs, stayed active in recovery communities, and committed myself to education. I'm currently enrolled in college. I've learned how to understand my past, manage my emotions, and live with integrity and discipline. But despite everything I've done and everything I've become, under the current law in Maine, there is no meaningful pathway for someone like me to ever return to society, no opportunity to demonstrate rehabilitation before a parole board, no chance to earn redemption in the eyes of the system, no matter how hard I work or how long I serve. LDL 1941 would change that, not by letting everyone out, but by giving people like me the opportunity to be seen for who we are today, not just who we were at our worst. Parole is not a free pass. It's a process of accountability and evaluation. It's a system of review that asks whether a person has changed, whether they pose a risk, and whether they can safely re-enter the community. This is something that a life sentence alone can never measure. There are many of us in Maine prisons who entered the system young, broken, and addicted, but who have since done the deep, difficult work to heal, grow, and become better people. I know I can never undo the past, but I truly believe I can make a difference in the future. Given the chance, I would devote the rest of my life to helping others struggling with addiction and despair, to prevent others from making the same mistakes I made. Parole would not just impact my life, it would impact families, communities, and the very idea that the justice system can be both firm and fair. Maine once had parole, and we can bring it back. not as a guarantee, but as a tool of justice and hope. Thank you for considering my story and my plea. I urge you to support LD 1941 and give people like me a path forward. Thank you.
Thank you for sharing that testimony.
Hi, welcome. I'm not nervous, you are. Good day, Senator Carney, Representative Kuhn, and honorable members of the Judiciary Committee. My name is Thasra Rosie Hilton. I'm humbly speaking to you as a born Mainer, a survivor of a violent attack, and a family member of an incarcerated individual here in our state. I also sit on the board for the Maine Prisoners Advocacy Coalition. I love my home state, flaws and all, and I do consider the fact that we abolished parole to be a cold-hearted flaw. The cold weather we're currently experiencing will give way to warmth and new growth, but there are people in our prisons that have made it through the coldest depths of terrible choices in life and are being denied any chance of bringing warmth to the communities they previously harmed. Even though they have served decades, learned, repented, changed, and repeatedly shown their capability of growth, there is no hope for them to spring forth in life. Parole was abolished here 50 years ago as of this year, and I believe that we have societally evolved past that choice, that we as a people believe in second chances. Maine's lack of parole sends a clear message that our system does not truly believe in redemption. I've shared my survivor status with you all just to illustrate my position here is not just one-sided regarding second chances for people who have caused harm. I relate to the concerns and fears that can come along with having someone who caused me permanent physical and emotional scarring not being incarcerated. Every person, every survivor has their own perspective on what justice and safety feel like. For me, I do feel that justice can only come to fruition when rehabilitation and forgiveness are at the forefront of the process. And I feel safer in a community that prioritizes healing over punishment. Along with my general thoughts on the world I want to live in, I am speaking on behalf of 4 generations of my family members that are hurting and feeling very hopeless right now. My baby brother, whose testimony you heard earlier, Leo, he was arrested for a horrible act right after he turned 18, and he's about to enter his 18th year of incarceration. That's longer than the lifetime of several youths in our family that have no memories of him outside of that prison visiting room. I interviewed everybody before I wrote my testimony so I could represent my family well. My niece and nephew, they're really longing for their uncle to be there to cheer them on for band performances and their upcoming graduations this year and next. My children are all adults now. They've grown up with this family separation. They and I are extremely saddened by the fact that now my grandbabies are going to have the same disappointments as they grow. My mother is in her 70s and prays to see her youngest child walk through her door before she leaves this earth. She's not promised another 32 years, and that's how much longer we have to wait without parole. There is no other option for my family. His absence is felt at every family gathering, and his support is needed as our mom ages. And there's a constant state of fear in the back of all of our minds that something awful will happen and he won't ever get to come home. We're just one family. We are one story, but there are many other families I've met in similar situations, and we would all really love a glimmer of hope. I'm going to wrap. Just with the current lack of parole, we continue to suffer with the pain that our family member caused to his victims and to our family. And I hear folks, I've heard them today, talk about paying a debt to society after a crime is committed. So why don't we let people truly do that after they've served a reasonable number of years? Right now, we tax-paying citizens are paying to house an aging prison population who could be out here working in the community and actually contributing to our society in a positive way. So thank you for listening.
Thank you for your testimony. Committee members, are there any questions? Yes, Senator Talbot Ross.
Thank you so very much. I want to first just acknowledge the courage it takes for you to be here today, to deliver this testimony, and to speak about your personal experience as well as your families. So I just wanted to give you a tiny bit more opportunity. The statement here, I feel safer in a community that prioritizes healing over punishment. That's a very powerful statement for me. I hope for my colleagues as well. I just want to hear a tiny bit more about that worldview that you have.
I have spent a fair amount of time in prisons and jails, not just because of my baby brother. My eldest son spent some time with Leo in Maine State Prison. I've met a lot of people who were incarcerated for one reason or another. And I have seen so many examples of people like my brother, people like Cuba and Joseph, who you heard speak today, who will go through the correct channels and they heal what was broken in them that put them in the position to cause harm in the first place. And then they are able to put great pathways for healing into the community by creating different programs and just by putting who they are and what they have experienced out into the world. And then I've seen other people who like somebody said earlier, they just sit around, they watch TV, they play cards, they cause more hate and discontent. And that is a broken person who just continues to be punished. There's no intervention to heal that person. So that punishment creates more harm within that person, and then they put it out into the community. And so if people are healed and take the work to heal themselves, why should they sit there with those same people who are not creating good? Like, they should be out here with the rest of us who are fighting to do good.
Thank you so very much. Thank you for being here today.
Thanks. See you.
Any further questions? Not seeing any. Thank you.
Okay, sorry. Bye.
You're all set.
My name is Luca Mellon. I'm here to speak in support of LD 1941. Thank you, Senator Carney, Representative Kuhn, and honorable members of the Joint Standing Committee on Judiciary. I'd like to share some historical context around Maine's relationship to parole because a lot of it is no longer true, yet we still have no parole, rendering our system, our criminal justice system, somewhat incoherent. My written testimony includes quotes by people describing what was going on at the time to show that Maine's parole officers and the parole board were both inadequately prepared to do their jobs at the time, and Maine's prison system at the time was not able to actually rehabilitate people effectively. Please compare what follows to what you know about Maine's Department of Corrections today. Maine's probation and parole officers had pretty serious problems. A white paper published in 1970 about Maine's system found that the POs were underqualified and undertrained. They needed instruction in how to actually supervise people, and they were often given the job even though they weren't actually meeting the qualification standards. They also didn't know how to help their parolees and probationers find the community resources that they needed. In other words, they were ineffective. Maine's parole board likewise had problems. The same white paper found that the parole board was 3 part-time people. They were also underqualified and ineffective at their jobs, and it made recommendations otherwise to have them be part-time and subject to certain requirements around qualification. The father of parole, the father of determinacy, Dr. David Fogel in 1975, described how people felt about parole at the time. It was subjective, subject to human whims and subjective standards, and it bred discontent within the facilities because people felt it was unfair. I say all that to say a system that is actually functional could work. It just really wasn't working at the time, obviously. This abolishing parole was part of a new criminal code in 1975 and 1976, which was a turn back towards punishment and away from rehabilitation. The rehabilitation programs at the time were found to be ineffective. The purpose of prison is punishment, not rehabilitation. That's a quote. The new criminal code was also meant to be reviewable. So notably, there were parts of this package of reforms in 75 and 76 that included capacity of a judge to return to a sentence and revise it, which was repealed and replaced with another version where the DOC could petition for someone to have their sentence reconsidered by the judge. That was also repealed later. I think our current versions are commutation and post-conviction review, which we've heard from Mr. Evangelos is not really happening right now. What did stakeholders at the time notice about parole? According to the AG, James Tierney at the time, the main experience is that although we certainly solved the problem of too early releases by a too liberal parole board, we did it at a tremendous cost by eliminating needed flexibility in a system which requires it if true justice is to prevail. The new system once again lacks the flexibility needed to deal with individual cases from a correctional perspective.
If you could sum up, please, in just a sentence or two.
I think the past is, this description does not describe our capacities right now. It doesn't describe what we see with the Department of Corrections, and it doesn't describe what would happen if this bill was passed. I think parole would be really different now. Thank you so much.
Thank you. If you could just pause for a moment.
Oh, yes.
Committee members, are there questions? Senator Carney.
Thank you very much, Representative Kuhn. Thank you for citing all of this research that took place in the 1970s in that era. I don't know how easy it would be for us to access this. So if you have PDFs of those documents, could you please send them to our committee clerk?
Yes.
Thank you.
Any other questions? All right, not seeing any. Thank you.
Good morning, Senator Carney, Representative Kuhn, and respected members of the Joint Standing Committee on Judiciary. My name is Benjamin Miller. I'm associate with Society Impact of Portland, Maine. We are a statutory public benefit company that helps state and local governments and community organizations create a more just, safe, and fiscally responsible legal systems, public safety policies, and programs. We are presently working with a community group in Maine and Maine judicial branch officials to create a pilot case diversion program in Monadnock County, Maine. I'm here today to urge the swift passage of LD 1941. For nearly 50 years, Maine has operated a one-way justice system. We have become the only state in New England to abolish parole. In doing so, we have traded a proven tool for rehabilitation for a system of permanent and high-cost incarceration that serves neither the taxpayer nor public safety. Currently, Maine spends between $75,000 and $115,000 per year to keep a single person behind bars. By contrast, supervising an individual in the community through a parole program costs a fraction of that amount. According to the Administrative Office of the Courts of the United States Courts, the average annual cost of supervising a released individual is just $4,742. That means that if Maine offered incarcerated individuals who have demonstrated genuine rehabilitation the opportunity for parole, taxpayers could save approximately $70,000 to $110,000 per person each year. Our neighboring states of Vermont has a successful parole rate of about 50%. If a similar proportion of Maine's incarcerated population were granted supervised parole, it could potentially save upwards of $50 million to $100 million per year, depending on the numbers of individuals released. Even if the percentage granted parole were significantly lower than 50%, the state would still realize substantial taxpayer savings. But this is not just about the bottom line. It is about the integrity of our justice system. The national average is that 95% of incarcerated people will be eventually released. Parole and parole preparation in prison are essential for successful reentry. Without parole, Maine lacks a meaningful incentive for incarcerated individuals to engage in the hard work of transformation. We are effectively telling people slated to be eventually released from prison that no matter how much they change, the door is locked until a calendar date decides they are free. This creates a stagnant prison environment that does nothing to prepare individuals for the terrible burdens of collateral consequences after release. When we lack a parole board to oversee structured and supervised transition back into society, we actually increase the risk to community safety. Parole works because it provides accountability and ensures that release can happen when it is demonstrably appropriate, not just after a certain amount of time has passed. It also provides the oversight necessary to help people secure housing and employment. These are the very things that keep our neighborhoods safe and reduce recidivism. Maine is currently an outlier. We are lagging behind our neighbors in New Hampshire and Vermont who use parole to manage their prison population in economically rational ways. We need to be in alignment with the rest of the country and New England, and we need to put Maine at the forefront of justice reform.
Thank you for your testimony. Are there any questions, committee members? Not seeing any. Thank you. Welcome.
Senator Carney, Representative Kuhn, and members of the Judiciary Committee. My name is Lonnie Graham. I'm submitting this testimony in support of LD 1941 on behalf of the Maine Medical Association and the Maine Osteopathic Association. Keeping people incarcerated is expensive. Estimates are that keeping an adult incarcerated in Maine costs taxpayers between $80,000 and $117,000 annually. I'm sure each of us can imagine good uses for such funds if they were not tied to incarceration. Reinstating parole is one solution, virtually guaranteed to reduce Maine prison population while at the same time assuring good outcomes for Maine communities. Let's start with the prison aging crisis. About 13% of people in Maine prisons are over the age of 55. The prison population is aging fast, with the percentage of incarcerated people over 55 expected to raise to 1/3 of the total by 2030. These are people who tend to have chronic diseases, such as diabetes, high blood pressure, heart conditions. At the same time, these older prisoners are very unlikely to be rearrested if released on parole. A well-run parole system could save thousands of taxpayer dollars while at the same time increasing the likelihood that an incarcerated person is prepared to return to his or her community. Another issue to consider is the importance of incentivizing incarcerated people to participate in programs and care that will help them become better members of Maine communities when they are ultimately released, as about 95% of them will be. The Maine prison population is made up of people who may not easily see the value of participating in rehabilitation programs offered to them. Compared to the general population, the incarcerated have lower levels of educational attainment, have experienced more adverse childhood experiences, and may be living with a mental health illness. A parole program could help this population to engage in necessary care services that will prepare them for release into our communities. This is a step that Maine needs to take. We hope that you will support parole in Maine. Thank you for your attention.
Thank you. Are there any questions, committee members? Okay, Representative O'Halloran. Okay.
Mine is if they don't have a suitable place to go home to, because oftentimes they're around the same people that got them in trouble if they're going home, or if they don't have one to go to, who's going to pay for where they'll be staying? They can't stay with family. And like, how would that look for this?
Well, yeah, that's an excellent question, and I'm sure others can take it up in work session, but a sort of a quick answer is that in the process of developing for parole, those are the kinds of considerations that are taken up with the parole board, and the person who is being considered for parole works to establish those options before they are released.
Yeah, I know they do that now, but I'm just kind of wondering how we would work that out, but I appreciate it. Thank you.
All right, thank you.
That'll be a good question for the work session. Any other questions? Oh, can you come back, please? We have another question from Representative Lee.
Exciting.
I think some of your testimony dances around this comparison that is in my brain, which is the cost of providing medical services to someone who's incarcerated versus the cost of providing medical services outside. And I'm wondering if you're aware of any studies that make that comparison. And it's certainly something you can give us.
Yeah, I think that would probably be better for the work session because it's extremely complicated. The kind of care that's provided in the prison is part of the problem in answering that question.
Thank you.
I'd like to just get a sense of how many folks are left in the room to testify in support of the legislation. Right, so we have quite a few left. And we should take a break. So let's take a break until 4 o'clock. And then we'll come back and complete the testimony. Thank you.
Yeah, so it's like for free. Yeah, yeah, like. It's like a reading a research. I think my eyes are crossing already.
No, I'm not. She good first, so this one. And this one.
Committee members, please take your seats around the horseshoe so that we can resume our work. We're resuming the testimony. We're going to resume testimony in support of LD 1941. And I know that there are additional people present in the committee room who still wish to speak in favor. So if that is you, please step forward to provide testimony. Welcome.
My name is Christine.
Oh, just a moment. We can help you with that.
Oh, good. Hello, my name is Christine Hay. I'm from Portland, Maine. And to Senator Carney, Representative Kuhn, and the esteemed members of the Judiciary Committee, I'm here to read a letter from a student, and because she couldn't be here. So I will hence read the letter. My name is Malaya Chadwick, and I am a Maine resident currently enrolled in the degree program to obtain a master's in forensic psychology. My educational pursuits were in the part of a result of the internal conflict I experienced after publicly encountering the man who was charged with manslaughter and the death of a close friend. At that point, he had served his time and had gone from a teenager to a man almost in his 30s, his brain reaching maturity after having been incarcerated for almost 7 years. After 9 years, he was thrown back into a world that had moved on without him. His girlfriend, throughout the entirety of his teens, had married someone else. The building where he had been told his job would be waiting for him was torn down, and the home where he had resided had been removed with nothing built to replace it. His actions robbed him of time, but his time took everything from him. When I was capable of overcoming the unexpected encounter, I could not help but think of how much of his life had been lost. I was not filled with the resentment that had seethed through me those many years ago, but instead a profound sympathy. By that point, my education had challenged my beliefs that were rooted in fear as a result of being a secondary victim. What I learned had drastically changed my perspective, opening my eyes to the dangers of failure to actively work towards reintegration. As I have witnessed in my own life and educational research, evidence indicates that many criminal offenders begin as victims to some capacity. The man who took the life of my friend was no exception. His tumultuous youth, pocketed with traumas and neglect, this overlap between victimization and criminal behavior could be a focus in our efforts to improve the justice system. Hope is a powerful motivator, and the lack of parole in his state undermines the value of rehabilitative efforts. Parole is a vital tool for addressing overcrowded prisons, reintegrating valuable members of the society, and acknowledging the starting of a number of perpetrators who began as victims. I am an advocate for parole because my education and life experiences have illuminated the importance of working to return rehabilitated individuals to society and restore a sense of normalcy for both offenders and their families. Through utilization of rehabilitative efforts, risk assessment tools, and community participation in reintegration, parole can be utilized to mitigate unnecessary prolonged incarceration. I urge you to vote ought to pass on LD 1941. Thank you for your time. Sincerely, Malaya Chadwick of Winterport, Maine.
Thank you very much for reading the testimony for us.
Thank you.
Okay,
Oh, no questions.
welcome.
Good afternoon, honorable chairs and esteemed committee members. My name is Carter Reed, and I'm here today in support of LD 1941. I'm a husband, father, homeowner, and business owner here in Maine, and a graduate of Maine Maritime Academy. Most importantly, I am a concerned and conscientious citizen. Over the years, I've been a volunteer with the United Way, Habitat for Humanity, Rebuilding Together, and Epica. I've worked with high-risk youth in programs like ROCA, UTEC, Job Corps, and Youth Build, and I've spoken throughout New England on social and criminal justice issues. I'm also a consummate Good Samaritan. So if you've ever been stranded on the road, I'm the guy who pulled you out of the snow, changed your tire, gave you gas to help get you on your way. I haven't eradicated world hunger, poverty, or addiction, and I've yet to find a cure for cancer. But I promise you, I work every day to make the world around me and our community a better place for our children and future generations. But if I were originally from this state, I wouldn't be able to do any of those things because I was given a life sentence as a teenager. Instead, you, the taxpayers, would be paying millions, possibly tens of millions over the course of my lifetime to warehouse me in a prison forever. That's not justice, and certainly wouldn't serve anyone's interest, including the victims. Nobody knows better than me that no amount of good I do in the community can bring back the life I took or erase the pain and suffering that I caused. So instead, I live my life every single day in a way that honors Jason Robinson and his family, and I strive with every bit of my being to not only be a better person, but to make a difference for the better. And I can say humbly that I absolutely do that. Lastly, please don't think of me or look at me as an anomaly. I am far more the rule than the exception. So I urge you to take this opportunity to support justice here in the state of Maine and create a true path for healing, restoration, and redemption. Thank you so much for your time, and I urge you to put this out favorably.
Thank you very much for your testimony. Let's just see if there are any questions for you, if you don't mind. Committee members, are there questions? I'm not seeing any. Thank you. Next person who wishes to speak in support, please step forward.
Senator Carney, Representative Kuhn, and members of the Joint Standing Committee on Judiciary. My name is Carly Fisher, and I'm submitting testimony today on behalf of the Maine Coalition Against Sexual Assault, or MICASA, the organization which represents and serves Maine's sexual violence prevention and response programs, as well as Maine's children's advocacy centers. We are here today in support of LD 1941. Historically, MICASA has approached parole reform with caution. Earlier proposals, we felt, did not adequately address concerns consistently raised by survivors, nor do we feel that they included the level of investment needed in treatment, reentry supports, and community resources to meaningfully reduce recidivism or prevent further harm. But after several years of working with advocates to improve the parole bills being presented, and for the reasons outlined in our written testimony and attached position paper, MICASA and our member centers ultimately decided to support this policy change. As with many issues, survivors of sexual violence do not experience or view parole in a single uniform way. This is particularly true when the harm was committed by someone close to them, which is a dynamic that also helps explain why many survivors never enter the criminal justice system to begin with. Some survivors see structured, supervised release as a meaningful pathway towards accountability and healing. Others justifiably fear that early release will threaten their safety or reopen trauma, especially if it's unexpected or under-resourced. Because we only saw the most recent amended language yesterday, we have not yet had the opportunity to review the scope of the changes since the last version we examined. This matters to us because the directors of MICASA's member programs reviewed the prior language section by section in developing our position. We do plan to complete that review and will provide the committee with any additional comments as needed. With that said, in the last version, we saw genuine attention paid to survivor needs, a deeper commitment to trauma-informed practice, and broader recognition that community-based supports are essential to reducing recidivism and promoting long-term safety.
In recent months, we've listened closely to survivors, advocates, and partners across the criminal legal system. Their perspectives are nuanced and sometimes conflicting, but always deeply human, and together they point to the need for a parole system that's grounded in safety, dignity, and evidence-based practice. We support this bill because with the right resourcing and careful implementation, parole reform can respond to the realities of sexual violence, trauma, accountability, and reentry, and can provide a more victim-centered, structured, and supervised release than sudden discharge at the end of a sentence. At the same time, even with the thoughtful additions around victim voice and choice, the bill does not yet fully address what is required for a successful parole system. Strong community-based supports are essential for both those who have caused harm and those who have been harmed. And that includes victim advocacy staffing to support post-conviction reporting, safety planning, and the prevention of re-victimization. All of those are needs that the Parole Commission itself has identified as critical. A successful parole system must also include provisions for ongoing community-based support for those convicted of sex offenses. This supports safety and healing not only for the public, but also for the person who caused harm and others in the community. Without treatment and support, the risk of further sexual harm increases. Thank you for your consideration. Be pleased to answer any questions.
Thank you very much for your testimony. Committee members, are there questions? Yes, Representative Lee.
Trying to interpret your testimony, are those additional community supports something that you think should be part of the bill, or you're saying that we can't have a parole system until those other community supports are provided?
Well, part of what we really admire about this draft of this bill is that that's written in sort of in the meat of the bill. There's a lot of attention paid to victim services. I remember looking at the first time, control Fing, looking for the word victim, and it was everywhere, right? It's built in throughout in this version, which really meant a lot to us, seeing that was taken so seriously. And also there's a lot of mention of investment in community-based supports. I don't think we're alone in knowing how important that is, but this time that's really been baked into the language. So we want to make sure that that's captured in a fiscal note and also make sure that there are victim service providers at every step of the way to make sure that this gets implemented properly.
Any other questions, committee members? Yes, Representative Crusoe.
Thank you. Will you be at the work session for if we have questions with details?
We'd be happy to be.
And if you're able to provide us with your any updated testimony based on your completion of the review of the amendment, we'd appreciate it.
We will, and we're between public policy directors at the moment, so thanks for your grace on that.
Thank you. Any further questions, committee members? Seeing none, thank you. Is there anyone else present in the committee room who wishes to speak in support? Please step forward. Welcome.
Good afternoon. My name is John Glowa Senior. I live in South China. And I'm speaking as a private citizen and as an independent candidate for governor. I just want to express my complete support for this legislation. And in my opinion, it's long overdue. Thank you.
Thank you. Let's see if there are any questions. Committee members, are there any questions? No, thank you.
Thank you.
Is there anyone else present who wishes to speak in support? Welcome.
Hi, thank you so much. Senator Carney, Representative Kuhn, and esteemed members of the Judiciary Committee. My name is Eli Duran McDonald. I'm from Bar Harbor, and I work as a policy director at Maine Youth Power, which is a youth-led youth movement working throughout rural and suburban Maine to win human dignity, equity, and a livable future for all. Today, I'm speaking on behalf of my colleague, Anjit Tahitsi, and the whole of Maine Youth Power, as I urge you to support LD 1941. Unlike a lot of people that have spoken and a lot of orgs that have spoken today, well, Maine Youth Power does not exclusively focus on the criminal justice system. Our membership understands the power of parole, and we envision a Maine criminal legal process that is focused on rehabilitation as opposed to increased incarceration. This bill would be a vital step towards that vision. Parole is a rigorous process that allows incarcerated individuals, specifically those who have demonstrated growth and accountability, an opportunity to be released and transition back into society with support and dignity. From a youth perspective, many long sentences are given to individuals who commit these crimes at a young age and are now unable to have their sentences reviewed. Mistakes made at a young age could seal young Mainers' fate to a life of imprisonment or at least decades, as opposed to the opportunity for growth and reintegration. Other youth in Maine have loved ones incarcerated without the opportunity for parole, which can create long-lasting trauma and perpetuate cycles of instability. Instead, we believe in smart, humane reforms that create real pathways back into the community. Parole is one of those pathways. Once again, I urge you to support LD 1941. Thank you.
Thank you very much for your testimony. Just one moment.
Oh, yeah, sure.
Committee members, are there any questions? Could you just repeat your name? I didn't. catch
Yeah,
it.
sure. It's a long one. Eli Durand McDonnell.
Thank you.
Thank you, sir.
Is there anyone else in the committee room who wishes to speak in support? If so, please step forward. Welcome.
Honorable Senator Carney, Representative Kuhn, and esteemed members of the Judiciary Committee. My name is Deborah Sachere, and I'm a resident of Brunswick. I'm speaking today in strong support of LD 1941. I come before you today as someone who is motivated by facts and figures. I'm a researcher and a PhD student who also has a loved one currently incarcerated with a de facto life sentence in Maine. I moved to Maine to be closer to my partner, and I want to help make my new community safer. Based on what I have learned about parole, and specifically the type of support and that this parole bill will provide, I believe parole can help make my new community that place. Parole is the safest, most clearly demonstrated way to implement a supportive reentry process. However, some argue that parole is too progressive and shows that we are soft on crime. So does that mean Texas is too progressive or Alabama too soft on crime? The answer is clearly no. So I'll quote former Republican Governor of Kansas, Sam Brownback, explaining that without parole, recidivism rates are too high and create too much of a financial burden on states without protecting public safety. My state and others are reinventing how we do business. If those red states can do it, why not Maine? Parole would have major benefits on Maine's economy, support a safer return of members to community, and provide greater care to victims than the current system. In addition to supportive reentry, I believe Maine must care for our victims and survivors of crime. We must listen to our victim survivors and ensure that their needs of community safety are heard first and foremost. By a margin of 2-1, victims prefer that the criminal legal system focus more on rehabilitating people who commit crimes than punishing them. I plan to support meaningful accountability in wrongdoers and provide avenues of voluntary financial support to victim survivors of crime by building on the success of the Maine model of corrections. In fact, by a 28-point margin, Maine voters believe that too many people serve long prison sentences and that we should be doing more to get incarcerated people into rehabilitation and job training rather than keeping them incarcerated. So it's based upon these facts that the broad support of Maine citizens and the stated desires of survivors that I urge you to vote to pass on LD 1941 today. Thank you.
Thank you very much for your testimony. Committee members, are there any questions? Representative Lead?
I don't have your testimony yet, but are there citations for the statistical claims?
I actually gave you the full
awesome.
records. And on these, there's also citations at the bottom for more information for both.
Thank you.
Yep.
Additional questions, committee members? Seeing none, thank you.
Thank you.
Is there anyone else present in the committee room who wishes to speak in support? Welcome.
Hello, to Senator Carney, Representative Kuhn, esteemed members of the Judiciary Committee. My name is Nicole Lund, and I'm a graduate student at the University of Maine in Farmington studying counseling psychology, and I'm also a certified alcohol and drug counselor. My interest in pursuing a career as psychological clinician specializing in addiction treatment stems from my lived experience as a survivor of violent crime and a person in long-term recovery. I am incredibly grateful for the second chance I was given through diversionary programs, rehabilitation, and substance use treatment services I received in lieu of prison when I was actively using in Massachusetts. Nobody at the time of my active use could have predicted when I would rehabilitate. I'm also grateful to have overcome my adversity and that I am able to be here today to talk about second chances. It is impossible for me to not believe in a person's ability to rehabilitate and change because I have changed immensely since my time engaging in criminal behavior, as have many other people who were once in my position. People are capable of change when they are provided the resources and support to do so. And a judge at the time of sentencing has no way of knowing how long it will take a person to rehabilitate. Without parole as an option, we are asking a judge to do the impossible. He must blindly guess at what point in the future a perpetrator will no longer be a danger to society. We are asking a judge to predict the future and decide how long a person must be warehoused before they will age out of criminal behavior. The concept of aging out of crime is not anecdotal. One of the most robust relationships in criminology is between age and crime. Criminality increases in adolescence, peaks in the late teens and early 20s, and then continually decreases as a person ages. This relationship is the foundation for the well-known age crime curve, which underlies predictions and risk assessments about future offending. Inhibitory control, a primary executive function, affects a person's ability to stop themselves from an automatic response and think through the consequences of their actions. Research has shown young adults lack the same level of inhibitory control as older adults and are more likely to engage in dangerous or problematic behavior such as abusing substances, violence, and recklessness. It is well understood in the mental health community, adverse childhood experience, or ACEs, greatly increase a person's likelihood to become incarcerated due to maladaptive behavior such as problematic substance use. These ACEs, when not addressed, can manifest as post-traumatic stress disorder, which results in automatic responses. PTSD is a treatable mental health condition linked to substance use, antisocial or criminal behavior. Traumatic experiences can manifest themselves as nightmares, flashbacks, intrusive memories, antisocial behavior, persistent negative beliefs and emotional states, recklessness, and self-destructive behaviors. The sufferer finds himself reliving the traumatic event as though it is happening to them again and again. If a person has suffered trauma as a child, they are much more likely to engage in dangerous or antisocial behavior and become incarcerated. PTSD occurs at significantly higher rates in incarcerated individuals compared to the general population. Incarcerated individuals have also been found to have experienced a significantly higher rate of ACEs. It is estimated 65% of the U.S. prison population meets the criteria for substance use disorder. An additional 20%, while now meeting the full criteria for SUD, were under the influence at the time their crime was committed.
Could you please wrap up
I'll
in a
wrap it up.
sentence?
It is a shameful thing for our society to incarcerate people suffering from mental health conditions without ever offering the opportunity for them to heal and reintegrate. I have witnessed firsthand people can change when they are given the resources to do so. Parole offers a person the motivation, encouragement, and support they need to heal, grow, and change. As a Maine resident, I would welcome a paroled individual into my community and happily support them in their recovery. Thank you for your time. I urge you to vote ought to pass on LD 1941.
Thank you. Committee members, are there questions? Not seeing any. Thank you very much. Is there anyone else present in the committee room who wishes to speak in support?
Hello,
Welcome.
respected members of the Maine legislation. My name's Nicole. I actually didn't write something down for mine. I'm just gonna go off my chest. I was incarcerated in the Maine Department of Corrections. What led to my incarceration was a pretty serious substance use disorder. The opioid epidemic definitely impacted my family, multiple generations. And then I went to prison because of it. And I definitely caused harm and needed some type of action in my life. And my social justice friends might disagree with me, but I was somebody that benefited from the Maine model of corrections. I earned a college degree. I was able to regain some hope in my life. And when I think about when I was sitting behind the prison walls, I was at the reentry center, but I was still incarcerated. And I was thinking about what my life would look like once I was released. I didn't think it would be this beautiful. I knew I wanted to do great things, but now it's like I help other people in the community. I work with youth. I'm an executive director of a nonprofit, and I work closely with these partnerships with DOC, with organizations that work inside and outside of corrections. And I feel like I just couldn't imagine doing all the things that I did and sitting inside a prison and not being able to see what the outside world and use the main model of corrections and use it to do something significant with. Somebody that's incarcerated, Sean Libby, is doing amazing work, has a full-time job, lives in the earned living unit. And he might not have a way out until he's very old. And to me, that's just really disheartening. I know that he could be a great member of this community, and there's a whole bunch of other people that I know would do just as good as they could. And yeah, thank you.
Thank you for your testimony. If you could just wait a minute, there may be some questions for you. Thank you.
Come back up here.
Committee members, are there any questions?
Perfect.
Okay, thank you. Is there anyone else who wishes to speak in support of this legislation? If so, please step forward.
Oops. I bet you're all taking a sigh of relief that I'm the last person to stand up. I won't take it personally. Thank you so much, Senator Carney, Representative Kuhn, and distinguished members of the Judiciary Committee. My name is Jan Collins, and I'm Assistant Director of Maine Prisoner Advocacy Coalition. I have some testimony before you that talks about how much money we have spent since the 1970s on fighting drugs, fighting crime. We've spent trillions of dollars. The war on drugs and actually has not changed the number of people who actually have a substance use disorder, even 1%. Trillions of dollars, just throwing that out there. You can also see how much the expenditures have changed for corrections over the last 10 years. They've gone up 10 times. Is there anyone here who feels 10 times safer than they did 10 years ago? Just raise your hand if that's how you feel. So we're spending a lot of money and not getting much for return. But the truth is that money has to come from somewhere. What we have seen is that the kinds of things that actually provide a safer community are getting less funding than things that make our communities actually less safe. So those things that we know protect you from becoming incarcerated are things like medical care. If you have a substance use disorder, if you have a mental health issue, it's really important to have medical care in order to stay out of prison. Housing. The Supreme Court has now said that you can actually criminalize homelessness. Education. The higher your education, the less likely you are to go to prison. We now have 10 times more people with severe mental health issues in our prisons than we do in mental health hospitals. That's shame on us, really, shame on us. So the things like education, housing, medical care, food, and job skills are the things that actually make our communities safer. And yet, as we watch the corrections and policing budgets balloon, those things get less and less money. I want you to note that there were 4 groups that testified on this bill who actually represented victims of crime, as well as very many individuals in this room who are victims of crime, including myself, of violent crimes. I have members of my family who have died from domestic abuse. I have sustained domestic abuse and simple abuse. But of those four groups, Restorative Justice Maine, MICASA, Healing First, and MCDEV, which chose not to be here to testify, but did submit written testimony in opposition, they all supported this bill. To the person, they all supported this bill.
Thank you for your testimony. Could you please wrap up in a sentence?
Please support parole, make our communities safer.
Thank you.
Thanks.
Questions? Yes, Senator Talbot Ross.
Thank you, Madam Chair. I just wanted you to say those four groups again. I've been in and out of the committee room throughout the day, and I know how important it is to some of my colleagues that victims' voices are considered and valued and seen. And so just for the record, would you just name those groups again? Because it's a really important point.
Absolutely. Thank you. Restorative Justice, Maine, MICASA, Maine. Yeah, what do those? What does it acronym?
Maine Coalition.
Coalition Against Sexual Assault. Thank you. Yeah. Healing First, which is a group of survivors who have come together to support things that actually heal our communities. And MCDEV. And I do want to thank the sponsor of this bill, Representative Milliken, for bringing those groups together and actually working hard to meet the needs of victims for this bill. So thank you, Representative. I also want to note very quickly that we do have people on parole in Maine, and we have ever since 1976. We have a parole board in Maine, and I'm hoping Richard Harberger will be on Zoom and testify to that. The people who are on parole in Maine now are from other states.
Thank you.
Yes.
Representative Kuhn.
Thank you. Just a clarifying question. I heard you say that MCEDV was one of the entities in support, but then I thought you also said they submitted testimony
No, I
online
said
in opposition.
Yeah, they're in opposition.
Okay.
Yeah, but they've come a long way.
Okay.
I have to say, they've come a long way, and
Okay.
that's all due to Representative Milliken.
Okay.
She's worked
Just
really
wanted to
hard.
clarify. Thank
Yeah,
you.
Yeah. I'm sorry if I said it the other way around.
Yeah.
Okay.
Any additional questions, committee members? Not seeing any. Thank you very much.
Thank you so much. Appreciate your time. A long day.
We'll now hear, I think we're now going to. We're going to take testimony from all of the people who are physically present in the committee room in opposition, and then I know that we have several people signed up to provide online testimony. Please be patient. We will reach you as soon as we can. So if you are in the committee room and you wish to speak in opposition, please step forward.
Thank you. Senator Carney, Representative Kuhn, and distinguished members of the Joint Standing Committee on Judiciary. My name is Sue Salisbury, and I represent House District 128, which is part of Westbrook. I am here today to testify in opposition to LD 1941. I just want to call out a couple of things. I know there was an amendment issued, so I don't know if anything that I say today might go against that. I haven't had a chance to review that, so perhaps some of my questions might be addressed there. I do want to take the opportunity to thank everybody that did speak in favor of the bill. I'm glad that I had the opportunity to hear all of that testimony and hear some of those comments and some of the stories. I appreciate that. And I do want to thank the bill sponsor and the advocates for their work on this bill. Since the last iteration of the bill in the 131st legislature, there has been more attention paid to the victims and their families, as well as some other issues that were raised, and I do appreciate that. Having said that, all of that, I am still here in opposition to this bill. I want to make it very, very clear that I am not opposed to parole being given as a new sentence.
I'm not opposed to parole being given as a new sentence. What I am opposed to is a person currently sentenced to life in prison being offered the opportunity for secured community confinement or parole. In Maine, there are approximately 50 people that are serving life sentences. When that sentence was given, the family and the people left behind, because they are, in most cases, were not victims left behind, were given a sense of security that that person who committed that crime would be behind bars for the remainder of their natural life. If we offer those individuals the opportunity to apply for parole or secured community confinement, we are taking away that security. I cannot speak for any victim's family, and I'm sure, we've heard today and we'll hear throughout this process, some families would be okay for the opportunity for parole. However, for the families and loved ones who are not okay with parole, forcing them to be a part of the parole process now is re-victimizing them. We are telling them that what they went through has no value. The only concern is with the incarcerated individual who, through this parole process, will be able to work with staff, counselors, and lawyers. They will be able to share what they have accomplished while incarcerated. You've heard a lot of that today about educational opportunities, rehabilitative opportunities, including job opportunities, all things that their victim does not have. I want to point out a few sections of the current bill. Again, I haven't looked at the amendment that I have concerns about. The first section was about that this bill applies to all people currently incarcerated. That would imply that all current residents could apply for parole. There is what I'm calling a companion bill, LD 648, an act to expand secured community confinement, that basically almost makes it mandatory for anybody sentenced before they're 26 to apply for SCCP. So I just want to point out the final thing I'll say, a reminder of the people serving life in prison right now. We're convicted of tying up, sexually assaulting, and murdering a neighbor, convicted of murdering a 12-year-old girl, convicted of murdering a 4-year-old stepdaughter by putting her in an oven, convicted of murdering a couple in front of their kids, convicted for killing 3 people, convicted for shooting 2 people after going on a rampage. There's 2 other sections that you'll have an opportunity to read my testimony. And again, they might be addressed in the amendment. I'm not sure. But I am very concerned about the amount of time as well that it talks about. One section talks about the wording about parole denial. It says the wording 1 to 5 years being notified of parole. Again, that drags out the process. It's not only stressful for the resident, but also those that have been impacted by this. And I want you to refer back to, it's mentioned at the MCEDV testimony that was provided back in November when you had your information session. Really very powerful information, and I hope that you have an opportunity to review that. I do want to reiterate my appreciation for the work that's gone into this bill. I think more work needs to be done.
Thank you.
So
if you
thank
can wrap up in one additional sentence, please, if you have one.
No, that was it. Thank you.
Thank you. Let's see if there are any questions for you. Committee members, are there any questions for our colleague? Yes, Representative Lee.
Am I understanding correctly that your biggest issue, I know you have some other issues with the bill, but is your biggest issue that it applies retroactively rather than just prospectively?
Yes. If this bill was solely about parole being offered going forward, I would be in support of the bill with some, the parole things and the different concerns. But if this was going forward, then I would be in favor of this bill.
Additional questions, committee members? Could you elaborate on your answer, please? Why that makes a difference for you?
Because one, some of the things that I talked about in my testimony are that we know as a state, we are lacking in mental health and behavioral health, substance use disorder care. And if we start going back through people that are already sentenced to life in prison, and we don't have services available, we already know that we're lacking in a lot of services. If we aren't able to provide those services for those people that have been incarcerated, we're setting them up potentially for failure. I think that we're putting the cart before the horse. If we're looking at going forward, where at sentencing, the judge has the opportunity to say, we know that parole could be an option for you because now we have these services available for you that we can offer. And then that would be more likely to set somebody up to succeed. But right now, I'm having a hard time wrapping my mind around someone that was sentenced to life in prison and being given that opportunity to change that completely and being allowed to apply for parole or secured community confinement. And the victims' families and the first responders, the police, the fire, the EMS that perhaps were on the scene, all of the people that were impacted in some way to that original crime now being part of parole. So they've had this feeling, this sense of security for X number of years, 20, 30, however many years. Now being told, we've reinstated parole and it can be done retroactively. So the person that committed the crime, and the information that I got was just a quick Google search. One, the case of the man that is incarcerated by putting his stepdaughter in an oven, I know very well. The first responders, there were originally 9. I believe there's 1 left working in EMS. Some have passed away, and they passed away because of suicide. In those cases, the people left behind, families, first responders, being re-victimized, that sense of security perhaps that was given to them being taken away is what I'm really concerned about.
Thank you. Any other questions, committee members? Senator Talbot Ross?
Thank you, Madam Chair. Thank you for being here, Representative Salisbury. I just, now that you've clarified your opposition to retroactivity, it generated a question. And what I think you said was it's because the lack of mental health services and substance use disorder services, they're not able to cover the acuity that one might have after serving so much time in prison. And it was like putting the cart before the horse. I'm hoping I'm getting it right. And what it started to, I started to think about is in applying for secure community confinement, you helped me understand this correctly. This is my question. In applying for the SCCP program, one has to have a plan in place that then confirms that their housing and these services are, and maybe employment, they're all put in place. The same would be case would be made with an application for parole. So help me understand, again, your concern that the services aren't in place. If you're applying for these programs, you would have to have them in place in order for the Department of Corrections to grant you that release.
Sure. Thank you for that question. So I think basically you just said it yourself. We're setting them up for failure because we know we have a housing shortage. We know we have a mental health shortage. We know we have shortage of services. So we're saying this potentially an influx of people applying for SCCP or parole set all those things up. We don't really have that available because people that have not been incarcerated are struggling to find housing, to find jobs, to find mental health, to find all of those things. So people that have never been incarcerated are struggling to find that. So now we'll have an influx of people struggling to find those same things. So we're setting them up for failure. So again, that's my concern.
I appreciate your response and I appreciate you being here and sitting all day to be here. I'm going to turn my attention to the chair. So thank you. For the work session, I think we should get more information on SCCP and the process that one has to undertake. And what I know, I see the Deputy Commissioner here, the process one has to take in order to be granted that program. It's a direct correlation. Thank you. Thank you.
Is it possible I guess it's not possible for me to ask a question that you could maybe have for your work session related to what I've heard
You're
today?
going to suggest something that you
Yeah.
feel the committee should look into? Go ahead.
Yeah, we've heard a lot today about what the cost is for a currently incarcerated person. What is the cost associated with someone on SCCP or someone that would be on parole? What would that cost correlation be?
Okay,
That'd be
thank
good
you.
to- Thank you.
Thank you, Representative.
Is there anyone else present in the committee room who wishes to speak in opposition? If so, please step forward.
Good evening. Senator Carney, Representative
Welcome.
Kuhn, and distinguished members of this committee. I am Anthony Cantu. I'm Deputy Commissioner, Maine Department of Corrections. And I'm providing testimony today in opposition LD 1941, an act to implement recommendations of the Commission to examine reestablishing parole. It is our department has consistently expressed the opinion that reinstating parole is unnecessary. Given good time credits and supervised community confinement, as CCP has been alluded to, the parole program contemplated by this bill would be complicated and expensive. The bill would require a new 7-member board to hold hearings within 60 days of all parole applications and would require the department to provide full records on the applicants within 30 days, leaving little time to redact victim information and giving the board just 30 days to review this record, no matter how large that may be. Some unstated entity must also administer an actuarial evidence-based risk assessment for every parole applicant and every time someone is accused of violating parole. The board would have to make a decision on parole within 2 weeks of the hearing. An applicant can turn to the court if dissatisfied with records received from the department, requiring the court's resources and attorneys to defend the department's process. Not to mention the applicants granted parole would have to be supervised by department employees in the community, and the amended version of the bill would require a court instead of probation to address technical violations of parole. The process anticipated by the bill would require massive changes to the resources of the department, particularly in our adult community corrections, who've been tasked with supervising parolees and summoning them for violations and obtaining warrants for their arrests. The bill would require large-scale changes in criminal court processes, Attorney General resources to defend the department and the board, and potentially appointed counsel for the parole applicants, though it's not very clear in this bill. Unlike parole, SCCP already set out in statute permits prison residents to spend the last 30 months of their sentence in community supervised by the department through probation. The program is managed by existing departmental staff and allow individuals to live at home, residential settings, go to school, work, be with family, travel, and generally live like anyone else in the community for the last 30 months of their sentence. In the past year, 2025, the department released 107 residents to the community under SCCP. The program has a high success rate. The women's successful completion rate for SCCP in 2025 was 91%, and for men, it was 82%. These high successes rates reflect the strength of these plans these residents created and the effective incentives that SCCP statute creates for these residents who want to remain in the community. Department would like to expand SCCP, but like we've just heard, there are barriers to that, such as affordable housing and other factors that would still exist for people under parole. And to summarize, and as you have the testimony in front of you, over the last 5 years, the department has served and supported over 600 people in SCCP. Those are real numbers. And I'd also like to highlight the other incentives that are in place of the department that provide pathways for people to progress through. Thank you.
Thank you for your testimony. Committee members, are there questions? Yes, Senator Talbot Ross.
Thank you. I just have a very quick question, and I want to say thank you to the Deputy Commissioner for being here. I also just want to say thank you to the Deputy Commissioner for his work on all of the rehabilitation programs that are happening at the DOC. You're one of the leaders in the field, and I just want to say thank you. I know from
Thank you, Senator.
all of the work that I do, you are part of that work. So I appreciate you being here today. I just have a simple question about the demographics of SCCP. I've been asking for them for a couple of years now, and I appreciate looking at the rates of women versus men. But how difficult is it that you can give us the data, the demographics data on how many people apply and that racial background, breakdown, how many people get approved, how many are denied, how many move on, that kind of level of detail for SCCP. Is that possible for you to get for the work session?
Yes, that was going to be my question. If that's something that the analysts would want to just make sure comprehensive, that we capture all the areas of the demographic pieces, we'll work on that. Provided for the work session.
It would be helpful. Thank you so very much again.
You're welcome. And if you could provide the analyst, if I may ask, just a time frame in which for us to be looking for that
Oh, that's a very good question. I'm going to look at your testimony, see where you're citing just 2025.
No, that was
No.
just one paragraph in the testimony.
Well, how long do you have it? How many years? How far does it go back?
Would it be fair to go 5 years?
Let's do 10, just because you
We'll
gave
do
me
10
the-
years.
You gave me a window, so.
Okay.
I thought I'd open it a little, yeah. Let's do, yeah. Do I have an 8? I'll do 10 years. Thank you. Thank you, Madam Chair.
You're welcome. Yes, Representative Otto.
Thank you, Madam Chair. In that data, can you also provide the number of residents who are eligible, total residents who are eligible, applying or not applying or denied, all of them?
Yes.
Thank you.
Representative Lee.
I'm gonna ask a very high level 400,000 foot question generated by some of the testimony we heard earlier. And I join Senator Talbot Ross in complimenting the work that you've done to create the main model.
Thank you.
Which I think is focused greatly on rehabilitation, empowering people and restoring their lives. And we heard earlier some testimony that says that for some people, that main model is not achievable for them because they know that there's no way that they're ever getting out of prison. And I'd like to hear your response to that.
I think that regardless of someone's sentence length, the opportunities are laid out. And I think we recognize we have to be very responsive to what that looks like. Shorter term sentences are going to need to require probably a little bit more direct and robust and more acute response, just given the short time frame, coupled with whatever their individual plans are, risk assessment, so on and so forth, looks like for them too. I think that we have heard some stories from members of today that have shared backgrounds of individuals with very long sentences. What I will share is that my experiences, starting from the foundational level as a correctional officer in this department to where I am today, I have seen individuals, regardless of their sentence length, take advantage of the resources and what's available to them. We have a lot of critics in this field. Why provide college education for someone that's never leaving? We have not hung our hat on that statement. We say, here are the opportunities, please pursue if it's available, which it is available. So I think there's a different myriad of educational opportunities, vocational opportunities, programming, and other opportunities that are there. People have to take advantage. And we've also recognized people take advantage of those things at different lengths of their stay as they are wanting to. We can't necessarily force everyone to do what we feel like it may be right for them. They have to be the ones that carry on that. Welcome.
Are there additional questions, committee members? Yes.
Thank you, Madam Chair. As I'm hearing information requests and potentially from someone who testified beforehand, curious, do you track the amount of individuals released on the community confinement program, or even just released from prison in general? How many of them go on to be or to benefit from social services, i.e. housing, housing assistance, heat assistance, food stamps? Is that something that you track, or would that be more of a question for DHHS?
We track some of that information that's available.
Okay.
Part of the infrastructure issue we have is systems not communicating bilaterally. Some information that we may have are who take on opportunities for benefits through main care are one, but we can only track that information so long. Our counterparts in HHS within OMS or main care office may be able to have that information more readily available than the department.
Okay, would it be possible for what you have available to try to provide that to us? And it doesn't have to be 10 years. It could be 12 years. I'm just kidding. If maybe just the last couple of years, right? If we kind of can see kind of an idea of how many are coming out of the prison system and then moving right into relying on social services.
Okay, I can do that. And I will share just to answer maybe a part of your question. Those who do transition to SCCP are eligible for main care if they meet all the other eligibility requirements like anybody else.
Okay, thank you. And then
I just wanted to ask, how complete will that information be? Because I think you said that you're not able to necessarily track that. And I just don't want us to get something and assume that it's 100% accurate when it's only a small.
I think to be fair to the representative's question, that if we focused on main care, that may be one entity. And I'll report back or try to get to the analyst ahead of time to say, we cannot track X, Y, like housing information,
Right.
for example. And that's also going to be, I think contingent on the time frame and when the work session may be scheduled for as well.
That's fair.
I want to recognize Representative Henderson again.
Yes,
'Cause
thank
I
you.
cut her off earlier.
Thank you, Madam Chair. That was actually going to be part of my information request for the analyst, was that if he could reach out to DHHS with a request to see if they do track and yes or no, and if the answer is yes, that they could provide us with as much accuracy as possible, the amount of individuals. Like if we know how X amount of people were released from prison in 2024, whether through community confinement or otherwise, and then how many of those individuals are now relying on main care, on housing, on food assistance, that type of thing. Trying to get fiscally trying to get a large scale picture of the fiscal impact to the state of Maine.
Thank you. Are there other questions? Yes, Representative Lee?
Now I'm gonna make Representative Henderson's information request way broader, because it seems to me that an important component of that would be not just year one after release, but year 5, right? So I would guess that the number of people who are receiving public assistance in year 1 is very different from year 5 after release.
It may be helpful for you and our analysts to work together on what's possible to do, and would give us accurate, helpful information. I think you understand kind of what we're looking for.
Absolutely. Once you all sort of compile exactly what you want to the analysts, we'll work with them to prepare what we can with the information at hand.
Okay, thank you. Yes, Representative Caruso?
Thank you for your testimony. I know, I have a few things that I'm trying to figure out in my mind, and I know you didn't get a chance to read through all of your testimony. One thing I have is, on towards the bottom of page 2, you said that you were just explaining that the SCCP, how it works and the reviews, and you said that, that the reviews are different from what's proposed in LD 1941, which relies on a parole board that has paper records, but no firsthand knowledge of the individual's rehabilitation, behavior, or safety risk, and yet is deciding whether to release them. I was wondering if you could just talk about that.
I can, and we did provide a little snippet to that on page 3 or 4. Essentially, the resident works closely with facility staff, with different titles and different roles. In addition to that, when the review goes out in the community, it's the community correction staff, probation officers that are going out there and taking a look at what that plan looks like in the community, to include the residence check, program checks, and other checks that may be applicable depending on their plan. So what we mean by that, based upon our interpretation of the bill, these are departmental staff working with the individuals every day, whether in the current moment or relying on historical context from a former facility or other members they've worked with, to work through that plan and work with them, versus an external board that does not see them every day in their environment and seeing those positive actions in play.
Great. Could I ask another question?
Yes.
Thank you. So I think I saw, and I'm trying to find it, there's 2,060 or 2,600 currently in the system. Is that-
Approximately 2,060.
2,060. And 600 last year went into the SCCP.
No, 107 residents went into SCCP. I was citing, we had supported over 600 residents, over the last 5 years on SCCP. That's the top paragraph on the last page.
Okay. Am I gathering that if LD 1941 were to go through, that it would be one or the other? You can't have both programs? Is that what?
That's our understanding. I mean, I think there'd be some redundancy that may be in play with that.
And I was just curious, can I ask another?
One more. We've got a couple of other people who
Okay.
had their hands up, but I also wanted to know that we can explore that more at the work session.
Okay.
But go ahead and ask your final question.
I was just wondering, and based on your understanding of LD 1941, if it were to go through, how many people do you think would be eligible for it if you had to guess?
We'd have to take a look in that number and be better prepared for that for the work session.
Okay, thank you.
You're welcome.
Think Senator Talbot Ross,
I
and then
appreciate it.
Senator Hagan, did you have a question? Okay.
Thank you, Madam Chair. I actually had a different question. I'm gonna skip it, because I know how to reach you. But I do want to ask a follow-up to Representative Cruz. You just said that SCCP and parole couldn't exist at the same time?
I think the question was, as it's written, does it exist in the same time? I'm not fully prepared to answer. My review of that, it would be redundant to have two. So that's my understanding of it.
May I ask a clarifying question?
Yes.
Thank you. Help me understand redundancy. Because if I was a long-termer, 20, 30, 40 years, under SCCP, I have to wait to the last 30 months for my sentence. Under parole, I might have a window of opportunity to get released based on all the criteria. So those two things in my brain can exist at the same time because we're giving long-termers some relief in one program that they will probably never receive or get access to in
No,
another.
that's a good point you bring up that, because obviously there would be stipulations if someone's under parole, even if they're eligible for parole. So SCCP could come into play for those that may not be eligible if they meet those timeframes within the current language of the statute of SCCP today.
So they could exist
Yes.
essentially at the same
Session.
time.
I misunderstood the functionality of the redundancy, the staffing and things like that.
I got you. Thank you, Deputy Commissioner.
Yep.
Additional questions? And I'm assuming you will be with us for the work session.
I will be, if invited. It sounds like I am.
You are invited.
All right.
Any
you.
other questions at this time, committee members? Seeing none, thank you. There are additional persons present in the committee room who wish to speak in opposition. If so, please step forward. Seeing none, is there anyone present in the committee room who wishes to speak neither for nor against? If so, please step forward. And at this time, it doesn't look like there's anyone else present in the committee room. Oh, just one moment. In the meantime, if you are present, if you are attending the meeting online and you wish to provide testimony in support, at this time, just raise your electronic hand, please, and leave it raised until you've had a chance to provide your testimony. So that's people participating remotely who wish to testify in support. Just raise your electronic hand and leave it up. Committee members, we're going to start to hear from those who are testifying online. Ask the clerk to move over the first person who is going to speak in favor remotely. Ignatius Parker, if you could please activate your audio and video and begin your testimony. And we realize that you're not going to be able to see the timer clock, but we'll let you know.
And I'm going to be reading on behalf of two folks who are currently incarcerated in the Maine State Prison in Warren. They're very, very short, so it should be well within time. Good evening, Senators Carney, Senator Amy Kuhn, and honorable members of the Judiciary Committee. My name is Jared Donathan. I'm providing testimony in support of LD 1941. I'll start this testimony off by saying how much incarceration affects my whole family, not just the resident. My incarcerations have been brief stints, but many. I've been in and out for possession of drugs and for driving offenses. My children, mother, sister, and Nana have been watching me through the bars when in fact I should have been in treatment or educated about my disease. I'm not here to put blame on anyone because I made the choices that got me here, but we can at least come to an agreement that we are both in the wrong about many things. This bill does not apply to me, but it does apply to many good men. I've watched so many men change and accomplish amazing goals in here. I myself have found a new way and new patterns to life. The moral of my testimony, that's a little all over the place, is we're all human at the end of the day. We do change and can change if we apply ourselves. Please vote ought to pass on LD 1941. Please go deep inside yourself and say, if it were your son, would you want a second chance given to him? And then this is from Caleb Jewett. Good evening. My name is Caleb Jewett, and I'm providing testimony in support of LD 1941. I am directly affected because I am currently incarcerated. My family is also affected by this. My son is without his father, and my parents are without their only son. While incarcerated, I've done everything I can to become a better person. I've enrolled in college and got an associate's degree in business and continue to work towards a bachelor's degree. I also train service dogs for the American Vet Dogs Association. I have taken every opportunity available and tried the best I can. I have learned from my mistakes and feel that many others in Maine State Prison have also. This bill will save the state money and provide future opportunities for many people and their families. I'm asking that you please vote ought to pass on LD 1941. I have a third very short one. Do I have time?
Please go ahead. That's
Okay.
fine. Go ahead.
This is from Justin Pillsbury. Greetings and salutations. Respectfully, my name is Justin Pillsbury. Today, I'm writing this to try and provide support for LD 1941. I am currently imprisoned. I am 12 years into a 50-year sentence. It was my first experience ever being imprisoned. On the street in my old life, I was a pillar of my community. Besides being in the Army, I was vice president of the PTO at my kids' school, and I attended field trips regularly as well as volunteered my time to come and read to the kids. I coached Little League baseball and PAL and basketball. I was a specialist in the US Army, and I was a proud full-time father. One night, I made a tragic mistake for which I pay for mentally every day of my life. When I arrived at prison, it wasn't at all like the Shawshank Redemption or the movies I had watched. It was full of people who had also made mistakes. Some meant to, some did not. Some didn't even do it. Everybody grows mentally regardless. Everyone changes. Everyone can be rehabilitated. I guess what I'm saying is after my term of punishment, let me live again. I will still pay my debt to society. It will just be on the other side of the wall. Thank you for your time, Justin Pillsbury, and on their behalf, Ignatius Parker.
Thank you very much. And since you were reading the testimony of others, we won't be asking you, committee won't be asking you questions. Thank you. And is Doug Dunbars the next person who's going to speak? You
Hi
can begin
there.
your testimony. Hello.
Thanks a lot. The committee, I know it's getting late. I spent many hours in committees. It's dwindling. I can't see who's there, but I'm glad a few of you are there. Thanks for sticking it out. I'm the guy who was Governor Balaji's press secretary. I was Maine's Chief Deputy Secretary of State, worked for George Mitchell. Anyway, doesn't matter. And then I went to jail. And again, I'm sorry you don't have the benefit of going to jail, because it would open your eyes to so many problems. You folks would trip over each other, racing back to the revisor's office from whatever jail you were in to try to make changes. But you don't have the benefit of spending time incarcerated. I do. One thing, as a bit of an aside, I've heard the chair say many times to someone who read testimony from someone who was incarcerated that we'll hold off asking questions because you're reading testimony from someone else. Wouldn't it be wonderful if you could ask questions of the people who are incarcerated? Let's try to find a way so that people who are incarcerated can participate in this civic life. And so then you can ask them questions. You can get benefit directly from the people. Let's try to work with DOC to allow those people to actually testify so then you can be edified by what they have to say in response to your questions. Parole is about giving people hope. It's about many other things. But if you take hope away from people who have completely changed their life, you're doing a disservice to the state in many, many ways. As I said before, we spend so much time and money punishing people who primarily are sick and poor for a lifetime, even when they get better. Some who are even innocent. I hope you all pay attention to the Innocence Project. I hope it takes your breath away when you see on the news that someone was exonerated who had spent 20 or 30 or 50 years incarcerated. I hope that takes your breath away. I can't imagine that. I was in a jail cell for 4.5 months. To be incarcerated for 20 or 30 years and be innocent. There are people like that. And parole is one avenue that might get someone out sooner. Look at the rate at which we disproportionately incarcerate people of color. Many of those people got much longer sentences or got sentences at all because of the color of their skin. That's real. If you don't believe it, you're living in a world that I wish we all lived in. So there's so many reasons, but I think for me, it's about hope. If someone has changed their life and could be benefiting society, and we don't give them that opportunity, we're doing a disservice in so many ways. There'll come a day.
Thank you.
I'll
Thank
just end
you,
with
Mr.
this.
Dunbar. If you could wrap up in one sentence and then we'll see
Yep.
if there are committee questions. for you.
Absolutely. There will come a day, I'm convinced, when we will look back on this time when we punished people endlessly who are sick, and we will think to ourselves, in God's name, what were we doing?
Thank you. Let's see if there are committee questions. Are there any questions, committee members? I am not seeing any. Thank you for your
Take care.
testimony.
Take care.
Next, we'll hear from Kelly Martin. Welcome. You may begin your testimony.
Good evening, Chair Senator Carney, Representative Kuhn, and distinguished members of the Joint Standing Committee on the Judiciary. Thank you for the opportunity to testify in support of LD 1941 to reestablish parole. It's been 50 years since Maine became the first state in the country to abolish parole. But since then, our society hasn't become safer. Since then, the prison population has grown significantly. It is more than 3 times larger than it was in 1976, though the population of the state has grown by just 29%. So to be clear, proportionally, that's 29% versus over 300%. This bill would allow people to become eligible for parole after they have served 1/3 of their time. It would liberate people to return to their families who are also disaffected. It would free people to return to society and live a life outside of prison that might benefit us all. I know many formerly incarcerated people. They are some of the most inspiring people I know. Highly motivated, transformed, and powerfully beneficial to society. Servants of the people. That is not just my experience with formerly incarcerated people. I think that truth is evident from the testimony presented today. This is a measure of restorative justice. It is a measure of racial justice, and such transitional programs make us significantly safer. Fiscally, this measure would increase Maine's economy by an estimated $14.7 million per 100 paroled workers. So I'm wondering what original intent of the law that revoking parole was meant to achieve. Prison is a place where people are punished. Some have said today that it has served to rehabilitate them. But not restoring parole guarantees that it is a place where people are thrown away. It doesn't allow any discernment in assessing an imprisoned person's growth or the way that they served their time. Hope, rehabilitation, redemption, and healing are what we all need. People who have been imprisoned are also deserving of that opportunity. They are also deserving of that dignity. We respectfully urge this committee to vote LD 1941 ought to pass and join the 46 other states that have some form of parole. Thank you for your time.
Thank you very much for your testimony. Committee members, are there any questions? Not seeing any. Thank you.
Thank you.
Next, we'll hear from Richard Harburger. Please activate your audio and video, and you can begin when you're ready.
Good evening, and welcome to the this hearing. I am Richard Harburger from Brewer, Maine, and I strongly support the proposed legislation. Now, I come to you as the chair of the present Maine Parole Board and have served on this board for over 26 years. My employment history involves 54 years in law enforcement here in the state of Maine. I have served as a police officer, deputy sheriff, a state probation and parole officer for 10 years, and a federal probation and pretrial service officer for 20 years. I possess 2 undergraduate degrees along with a master's degree, and I have taught classes in criminal justice, corrections, and in the behavioral sciences at both Hudson University and the University of Maine for over 15 years. Now, all of my training, employment, and education tell me that parole is a worthwhile endeavor. I have read the proposed legislation and believe that it represents a fair and just process for the safe release of inmates who meet conditions allowing for early community release. My history here in Maine shows me that parole or reentry and reintegration into the community works and allows for a reduction in recidivism when the parole plan is collectively created and executed by all parties involved. I also believe this legislation allows for the victim of the original crime to have significant input into the parole process and allows for a degree of restorative justice within the community upon release. It is in everybody's best interest to construct a program that creates an incentive to the process of change. The inmate will now see a concrete way to shorten his sentence by working within the system rather than just sitting there to wait it out. History has shown us that the longer an inmate remains in jail, the more likely it is that the inmate will return to the criminal justice system. Parole allows for a safety net to be in place for the protection of both the releasee and the community. As we have heard numerous times today, Maine is one of 16 states that does not utilize parole. This needs to change. Parole will offer a more positive outlook to Maine's correctional population and add an important safety net to released individuals who may need assistance once outside the institutional walls. Having read the bill, I just have 3 concerns that I think the committee needs to look at. One, although not mentioned, the parole board, in my opinion, would need to be full-time, not part-time as it is now. Secondly, I think the 10-year wait for parole eligibility is too long. It should be 5 years. And lastly, there needs to be an ability for the parole board to discharge a parolee early from supervision, which presently exists but does not exist in the new bill. Are there any questions that I can answer?
Thank you very much. Committee members, are there any questions? Yes, go ahead. Go ahead and ask them.
Okay, so I would like to, hi there, Dave Hagan. I would like to hear you out to completion on this one.
I'm sorry, I didn't hear that.
I'm in hopes of hearing you out. Did you finish?
Yes.
Okay, thank you.
Any additional questions, committee members? Seeing none, thank you very much.
Thank you.
And then next we have Brian Widenhouse.
Good evening.
Welcome.
Thank you. Senator Carney, Representative Kuhn, honorable members of the committee. My name is Brian Widenhouse. I'm a state legislative affairs manager at FAM. We are a national nonprofit, nonpartisan justice reform organization. While I do not live in the great state of Maine, I'm privileged to represent hundreds of families in our network who have incarcerated loved ones and ask for your support of LD 1941. FAM advocates for policies that individualize and fair, protect public safety, and preserve families. As a national legislative advocate organization, we work closely with stakeholders in the development and implementation of best practices, policies for safe and effective carceral system. We've worked hand in hand with state parole boards on legislation. We engage in back and forth dialogue and cooperative policy training, and we have developed relationships with organizations such as the Association of Paroling Authorities International. A vast body of research, studies, and effort has vastly improved the paroling process over the last 50 years. Today, parole is an invaluable tool for states and correctional systems for many reasons, of which you heard much testimony today that I won't repeat. Instead, I will focus on my personal experience with the parole process. I'm a formerly incarcerated person who once had a sentence that was not eligible for parole. I was a juvenile lifer sentenced to life without parole. This changed after the U.S. Supreme Court outlawed such sentences in 2017. When that happened, suddenly many parole boards across the country had to review such cases. While these cases were of juveniles, they were for the crimes of murder, a crime and sentences that were very rarely, if ever, reviewed by parole boards. It was new territory for them. During my incarceration, I diligently pursued my rehabilitation, education, and accountability. I don't have the time to give you a full account of my rehabilitative resume, but I can say that I stood before the parole board at my first hearing and was told that I had the best record they have ever seen. And then I was denied parole. Obviously, I was granted subsequently. I just want to demonstrate that parole boards are very, very conservative in their decisions. You can see this by the grant rates across the country. Granting parole is not a roll of the dice. Careful consideration is given to every element from the person's rehabilitation, the voices of victims, risk assessments, and reentry plan. As in my case, even when the record is very compelling, parole boards inherently default to very conservative and safe decisions. I fully trust that a Maine parole board will safeguard public safety, listen to victims, and make decisions for the betterment of all families and communities. I ask you to support LD 1941.
Thank you for your testimony. Can you let us know where you're located, Mr. Widenhouse?
I currently reside in Pennsylvania.
Thank you very much.
Madam Chair, if you could indulge me, there were two previous questions by committee members that I don't think were fully answered, and I think I could give some valuable insight.
At this point, I think we're going to, because
sure, I understand.
we're going to have a work session where we'll be able to dive into those issues. So we appreciate your offer, but we're going to go ahead and move on to our next speaker. Thank you for your testimony.
Thank you.
Oh, wait, let's see if there are questions from the committee. Committee members, are there any questions? I'm not seeing any questions. Thank you. Next, we're going to hear from Caitlin Horrigan.
Good evening. My name is Caitlin Horrigan, and I live in Monroe, Maine, and I'm speaking tonight in giving testimony in support of LD 1941. I am a person who has both witnessed and experienced violence in my lifetime multiple times, and the number one reason that I'm speaking tonight is because to me, safety is a world in which our policies and laws are shaped on data, and data shows that what increases safety in the community is when people both receive support when they leave incarceration and when they participate in the programs that we've heard so much about tonight. And to me, as a person who has experienced violence, I don't want my life to be defined by past traumatic experiences. And I also don't want that for the people who are incarcerated. I'm going to be reading a couple of testimonies and I'll just fit in what I have time for. The first one is from Gordon Perry. I offer this testimony from a stark reality. I'm serving a natural life sentence. I will spend the rest of my life behind bars, regardless of whether parole is reestablished in Maine. My motive here is not my own freedom. It's my conscience fueled by empathy, compassion, and the practical logic of a man who's lived inside this system for nearly 4 decades, if I am to count my childhood days as a ward of the state. Turning 50 this past April, I've witnessed the evolution from the old days of daily violence and hopelessness to the innovations of the Maine model of corrections. This model has effectively cracked the code in corrections with its humanizing philosophy, which did not just manage me any longer, it inspired me. I found real hope enabling a path to educate myself, find purpose, and my life passion to give back. Today, I enjoy paying forward my gratitude for my opportunities for the rest of my days, helping others impacted by this system. But here is the hard, sad truth. The MDOC is losing so much potential as it stands today. You cannot truly lead in corrections without parole. Parole is the engine of rehabilitation that offers the necessary hope and incentive for individuals to commit to the difficult work of change. Without parole, the system is broken or at best incomplete. While the government has many powers, it has failed to fix the systematic issues that lead people to prison. You have the power to help fix this outcome. We cannot be true leaders in reform efforts or in corrections, which most believe we are, if we continue down the current path that does not include basic necessities like parole. The US makes up less than 5% of the world's population, yet we hold nearly 20% of the world's prisoners. Sadly, we incarcerate our citizens at a rate higher than any other developed democracy on earth. I urge you to pass LD 1941 to validate the human potential for redemption and ensure taxpayer money builds better neighbors, not just better prisoners.
Thank you for your testimony and also for reading the testimony of Gordon Perry. Committee members, are there any questions for Caitlin Horrigan regarding her own testimony? Not seeing any. Thank you very much for joining us today. Next, we're going to hear from Valkyrie Cole.
Hello, my name is Valkyrie Cole. I live in Waldoboro, Maine, and I'm going to be reading a testimony from an incarcerated person. My name is Tiffany Sutherland. I am currently incarcerated at the Southern Maine Reentry Center in Windham, serving a 4-year sentence, but the impact of my incarceration has reached far beyond this facility. While I have been here, my mother, Tracy, who is 60 years old, has been raising my son. She carried that responsibility until her body could not anymore. She suffered a heart attack while caring for him. That cost does not appear in a budget line, but it is real, and my family lives with it every day. My son, Trayvon, is 18. He just graduated high school and began college for audio engineering. This should be a moment of confidence and momentum. Instead, without a parent present to guide him through this transition, he failed his Husson experience class. Not because he lacks ability, but because young adults still need stability and support, and I could not be there to give it due to the consequences of my own actions. This is another cost that does not appear on a budget line, but also very real to a child spreading his wings. While my family has absorbed the weight of my incarceration, I have worked to change. I am fully compliant with all institutional expectations and am enrolled full-time in college, pursuing a degree in business management. I have been eligible for community status since March of 2025. Despite my readiness to work, contribute, and reintegrate responsibly, I have remained idle, not due to unwillingness, but because opportunity is limited. A lack of available treatment programming and the absence of work contracts at the reentry center have stalled my progress. While I will be able to present my case for community status on January 8th, there is a lengthy waitlist of women ahead of me for employment opportunities, leaving me and many others without a pathway forward despite demonstrated readiness. This is not an isolated issue. It reflects a larger systemic problem created by the absence of parole in Maine. Readiness alone does not matter when there is no mechanism to move people forward. Individuals who pose no public safety risk remain incarcerated simply because there is nowhere for them to go. Maine is under significant financial pressure. The it costs the state roughly $170,000 per year to incarcerate one person. That money goes towards security, staffing, medical care, and facility maintenance, costs that continue even when someone is prepared to work, learn, and contribute. When parole is unavailable, the state continues to pay the highest possible price for people who could be costing far less and giving far more. Parole shifts people from expense to investment. Individuals released on parole are required to work, pay taxes, and comply with supervision. They contribute income tax, sales tax, and payroll tax. They support local businesses, pay child support, and make restitution. I'm going to skip a little bit because I see that I'm running out of time.
Yeah, you've got 5 seconds, so go ahead.
What has been lost is time. Time with my child at a critical stage of his life. Time my mother's heart could not afford to give. Time families never recover. What has been gained is accountability, education, perspective, and readiness to contribute. But growth has value only when it is allowed to extend beyond confinement.
Thank you. Thank you for reading the testimony of Tiffany Sullivan, and we appreciate you being with us this evening. Next, we're going to hear from Katrina Hoop. Katrina, could you please activate your audio and video and begin your testimony?
Thank you. My name is Katrina Hoop, and I'm presenting testimony for Samantha Moore.
We are not able to hear you. Can you try again to speak and see if we can hear you?
Can you hear me?
Just barely. It's very, very low. So speak as loudly as you can, please.
Okay.
Thank you so
Thank
much.
you. Yes. I'm Katrina Hoop. I'm presenting testimony for Samantha Moore. My name is Samantha Moore. I was born and raised in Maine. I am currently serving a 2-year sentence in the Maine Correctional Center. I spent my days and nights with some folks who have resided here at MCC for 10 plus years and have much more time to serve. The Maine Correctional Center has earned a title, Maine Model of Corrections, because of empowering change, normalization, and humanization. Who are the people who have made this happen? The residents. If the residents didn't adapt to the environment, there would be no Maine model. The people making a difference are the people who have spent time within these walls changing their lives. People make mistakes. People also change. I think LD 1941 would be a huge stepping stone to the rehabilitation aspect of the Maine model of corrections. I understand action comes with consequences. With consequences comes time, and with times comes change. Individuals who serve a substantial amount of time incarcerated spend time evolving to growth and knowledge. Healing is an active process and not just a passive result of time. Parole is a pathway to opportunity. The folks here deserve a chance at a life that they may have thought there was no hope for, because Maine doesn't give the option for it. If Maine had parole, prisons would not be at maximum security. They would not be talking about building more prisons if parole were in place. Parole would reduce the high cost of incarceration instead of adding costs by building additions to already existing prisons. Parole would give individuals a chance at joining the workforce, providing for themselves and or their families. This would shift from being a taxpayer expense to paying taxes. The money wasted on holding folks who deserve to be a free individual cloud could be used in other areas of need. LD 1941 would have a positive impact across the state with significant benefits. This could be a transformative stepping stone into Maine's history. Let's give these individuals the second chance that is deserved. Let's be the change Maine needs. Thank you.
Thank you for your testimony. Next, we'll hear from Evan Moody. Welcome.
In support of LD 1941, hello, Senator Carney, Representative Kuhn, and members of the committee. My name again is Evan Moody. I live in Lincolnville, Maine. I'm reading testimony written by an incarcerated individual named Janine LaPlante. My name is Janine LaPlante, and I'm currently serving a 4-year sentence incarcerated at the Southern Maine Women's
Excuse me,
Reentry.
Evan. I'm sorry
Yes.
to interrupt you. in the committee, we have a rule that applies whether you're testifying here or remotely, that you can't have posters. And it looks like you have a poster right behind
Can I
you.
just turn my video off?
That's exactly what I was going to suggest. And
you.
if you can start again, that would be helpful.
Yep, my name is Janine LaPlante, and I am currently serving a 4-year sentence incarcerated at the Southern Maine Women's Reentry Center in Windham, Maine. In my experience, I have most often struggled when transitioning from incarceration to the community. It feels like I am falling off a cliff. Moving from a highly monitored environment with a stable schedule and clear rules to the outside world with no structured oversight and a shaky plan creates an extreme change that is difficult to navigate. Without the structure and accountability that parole provides, the door is left open to return to familiar patterns, which all too often lead back into the grips of addiction and crime. I am a student at Central Maine Community College through a workforce training program called Community Reintegration and Behavioral Health Support. I'm currently researching how to reduce recidivism rates, and it isn't a one-part plan. It is going to take multiple different avenues which coincide with one another to help with the overall reintegration process. Education provides a piece of the puzzle, while stable housing is another. Parole is a step in the right direction. National data shows that upon an incarcerated individual obtaining education while incarcerated, the odds of recidivism reduces by 43%, as well as individuals that are released to parole supervision are 36% less likely to return to prison than individuals that fully complete their sentences and get out. I believe that if residents had access to parole, it would facilitate a more successful adjustment into functional, productive living. Parole isn't just about an earlier release. It's a supervised reentry that ensures we are not just let out, but instead integrate back into our communities with the support needed to stay there. And since I have some time left, I'd just like to add a quick personal note. I have a family member and a dear friend who were both in the Maine State Prison for just shy of a decade. Their crimes were serious, and since then they've taken every step available to do what is right, to serve others, and to better themselves. Their convictions and time spent in prison still create daily difficulties for them. Parole could lessen the lifelong burden on people like my loved ones. Please support LD 1941. Thank you for your time and consideration.
Thank you very much for your testimony and for including your personal reflections. Committee members, are there any questions for Evan Moody? Looks like he's signed off.
No, I'm still
No.
here.
Oh, terrific.
You
Let's
made
just
me
see if
shut
there are
my
any
video off.
questions for you. Questions? Seeing none, thank you very much, Evan.
Thank you.
Then the last person who's present online is Cage Johnson. Could you please activate your audio and video? And in order to do that, you have to accept the prompt that is asking you to move onto the panel to provide your testimony. Cage, if you could activate your audio and video, please, and begin your testimony. Welcome.
Hello, thank you. Back again. I'll try to be brief here. I'm Cage Johnson. I'm a resident of Winslow, Maine. I'm here testifying in favor of LD 1941 on behalf of Healing First. And as an individual, I'm part of the Maine Restorative Justice Coalition. I'm also the Maine State Chapter Rep of the Global Coalition Survivors for Justice Reform, Survivors of Serious Harm, including assault and rape. And we are in full and earnest support of LD 1941. I explained what Healing First is earlier, but we are a transformative justice collective led by survivors of serious harm, including sexual assault, intimate and domestic partner violence, and gun violence. And together we are claiming a public voice as survivors who want restorative approaches and healing-based alternatives to incarceration. And this includes being in favor of parole. And something that we really want to we wish to underscore, as pointed out also by Mikasa, is that LD 1941 includes multiple provisions which ensure that the parole process is considerate and caring to those who have been victims of crime. Concerns from this bill's last session have been carefully tended to and addressed. We need to reckon with the fact that incarceration, especially long-term, causes further harm to everyone involved, including the families that are torn apart. This trauma contributes to cycles and generations of harm. We need to start investing in and expanding rehabilitative, restorative approaches that genuinely heal, like we heard from today from Leo Hilton's sister so beautifully. Parole allows incarcerated people to return to homes, jobs, loved ones, while getting support to make their transition back to community successful. We see this happening in other states, such as Mississippi, who abolished parole back in 1995. They have successfully brought back parole and have lightened the load on their overburdened prison system and state budgets. We also know incarceration long-term is extremely expensive. It's a lot of our tax dollars. The average cost of incarcerating just one person in Maine per year is approximately $117,000. Healing First would much rather see these precious financial resources going to other programs, including parole, which encourages people to return as active and engaged members of communities. So again, I restate passionately Healing First's position of being in support of LD 1941. I think it's time that Maine catches up with other states across the entire country. And we urge you to invest in healthy communities and not prolonged harmful carcerality. And lastly, we wish to lift up the voices of over 100 people, many of whom were survivors of crime and harm, who testified in favor of this bill the last time it was heard. And I believe there were less than 10 who testified against. So please listen to the abundant voices in front of you, and again here today, and vote in favor of LT 1941. Thank you very much.
Thank you for your testimony. Committee members, are there any questions for Cage? I am not seeing any. Thank you for your testimony.
Thank you.
And so if there is anyone else online who wishes to speak either for, against, or neither for nor against on LD 1941, please raise your electronic hand. And there are none, so we have concluded all of the in-person and on remote testimony. And with that, we're going to close the public hearing on LD 1941. Thank you, everyone. And committee members, thank you so much for all your hard work today. And is there a motion to adjourn?